Yes, sir. Really urgent ಇರುವಷ್ಟೇ ಮೂವ್ ಮಾಡಿ. ರಿಯಲಿ ಅರ್ಜೆಂಟ್ ಇರ್ಬೇಕು. ಏನ್ ನಾಗರಾಜ್ ಏನು? ಯಾವಾಗ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ? ಭರತ್ ಭರತ್ ನೋಡಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೊಂಡ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. ಗೊತ್ತಾಗ್ತಲ್ಲ.
ಯೂಸ್ ದ ಮೈಕ್. ಮೈಕ್ ಯೂಸ್ ಮಾಡಬೇಕು.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಬೇಕು,
ಮಾತಾಡಬೇಕು. I filed application vacating stay, my lord. Next week, my lord, after vacation. Next.
My lord, challenging the created order. The Lokayata was conducting the inquiry for petitioner, my lord. That's why the urgency.
ಎನ್ಕ್ವೈರಿ ಆಗ್ಲಿ, ಏನಾಗುತ್ತೆ? ರಿಪೋರ್ಟ್ ಇಮಿಡಿಯೇಟ್ ರಿಪೋರ್ಟ್ ಆಮೇಲೆ ಗವರ್ನಮೆಂಟ್
allegation ಇಲ್ಲ my lord. Petitioner, they only demand is
application.
It's a fresh matter, my lord. Other connected matters are listed today. Memo was moved, my lord, day before yesterday, my lord. The date was given to today. It is not listed.
Other
matters are listed today.
ಅಲ್ಲ, ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಇದ್ರಲ್ಲಿ ಆಗಿದ್ದು ಅದರಲ್ಲೂ ಆಗುತ್ತೆ.
Lord, I am not tomorrow, my lord. For tomorrow, suspension tomorrow, my lord. Fresh matter.
Is regarding filling up a backlog of vacancy, your lordship. It's covered by your lordship's judgment.
ಜೂನ್ ಅಲ್ಲಿ ಮಾಡಿ ಹಾಕಿಬಿಡು. ಸರಿ, ಜೂನ್ ಫಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. Yes.
Your lordship.
40. 42. ಕೊಡ್ಬೋದಾ? ಡೆತ್ ಆಗಿದೆಯಾ? R1 is stated to be dead. Steps to be taken. Okay.
No, serial number 33, my lord. Senior counsel has some health issues. Can be taken up after, please. 33 and 33.1.
ಅವರೆಲ್ಲ ಇಲ್ಲೇ ಇದ್ರಲ್ಲ, ಈಗ ಏನ್ ಹೇಳಿ ಮಾಡೋದಾ? Please. All right. After vacation, a call after vacation.
Interim order. Interim order.
Interim order to continue. Further hearing ಇದೆ. Release from partner. Interim order to continue. All right. Please. Next.
Serial number 34, my lord.
34.
Please, my lord. Appraised for a week time, my lord. 34, my lord.
ಕೊಡ್ಬೋದಾ? 22, 24 matter, na? So immediately, soon after vacation.
30.
Interim order pending.
Serial number 39, your lordship.
Yes, Mr. Ahmed,
39, it's a batch matters, your lordship. The writ appeal has been filed.
it appeal hakira.
State has filed writ appeal. We will come back to you because we don't have that. ಅದ್ರ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ರಿಟ್ ಆದೇಶದ ಮೇಲೆ ತಮ್ಮ ಮುಂದೆ ಬಂದಿದ್ದಾರೆ. ನಾವು ರಿಟ್ ಅಪೀಲ್ ಹಾಕೊಂಡಿದೀವಿ. That ಅದೊಂದು ನೋಡ್ಬಿಟ್ಟು ಬರ್ತೇವೆ. That's what the instruction is from.
2 weeks ಮಾಡೋಣ.
ಆಗ್ಲಿ.
Writ appeal ಹಾಕೊಂಡ್ರಂತ. ಬರ್ಲಿ.
ಆಗ್ಲಿ.
Learned AAG, Mr. Ahmed submits that writ appeals have been filed in connected matters and therefore these matters be adjourned by 2 weeks.
Yes.
2 weeks.
We'll come
First, we agree with this. Yes.
Yes, sir. Lord, interim order may be.
Wherever interim order
Yes, sir.
obtains, comma, is extended.
My lord, serial number 36, my lord. Matter
36.
set 6.
ಯಾರೋ 36 ಕೇಳಿದ್ರು. ಏನಮ್ಮ?
ಅದು ಮ್ಯಾಟರ್ ಸೆಟಲ್ ಆಗಿದೆ my lord. ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೋತಾ ಇದೆ.
ವಿಡ್ರಾ ಮಾಡ್ಕೋತೀರಾ?
Yes.
This is very important to us. Counsel for the petitioner has filed memo dated so and so, which reads as under. First up, in terms of memo. For producing document. Disposed of there. In terms of memo, matter is disposed of. Okay, memo reads as under ಅಂತ ಹಾಕೊಂಡು.
ಅಚ್ಚಾ.
Yes. ಹೇಳಿ. ಮೆಮೊ 1, 2. ನೋಡಮ್ಮ. ಅಲ್ಲೇ ಮೆಮೊ ರೀಡ್ಸ್ ಆಸ್ ಅಂಡರ್ ಸೈನ್ಸ್. ಗೌರ್ಮೆಂಟ್ ಎಡುಕೇಟ್ ತೋರಿಸಿರಾ? ಅಲ್ಲಿ ನೋಡಿ, registry to send copy of this order to the private respondents by speed post immediately. ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಲಾಯರ್ಸ್ ಯಾರಿಲ್ಲ ಅವರಿಗೆ unrepresented private respondents. Okay. Yes, Mr. Rawsa. Rawsa is waiting for whom? Which matter? Next matter. Okay. Yes, sir.
Lordship,
Revati.
last occasion we were asked to file the complaints
ಹೌದು.
pertaining to
Payment.
order dated 3/7/2019. The order was that, your lordship,
ಹಾ.
to
ಅದು ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸೆಕ್ರೆಟರಿಗಳು ಅವ್ರ
ಹೌದು.
ಸ್ಯಾಲರಿ ತಗೊಳ್ಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿ.
ತಾವು ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ.
ಹಾ.
We got all the officers here
ಏನ್ ಮಾಡಿ?
collected. Parties to maintain status quo as on today ಅಂತಕ್ಕಂಥದ್ದು ಆದೇಶ.
Status quo relates to type of job.
Yes, yes, I'll come to that, your lordship. 3/7/2019,
ಹಾ.
the order of this honorable court was to maintain the status quo. 31 ಜನ ಒಟ್ಟು 31 ಜನ ಇದ್ರು.
ಹಾ.
This cleaning ಮಾಡ್ತಕ್ಕಂಥವ್ರು. ಅದರಲ್ಲಿ before this interim order 20 were removed by virtue of order dated 31/12/2018. ಈ ಆದೇಶಕ್ಕಿಂತ ಮುಂಚೆ 20 ಜನರನ್ನ ರಿಮೂವ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ SP ಗಳು ಆನ್ ದಿ ಆಕ್ಟಿಂಗ್ ಅಪಾನ್ ದಿ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂಡ್ ಬೈ ದಿ FD ಟು ದಿ ಹೋಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ತಮ್ಮ ಹತ್ರ ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್ ನಾನು ಸರಿ ಅಂತ ಹೇಳ್ತಲ್ಲ. ಐ ಆಮ್ ಬ್ರಿಂಗಿಂಗ್ ಟು ದಿ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ದಿ ಆರ್ಡರ್ ವಾಸ್ ಆನ್ 3/7/2019. 5 orders were issued by the district superintendent of police. ಕೋಲಾರದಲ್ಲಿ 5 ಜನ, ಒಟ್ಟು 8 ಜನ ಇದ್ರು. 5 ಜನ, ಕೊಡಗಲ್ಲಿ 4 ಜನ, ಮೈಸೂರಲ್ಲಿ 5 ಜನ, ಮೈಸೂರು KPN ಅಲ್ಲಿ 3 ಜನ, ಬಳ್ಳಾರಿಯಲ್ಲಿ 3 ಜನ. ಅಂಡ್ ನಾಟ್ ಓನ್ಲಿ ದೀಸ್ ಮೆಂಬರ್ಸ್, ಹೆಚ್ಚು ಜನ ರಿಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಇವ್ರು ಮಾತ್ರ ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದಾರೆ. ಔಟ್ ರಿಮೂವ್ಡ್ ಅಬೌಟ್ 40-45 ಜನ ರಿಮೂವ್ ಮಾಡಿದ್ದಾರೆ. ಕೋರ್ಟಿಗೆ ಬಂದಿರ್ತಕ್ಕಂಥವ್ರು ಕಡಿಮೆ. ಸೊ ಆಫ್ಟರ್ ದಿಸ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ 11 ಜನರನ್ನ ಅದು ಯಾರು ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರು ಅದನ್ನ ಉಳಿಸ್ಕೊಂಡಿದೀವಿ. 11 ಜನರನ್ನ ಉಳಿಸ್ಕೊಂಡು ಅವ್ರನ್ನ ಈಗ ನಮ್ಗೇನಾಗಿದೆ, FD ಸರ್ಕ್ಯುಲರ್ ಸಾದಿಲ್ವಾರು ಖರ್ಚಿನೊಳಗೆ ಕೊಡಬೇಕು ಅಂತ ಆಗಿರೋದ್ರಿಂದ, ಸೊ ಕಚೇರಿ ಸ್ವಚ್ಛತೆ, ಕಚೇರಿ ಕಾವಲು, ಕೈತೋಟ ನಿರ್ವಹಣೆ ಮುಂತಾದ ಕೆಲಸಗಳನ್ನು ಸೇವಾ ಗುತ್ತಿಗೆ ನೀಡುವ ಮೂಲಕ ನಿರ್ವಹಿಸಲು ತಿಳಿಸಿದೆ. ಇದಕ್ಕೆ ತಗುಲುವ ವೆಚ್ಚವನ್ನು 0.51 ಸಾಮಾನ್ಯ ವೆಚ್ಚಗಳು ರೆಡಿಯಲ್ಲಿ ಭರಿಸಲು ತಿಳಿಸಿದೆ. ದಿಸ್ ಇಸ್ ದಿ FD ಸರ್. ಅದ್ರ ಕೆಳಗಡೆ ಇವರು 11 ಜನರನ್ನ ರಿಟೈನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. ಹಿಂದೆ ಏನು ಅವ್ರಿಗೆ ಸಂಬಳ ಕೊಡ್ತಾ ಇದೀವಿ ಅದಕ್ಕಿಂತ 2ರಷ್ಟು ಈಗ ಸಂಬಳ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಅದನ್ನ ನಾವು ಥ್ರೂ ಅಫಿಡವಿಟ್ ವಿಲ್ ಫೈಲ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಲೇಟರ್ ಅದಾದ ನಂತರ 13/7/2021 ಈ when this matter came before this honorable court, it was observed that the coordinate bench of this court has passed an order of status quo on 3/7/2019, and the employees were working with the police. In spite of there being an order of status quo, they have not been permitted to work. It has been brought to the notice of this court that the petitioner at verge of the matter certainly requires a detailed hearing. However, to protect the employees, as there is already status quo order, the respondent state is directed to continue their services by way of interim relief. We have continued with that 11 members who are not removed as on the date of status quo. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ರಿಮೂವ್ ಮಾಡಿರ್ತಕ್ಕಂಥವ್ರು ಕೆಲವೊಬ್ರು ಇದ್ದಾರೆ.
ಅವ್ರನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂತಿದೆಯಲ್ಲ,
ಅಲ್ಲಿ ಇದು ಆದೇಶದಲ್ಲಿ
ಎರಡು ನಮೂನಿ ಇದೆ ಆದೇಶ. ಒಂದು ಸ್ಟೇಟಸ್ ಕೋ, ಅದಾದ್ಮೇಲೆ ಟು ಕಂಟಿನ್ಯೂ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಬೋತ್ ಟುಗೆದರ್ ದೋ ದೇ ಲುಕ್ ಲೈಕ್ ಮಂಗೂಸ್ ಅಂಡ್ ಕೊಬ್ರಾ, ವಿ ಹ್ಯಾವ್ ಟು ಎಂಪ್ಲಾಯ್ ಅವರ್ ಕಾಮನ್ ಸೆನ್ಸ್ ಅಂಡ್ ರೀಡ್ ದಿ ಆರ್ಡರ್ಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. So there is a direction to continue them in service because they should not die anta.
Yes. So
Then therefore I told Mr. AG, we told you,
yes, sir.
Unless government by its tall stand wins the heart of lower segment people, our heart anna mind anna win ಮಾಡೋವರೆಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಗೆ ಬೆಲೆ ಬರಲ್ಲ. ಈ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೆಲವೇ ರಿಚ್ ಪರ್ಸನ್ಸು, ಕೆಲವೇ ಅಪ್ಪರ್ ಸ್ಟಾರ್ಟ್, ಅವ್ರಿಗಲ್ಲ ಇದು, ಅವ್ರಿಗೂ ಹೌದು, ಇವರಿಗೂ ಹೌದು. ಅವ್ರು ನೀವು ಯು ಹ್ಯಾವ್ ಸೀನ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಇನ್ ಓಲ್ಗಾ ಟೆಲಿಸ್.
Yes,
Taking away means of livelihood is violative of Article 21.
20.
So that is the only job now. They have taken up such a contention. If you take out their job, ಅದು ಆಕ್ಸಿಜನ್ ತೊಗೊಂಡಂಗೆ ಹೊರ ತೊಗೊಂಡಂಗೆ ಆಗ್ತದೆ, ವೆಂಟಿಲೇಟರ್ ಇದನ್ನ. ಹಂಗಾಗಿ ಅವ್ರಿಗೆ ಕೇಳಿ, ನಿಮ್ ಆಫೀಸರ್ಸ್ ಯಾರಿದ್ದಾರೆ
ಎಲ್ಲ 30
ಅವ್ರಿಗೆ
ಜನ
ನಾವೇನ್ ಮಾಡೋಣ, ಅವ್ರು ತಗೊಂಡು ನಾವೇನ್ ಮಾಡ್ಬೇಕು? ಅವ್ರಿಗೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡ್ರಪ್ಪ ಅಂತ. ಅಲ್ಲಿವರೆಗೆ ಅವ್ರಿಗೆ ಸ್ಯಾಲ್ರಿ ಇಲ್ಲ,
ಕರೆಕ್ಟ್
ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರತ್ತು ನಡೆಯಂಗಿಲ್ಲ. ರಾವ್ ಸಾಬ್, we are very sorry, we are very curt nowadays in making orders, otherwise nobody cares the court. ನಮ್ಮ ಹತ್ತಿಗೆ ಆರ್ಮಿ ಇಲ್ಲ, ನಮ್ಮ ಹತ್ತಿಗೆ ಪೊಲೀಸ್ ಇಲ್ಲ, ಈ ಪೆನ್ನು ಇಂಕು ಸಹಿತ ಅವ್ರು ಕೊಟ್ರೆ ನಾವು ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಹಾಳೆ ಎಲ್ಲ ಅವ್ರು ಕೊಡುವಂಥವು. ಹಾಗಾಗಿ ಅದು ಯಾವುದೋ ಸಾಮಾನು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ದೂಡಿ ಮುರಿದ್ರು ಸಹಿತ ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದೇ ಸಾಮಾನು, ನಾವು ಹಂಗಾಗಿ ಏನ್ ಹೇಳಲ್ಲ. ಆದ್ರೆ ಕೋರ್ಟ್ ಆದೇಶಗಳನ್ನು ಫಾಲೋ ಮಾಡ್ಬೇಕು. ಮಾಡ್ಲಿದ್ರೆ ಹೆಂಗ್ ಮಾಡೋಣ ನಾವು? ರೂಲ್ ಆಫ್ ಲಾ. ವಾಟ್ ಈಸ್ ರೂಲ್ ಆಫ್ ಲಾ? Follow the orders of the court. First requirement.
Yes, sir.
ಅದಕ್ಕೆ ಅವರು ನಿಮ್ಮ ಆಫೀಸರ್
ಇಲ್ಲ, ಈಗ ಅವರು ಹೇಳಿದ್ರು
ಅವರಿಗೆ ಗೌರವದಿಂದ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನ ಫಾಲೋ ಮಾಡ್ತಾರೋ ಅಥವಾ ಇಲ್ಲೋ ಇಷ್ಟೇ ಹೇಳ್ತಕ್ಕದ್ದು. ಅವ್ರಿಗೆ ಹೇಳಿ,
ಇಲ್ಲ ಮಾಡಿಸ್ಬೇಕು, ನಮ್ ಜವಾಬ್ದಾರಿ.
ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
We don't want their interpretation.
Yes, sir.
To follow
As
the
an
rule of
officer
law.
of the court, it is my duty, our duty.
ನೀವು ಬಂದಿದ್ದಕ್ಕೆ ನಾವು ಲೀನಿಯನ್ಸಿ
ಹೌದು.
Yes.
ನೀವು ಬಂದಿದ್ದಕ್ಕೆ ಲೀನಿಯನ್ಸಿ ತೋರಿಸಿದ್ವಿ.
We are
Interpret ಮಾಡ್ತಾರೆ.
ಹಾ, Simple
Interpretation ಬೇಡ.
ಸ್ಟೇಟಸ್ ಕೋ,
ಹೌದು.
ದೇರ್ ಆಫ್ಟರ್ ಟು ಕಂಟಿನ್ಯೂ ದೆಮ್ ಸರ್ವಿಸ್.
Correct.
ಎರಡನ್ನು ದೇ ಆರ್ ನಾಟ್ ಮಂಗೂಸ್ ಅಂಡ್ ಕೋಬ್ರಾ.
Correct.
ಅವುಗಳನ್ನು ಎರಡನ್ನೂ ಅರ್ಥ ಮಾಡಿ.
My humble request is to Lordship may consider our submission that at par with other 11 employees, we will continue that. ಈಗ 11 ಜನ ಇದಾರಲ್ಲ, ಅದೇ ತರದ ವ್ಯವಸ್ಥೆ ಒಳಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ತಾವು ಅವಕಾಶ ಮಾಡಿದ್ರೆ ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಅವ್ರನ್ನ 11 ಜನರ ಟೈಪ್ ಯಾವ ರೀತಿ ಇದೆ?
ಅದು ಸಾದಿಲ್ವಾರು ವೆಚ್ಚ.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅವರು?
ಇವರು
ಪೆಟಿಷನರ್ಸ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಒಟ್ಟು 31 ಜನ.
30
ಒಂದು ನಿಮಿಷ, ಒಟ್ಟು
30 ಜನರಿಗೆ
31 ಜನರಲ್ಲಿ ಒಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
ಬಹಳ ಜನ ತೀರ್ಕೊಳ್ತಾರೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸಕ್ಕೆ.
3 ಜನ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. 3 of them are dead, my lord.
ಇನ್ನು ವೆರಿ ಫ್ಯೂ, ಇನ್ನೊಂದ್ 2 ವಾರ 3 ವಾರ ಹೋಗ್ಬಿಟ್ರೆ 20, ಅದು ಒಂದು ಬೆಸ್ಟೇ.
ಸೊ ಈಗ ಏನು 11 ಜನ ಇದ್ದಾರೆ, ಅದೇ ಸ್ಕೀಮನ್ನ ಇವ್ರಿಗೆ ಅಡಾಪ್ಟ್ ಮಾಡಿ ತಾವು
ಏನಾರ ಒಂದ್ ಮಾಡಿ.
My lord, sorry for interfering.
Please be seated. We are having interaction. We'll come to you.
Sorry.
Kindly be seated.
Sorry.
Kindly be seated. Don't disturb us.
I'm sorry.
Kindly be. You should not have put all these people here. This is not a magistrate court.
I didn't get them, my lord.
ಕೂತ್ಕೊಳ್ಳಿ. Yes, brother.
Your
What are you going to?
Your Lordship, now 11 members are continuing with working under the FD ಏನ್ ಸ್ಟಿಪ್ಯುಲೇಟ್ ಮಾಡಿದ್ರೆ ಅದ್ರೊಳಗೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ. ಅದೇ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ನ ಇವ್ರಿಗೆ ಮಾಡಿ
ಅವ್ರಿಗೆ ಏನಿದೆ ಅದು ಏನ್ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಅಂದ್ರೆ ಅದೇನು ಅಂತ ಹೇಳಿ.
ಅವ್ರಿಗೆ ಕಾಂಟ್ರಾಕ್ಚುಲ್ ಒಳಗೆ ಮೊದಲು 3-3.5 ಸಾವಿರ ಕೊಡ್ತಾ ಇದ್ರು. ಈಗ 4 ಗಂಟೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಇವ್ರು. ಒಟ್ಟು ಒಂದು ದಿನಕ್ಕೆ 4 ಗಂಟೆ ಕೆಲಸ ಮಾಡ್ತಕ್ಕಂತಿದ್ರೆ ಮೊದಲು 3,000 ರೂಪಾಯಿ ಕೊಡ್ತಾ ಇದ್ರು, ಈಗ 6,500 ರೂಪಾಯಿ ಕೊಡ್ತಾ ಇದ್ರು.
6,500.
6,500.
ನಿಮ್ಮ ಮಿನಿಮಮ್ ವೇಜಸ್ ಮಿನಿಮಮ್ ವೇಜಸ್ ತಗೊಳ್ರಿ,
6,000 ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ನಾನು ಜಜ್ಮೆಂಟ್ ತೆಗೀರಿ. ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಆನ್ ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ಟೇಕ್ ಔಟ್. ಬಿಲೋ ಲಿವಿಂಗ್ ವೇಜಸ್ ಕೊಡಕ್ಕೆ ಬರಲ್ಲ.
ಅಂದ್ರೆ ಇವರು ಓನ್ಲಿ 3 hours 4 hours ಮಾತ್ರ ಬೆಳಿಗ್ಗೆ ಬಂದು ಕೆಲಸ ಮಾಡಿ ಹೊರಟೋಗ್ತಾರೆ.
ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು?
ಕ್ಲೀನಿಂಗ್ ಮಾಡಿ ಹೊರಟು
ಕಸ ಹೊಡಿ
ಅಷ್ಟೇ.
ಊರಲ್ಲಿ.
ಆ
ಆಮೇಲೆ
premises
ನಡೆಯುವೆಲ್ಲ ಏನ್ ಮಾಡಲ್ಲ.
ಆಮೇಲೆ ಏನಿಲ್ಲ. ಆಮೇಲೆ ಬೇರೆ
ಲೈಕ್ ಹೌಸ್ ಕೀಪಿಂಗ್.
ಅದೇ
ಕುತ್ಕೊಳ್ಳಿ, ಕೆಡ್ಸ್ಬೇಡಿ ನಿಮ್ ಕೇಸನ್ನ. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಸ್ಪಾಯ್ಲ್ ಯುವರ್ ಕೇಸ್ ಆರ್ಗ್ಯೂ.
ಅವರು ಬೆಳಿಗ್ಗೆ ಬಂದ್ ಮಾಡಿ ಹೋಗ್ತಾರೆ. ಈಗ ನಾವು ತಗೊಳಕ್ಕೆ ಅದೇ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಅಲ್ಲಿ ತಗೊಂಡಾಗ ಸಮಸ್ಯೆ ಇರೋದಿಲ್ಲ. ಇವ್ರು 11 ಜನಕ್ಕೆ ಏನ್ ತಗೊಂಡಿದೀವಿ ಅದೇ ಸಮಸ್ಯೆ.
ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಇವರು?
ಇವರು ಗಾರ್ಡನ್ ಕೆಲಸ ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ?
ಎಲ್ಲಿ ಎಲ್ಲಿ ಮಾಡ್ತಾರೆ?
ಇವರು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗಳಲ್ಲಿ ಒಂದೊಂದ್ ಕಡೆಗೆ ಈ ಡಿಸ್ಟಿಕ್ ಮೈಸೂರು ಜಿಲ್ಲೆನಲ್ಲಿ 4 ಕಡೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗಳು ಮಾಡ್ತಕ್ಕಂಥ ಕೆಲಸ. ಆ SP ಆಫೀಸ್ನ ಕೆಳಗಡೆ ಬರ್ತಕ್ಕಂಥ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗಳಲ್ಲಿ ಕೆಲಸ.
ಅವರು 3 ತಾಸು 4 ತಾಸು ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಒಂದು 5-6 ವರ್ಷದ ಹಿಂದಿನ ಒಂದೇ ಒಂದು ಲೈನ್ ತೋರಿಸಿ ಎಲ್ಲಾದ್ರು. ಒಂದು ಲೈನ್, ನಾಟ್ ಓರಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
Yes,
ಶೋ ಫ್ರಮ್ ಯುವರ್ ರೆಕಾರ್ಡ್
that they are only ಇಲ್ಲ ಇದ್ರು
5 ತಾಸು
ಅವ್ರಿಗೆ
ಎಲ್ಲಾದ್ರೂ ಒಂದು ಸೆಂಟೆನ್ಸ್ ತೋರಿಸಿ ನೋಡೋಣ. ಶೋ 1 ಸೆಂಟೆನ್ಸ್. ಪ್ರೀ ಲಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರ್ಬೇಕು.
ಕರೆಕ್ಟ್.
ಕೇಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಕ್ಕಿಂತ ಪೂರ್ವ
ಮುಂಚೆ
ತೋರಿಸಿ.
ಅವರ ಕೆಲಸ ನೀವು ಡಿಫೈನ್ ಮಾಡಿದ್ರಲ್ಲ, ಏನ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ,
ಏನ್ ಮಾಡ್ಬೇಕು,
ಎಷ್ಟು ಸಮಯ ಮಾಡ್ಬೇಕು,
ಎಷ್ಟು ತೋರಿಸ್ಲು 4 hours ಅಂತ ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಕಡೆ ತೋರಿಸಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಬೇಡ, ನೀವು ಆದೇಶದಲ್ಲಿ ತೋರಿಸಿ. ಆದೇಶದಲ್ಲಿ ಕೇಸ್ ಈ ರಾಜ್ಯ ದಾಖಲು ಮಾಡಕ್ಕೆ ಮುಂಚಿನ ಹಿಂದಿನ ದಾಖಲೆ ತೋರಿಸಿ, ಈಗಿಂದು ಬೇಡ.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಗಿವ್ ದ ಪಿಟಿಷನ್ಸ್.
ಪಾಸ್ ಅಂತ ನಮ್ಮ ಪಿಟಿಷನರ್ ಅಂಶ ಕೆಳಗಡೆ ಮಾರ್ಕ್ಸ್ ನನಗೊಂದು ಕಾಪಿ.
ಅಂಶಕಾಲಿಕ ಪಾರ್ಟ್ ಟೈಮ್ ಅಂತನಾ?
ಹೌದು. ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನಂಬರ್
ನಮ್ಮ 21/3/2025 ಆದೇಶವನ್ನು ಒಂದ್ಸರಿ ಓದಿಬಿಡಿ. ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಂಗೆ ಓದಿಬಿಡ್ಬೇಕು, ಇಲ್ಲ ನಾವ್ ಇಲ್ಲಿ ಹಿಡಿದು ಬಿಡ್ತೇವೆ.
The petitioner before this court who were working on 21.
ಈಗ ಗೊತ್ತಾಯ್ತು ಅದನ್ನ.
ಅದೇ
21 ಆರ್ಡರ್ 2021 ಆರ್ಡರ್ ಅದು
13/7/21 your lord.
13/7/21.
Yes your lord.
ಆಲ್ಮೋಸ್ಟ್ 4 ವರ್ಷ ಆಗಿ ಹೋಗ್ಬಿಡ್ತದೆ. ಆಲ್ಮೋಸ್ಟ್
ಹೌದು.
4 ವರ್ಷನೂ ಈ ಆರ್ಡರ್ ಅನ್ನು ಫಾಲೋ ಮಾಡಿಲ್ಲ ನೀವು ಯಾರು. ಅವ್ರಿಗೆಲ್ಲ ಟೈಮ್ ಇರಲ್ಲ, ಅವರಿಗೆ ಆ ಸೆಕ್ರೆಟರಿಗೆ ಇವರಿಗೆಲ್ಲ ಬೇರೆ ಕೆಲಸ ಇರ್ತದೆ ಅವ್ರಿಗೆ ಬಹಳ. ಇವರು ಸಾಯ್ಲ್ಬೇಕಾರೆ ಅವ್ರಿಗೆಲ್ಲ ಸಂಬಂಧ ಇಲ್ಲ ಅವರಿಗೆ. ಯಾಕೆ ಇದೊಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ಬೇಕು. ವೈ ದೇ were not paid. ಬ್ರೆಡ್ ಬಟರ್ ಬೇಕಲ್ಲ ಅವ್ರು ಬದುಕ್ಲಿಕ್ಕೆ. ಅವ್ರಿಗೆಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ ಸೆಕ್ರೆಟರಿಗಳು, ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ತಗೊಂಡು? Why we need them? Why we need them? Colonial rule was far better.
I beg your lord.
Mr. Ahmad Saab.
Correct.
4.5 ವರ್ಷ ಯಾವ ಸೆಕ್ರೆಟರಿಗಳು ಇದನ್ನ ತೆಗೆದು ನೋಡ್ಲಿಲ್ವಾ? ಯಾಕಂತ ತೆಗೆದು ನೋಡ್ಲಿಲ್ಲ? ನಾವ್ ಹೇಳ್ಬೇಕಾ ಯಾಕೆ ನೋಡ್ಲಿಲ್ಲ ಅವರು ಅಂತ? ಹಿಂಗಾದ್ರೆ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ಆಮೇಲೆ ಅವ್ರ ಗತಿ ಏನು ಅಂತ ಅವ್ರು ತಮ್ಮ ಮಕ್ಕಳಿಗಾದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಕೇಳಿ?
I agree with it.
ಮತ್ತೆ
ಇದಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ ಎರಡು ಆದೇಶ ನಾನು ಇಟ್ಟಿದ್ದ ಉದ್ದೇಶ ಅದೇ ಗೊತ್ತು
ಅದು
ಸರಿಯಾದ
ಉದ್ದೇಶ ಆಯ್ತು. ಈಗ ನಮ್ಗೆ ಆರ್ಡರ್ಗಳ ಉದ್ದೇಶ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ಆ
ಹೌದು.
ಉದ್ದೇಶದ ಬಗ್ಗೆ ಹೇಳಿ.
ವಾಟ್ ಎವರ್
ಅವ್ರಿಗೆ-
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್
ಯಾವಾಗ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರು ಅಲ್ಲಿ ತನಕ ಸ್ಯಾಲ್ರಿ ಡ್ರಾ ಮಾಡಂಗಿಲ್ಲ. ನಾವ್ ಇಂಥ ಆರ್ಡರ್ಸ್ ಮಾಡಲ್ಲ ಸಾಮಾನ್ಯವಾಗಿ. ಬಟ್ ಅವ್ರು ಆರಾಮ್ ಇರ್ತಾರ, ಅವ್ರಿಗೆ ಸ್ಯಾಲ್ರಿ ಬೇಕಿಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್. ಬಟ್ ಇವ್ರಿಗೆ ಬೇಕಾಗ್ತದೆ,
ಲಾರ್ಡ್ಶಿಪ್
ಇವ್ರು ಬದುಕಬೇಕಲ್ಲ. ದೇ
ಹಾಗೆ.
ಹ್ಯಾವ್ ಟು ಹೋಲ್ಡ್ ದೇರ್ ದಿ ಬಾಡಿ ಅಂಡ್ ಸೋಲ್ ಟುಗೆದರ್. ಟು ಸ್ಕ್ಯಾಂಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್. ನಾವ್ ಹೆಂಗ್ ತಡ್ಕೋಬೇಕಿದ್ನ?
15ರಿಂದ 34 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
As on 13/7/21.
ಹೌದು.
You are snatching their bread and butter.
ಬಟರ್ ಅಲ್ಲೇ ಅಲ್ಲ, ಬರೀ ಬ್ರೆಡ್. ಬ್ರೆಡ್ ಎಲ್ಲ ಅವರೇ ಇಟ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
I beg your lordship, after lordship's order last occasion.
ನಮ್ಗೆ ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳ್ರಿ.
ನಾವು ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಯಾರಿದ್ದಾರೆ ನಿಮ್ ಸೆಕ್ರೆಟರಿ? ನಾವು ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್.
ಇಲ್ಲ ನಾನು ಇದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಅಟ್ ಪಾರ್
ಇದೇ ಆಗ್ತದೆ. ಅದು ಹೆಂಗಿದ್ರು
ಅಲ್ಲ.
ಈಗ ನಾವು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ರಾಂಗ್ ಆರ್ಡರ್ ಅದು. ಬಟ್ ನಾವು ಜಸ್ಟಿಸ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಹಾಗಾಗಿ
Lordship.
ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್ ಅವ್ರನ್ನ ಕಸ್ಟಡಿ ತಗೊಳ್ಳಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
Your lordship.
ಎನಿಥಿಂಗ್ ದೇವಿಲ್ಲ, ಈ ನಾಳೆ ನಾಡ್ ಬೇಕಾದಂಗೆ ಕೆಲಸ ಇದೆ.
ಲಾರ್ಡ್ಶಿಪ್
Let them learn a lesson.
ಅದರ್ವೈಸ್ ಹೆಂಗಾಗೋದು?
ನಾವು ಸೀರಿಯಸ್
Yes, sir.
ಈ ಕೋರ್ಟ್ ಆದೇಶ ಮಾಡಿದ್ಮೇಲೆ ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಬಹಳ ಸೀರಿಯಸ್ ತಗೊಂಡು ಇದನ್ನೆಲ್ಲ ಕಲೆಕ್ಟ್
ಸೀರಿಯಸ್ ತಗೊಂಡಾಯ್ತು, ದುಡ್ಡು ಎಲ್ಲಿ ಮುಟ್ಟಿದೆ ಅವರಿಗೆ?
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಪ್ರಾಪರ್ಲಿ ಕಮ್ಯುನಿಕೇಟೆಡ್ ಫ್ರಮ್ ಹಿಯರ್.
ನೀವು ಮಧ್ಯಾಹ್ನ ಚೆಕ್ ತರ್ಲಿಕ್ಕೆ ಆಗ್ತದ?
ನಾವು ಈಗ ಇದು ಇವ್ರನ್ನ ಅಟ್ ಪಾರ್ ವಿತ್ ದೆಮ್ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ಕೆ ಒಂದು ಅವಕಾಶ.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರನ್ನ ಕೇಳೋಣ ಅಂತ. ಮೇಡಮ್, ಯು ವಾಂಟೆಡ್ ಟು ಸೇ ಸಮಥಿಂಗ್.
Only one submission, my lord. 3,000 rupees they were paid, my lord, when they were working on daily wages. Now they have been removed and they have put on a contractual basis on the same post for 6,000 rupees, my lord. Morning to evening, up to 6-7 o'clock, they are working, my lord.
ಎಲ್ಲಿದೆ?
They don't have any
Where have you
records.
stated in the petition?
I have stated in my petition, your lordship may kindly see para 7, my lord. I clearly stated it's a full-time work. Your lordship may kindly see para 7. And I will show the appointment order also. It's not a temporary, it's not part-time also, man.
Appointment
Para
order?
7, my lord, para 7.
Have you produced that order?
I produced all the appointment orders, my lord.
Orders
They are working against a full-time post.
ಏನ್ ಪೋಸ್ಟ್ ಕಸ ಹೊಡಿಯೋ ಕೆಲಸ?
Kasa, ashte, Swami, your lordship may kindly see the first appointment order itself. It's against a full-time post. And they say, nimge seniority allowance kodala ashte. Para 7, it is submitted, petition has been working.
Whether they had filed a reply statement before the KAT?
The same thing, they say that this is not a pensionable post, this
No.
is a
How
part-time
many
post.
hours ಬಗ್ಗೆ?
They don't, they say the same thing there, it's a part-time post.
What they have said? Part time ಅಂತ ಹೇಳಿದಾರ?
Part-time ne ಹೇಳ್ತಾರೆ ಅವರು.
ಪೇಜ್ ನಂಬರ್
Everywhere
81.
they're saying this. Your lordship may kindly see one of the appointment order, my lord. I'll just take your lordship to one appointment.
ಈಗ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡಲ್ಲ ನಾವು. ಮೊದ್ಲಿಗೆ ಆದಂತ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿ, ಸೊ ದಟ್ ಅವ್ರಿಗೆ 4 ಕಾಸು ಮುಟ್ಲಿ ನಿಮ್ ಕ್ಲೈಂಟ್ಗೆ.
Please.
ಆಮೇಲೆ ಒಂದ್ ದಿವಸ ಹೇರ್ ಮಾಡೋಣಂತೆ. ಮೊದ್ಲು ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಆರ್ಡರ್ ಕಂಪ್ಲೈನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಸ್ಪೆಕ್ ಆಫ್ ಯುವರ್ ಡಿಫೆನ್ಸ್.
Yes, we will
ಆಯ್ತು, ಎಷ್ಟೊತ್ತಿಗೆ ತಗೊಂಬರ್ತೀರಿ? ಡಿ ಇದನ್ನೆಲ್ಲ ಚೆಕ್ ಎಲ್ಲ ಎಷ್ಟೊತ್ತಿಗೆ ತಗೊಂಬರ್ತೀರಿ? ನಮ್ಗೆ ಬೇರೆ ಹೇಳ್ಬಿಟ್ರಿ ಅಹಮದ್ ಸಾಬ್,
yes.
ನಿನ್ನೆನೆ ಹಬ್ಬ ಮಾಡಿರಿ ನೀವು ಅಲ್ವಾ? ಎಲ್ಲರೂ ಈದ್ ಮಿಲಾದ್ ಇದನ್ ಮಾಡಿದೇವಿ. ಎಸ್ಟರ್ಡೇ ವಿ ಹ್ಯಾವ್ ಸೆಲೆಬ್ರೇಟೆಡ್ ರಂಜಾನ್.
ಉಗಾದಿ ಮಾಡಿದೀವಿ, ಇದು
ಅದು
ಮಾಡಿದೀವಿ.
ಪಾಪ ಅದ್ರಾಗೆ ಅವ್ರಿಗೂ ಹಬ್ಬ ಮಾಡೋದ್ ಬೇಡ? ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡೋಕೆ? ಈಗ 4 ಹಬ್ಬಗಳು ಹಂಗ ಹೋಗಿದಾವಲ್ಲ, ಏನು ಅಲ್ದಂಗೆ.
ನನ್ನ ಹಂಬಲ್ನೆಸ್, ಸಿನ್ಸಿಯಾರಿಟಿ ಅಂತಾವು ನಾವು ಆಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್
ನಮ್ಗೆ ಏನ್ ಮಾಡ್ತೀರಿ ಅಂತ
ಮಾಡ್ತೀವಿ. ನನ್ಗೊಂದು
ಏನ್?
ಸಣ್ಣ ಅವಕಾಶ, ಅದು ತಾವೇನ್ ಹೇಳ್ತೀರಿ ಆದೇಶ.
ನಾವು ಏನ್ ಹೇಳಲ್ಲ, ಆರ್ಡರ್ ಹೇಳ್ತಾ
ನಾವು ದಿ ಆರ್ಡರ್ ಸೇಸ್ ದೇ ಆರ್ ಸಪೋಸ್ ಟು ಬಿ ಕಂಟಿನ್ಯೂಡ್. ಅದು ಆಗಿಲ್ಲ.
ದೇ ಶುಡ್ ಬಿ ಕಂಟಿನ್ಯೂಡ್.
ಕಂಟಿನ್ಯೂ
ಸೊ ಯು ವಿಲ್ ಕಂಟಿನ್ಯೂ.
ಕಂಟಿನ್ಯೂ ಅಟ್ ಪಾರ್ ವಿತ್ ಅದರ್ 11 ಮೆಂಬರ್ಸ್. ಅದೇ ತರದಲ್ಲಿ ಅದಕ್ಕೊಂದು ತಾವು ಆದೇಶ ಮಾಡ್ಬಿಡಿ. ಲೆಟ್ ದೆಮ್
ಲರ್ನೆಡ್, ಒಂದ್ ನಿಮಿಷ, ಲರ್ನೆಡ್ AAG appearing for the state and officials on instructions of the officials present before the court, namely so and so, promises and assures the court, promises to and assures the court that all the employees before the court shall be continued in employment with the terms that obtained when they gained entry to their service, comma, whichever be its nature. And this will be done within
ವೀಕ್ ಮಾಡ್ತೀವಿ.
within 1 week.
ಲಾರ್ಡ್ಶಿಪ್ ಒಂದು ಸಣ್ಣ ಕರೆಕ್ಷನ್. ನಾಟ್ ಆನ್ ದಿ ಕಂಡೀಷನ್ ಬೈ ವಿಚ್
ಅವ್ರಿಗೆ ಅಪ್ಲೈ ಆಗುವಂತ ಪ್ಯಾಕೇಜ್ ನಲ್ಲಿ ದಿಸ್ ಇಸ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಟ್ ಪಿಟಿಷನ್.
ರಿಟ್ ಪಿಟಿಷನ್. ಮತ್ತೆ ಈಗ ಏನಾಗಿದೆ, ಇವ್ರನ್ನ ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಇಟ್ಕೊಂಡು ನಾ ಹೆಡ್ಡೇ ಬೇರೆ ಆಗ್ಬಿಡ್ತದೆ. ಮನಿ ಡ್ರಾ ಮಾಡೋದು ಅಟ್ ಪಾರ್ ವಿತ್ 11.
ವಾಟ್ ಎವರ್ ಹೆಡ್, ವಿ ಆರ್ ನಾಟ್ ಬಾದರ್ಡ್.
Yes.
ಅವ್ರಿಗೆ ದುಡ್ಡು ಮುಟ್ಬೇಕು, ಈ ಹೆಡ್ ಆ ಹೆಡ್ ಅವ್ರ ಜೋಬಿಗೆ ದುಡ್ಡು ಮುಟ್ಬೇಕು ಕೆಲಸ ಮಾಡಿದವ್ರಿಗೆ. within 1 week, within 1 week. On par with
The
others, we have been
continued. with-
continued.
Yes, sir.
Continued. First, this arrangement shall be subject to outcome of the writ petition. Payment ಬಗ್ಗೆ ಏನ್ ಮಾಡ್ತೀವಿ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವರೆಗೆ ತಾವು ಏನು ಆದೇಶ ಮಾಡ್ತೀವಿ ನಾವು
ಅವ್ರೆಲ್ಲ ಅಲ್ಲಿವರೆಗೆ ಅವರು ಸ್ಯಾಲ್ರಿ ಡ್ರಾ ಮಾಡಂಗಿಲ್ಲ. ಆದ್ರೆ ಸ್ಯಾಲ್ರಿ ಡ್ರಾ ಮಾಡೋ ಅಗತ್ಯ ಇಲ್ಲ ಅವರಿಗೆ. ಇವ್ರಿಗಿದೆ, ಇವ್ರಿಗಿದೆ, ಅವ್ರಿಗಿಲ್ಲ. ಗೊತ್ತಾಗತ್ತೆ ನಮಗೆ.
ಎಸ್ ಬಿಕಾಸ್ ಆಲ್ ದಿಸ್ 5 ಕಡೆ
ಯಾವತ್ ಕೊಡ್ತಾರೆ ಪೇಮೆಂಟ್? ಯಾವತ್ ಮಾಡ್ತಾರೆ? ನಮ್ಗೆ ಚೆಕ್ ತಗೊಂಡ್ಬರ್ಬೇಕು ಕೋರ್ಟಿಗೆ. ನಮ್ಗೆ ದುಡ್ಡು ಅಂದ್ರೆ ಬಹಳ ಪ್ರೀತಿ ಆಗಿದೆ ಇತ್ತೀಚೆಗೆ.
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ತಂದು
ಹಾ?
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ತಂದು
ದುಡ್ಡು ತೊಗೊಂಬರ್ತೀರಾ?
ಚೆಕ್ ತಂದು ಕೊಡ್ತೀವಿ. So check to be drawn in the name of registrar.
Learned DAG further assures that with effect from the court order
Court order.
dated 21 July, 14 July
13/7/21.
13/7/2021, all the amount payable shall be computed, calculated, and checks shall be brought to the court hall itself in the name of individual employees, in the name of individual employees.
ರಿಜಿಸ್ಟ್ರಾರ್ ಇಲ್ಲಿಗೆ ನಾವು ಡ್ರಾ ಮಾಡಿ ಕಟ್ಬಿಡ್ತೀವಿ.
ಹಾ?
ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡೋ ತೊಂದರೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, ನಮ್ಗೆ ಅದೊಂದು ಕೆಲಸ ಆಗ್ತದೆ. ಅವ್ರಿಗೆ ಚೆಕ್ ಕೊಟ್ಟು ನೋಡಿ, ಇಲ್ಲಿ ಬಂದಾರ ಅವ್ರು ಪಾಪ. ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ತರಲಿಕ್ಕೆ ಆಗಲ್ವಾ ಚೆಕ್ಗಳನ್ನು ಬರ್ಕೊಂಡು?
ಅಲ್ಲಿ ಎಲ್ಲ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಇಂದ ಬರ್ಬೇಕು,
ಅಲ್ಲಿಂದ ಬರ್ಬೇಕು.
ಬಳ್ಳಾರಿಯಿಂದ ಬರ್ಬೇಕು,
ಅದೇ.
ಕೊಡಗಿಂದ ಬರ್ಬೇಕು.
ಅದೇ ಟ್ಯೂಸ್ಡೇನಾ?
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ.
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಆಗಲ್ಲ, ಮಂಡೇ ಹಾಕೋಣ. ಟ್ಯೂಸ್ಡೇ ಇಸ್ ಟ್ಯಾಕ್ಸ್ ಡೇ.
ವೆಡ್ನೆಸ್ಡೇ ಮಾಡಿ.
ವೆಡ್ನೆಸ್ಡೇ ಅದು ಟ್ಯಾಕ್ಸ್ ಡೇ. ಹಾಗಾದ್ರೆ ಮಂಡೇನೆ. ಆನ್ 8th of April. ಅಲ್ಲಿವರೆಗೆ ಸ್ಯಾಲ್ರಿ ತಗೊಂಡಂಗಲ್ಲ ಅವ್ರು ಯಾರು ಸೆಕ್ರೆಟರಿಗಳು. ನೋ ಸ್ಯಾಲ್ರಿ. ದಟ್ಸ್ ದ ಓನ್ಲಿ ವೇ. ನಾಳೆ ಜಡ್ಜ್ ಲಾಯರ್ಸು ಹೇಳ್ಬೋದು, ನೀವು ಜಡ್ಜ್ಗಳು ಸ್ಯಾಲ್ರಿ ತಗೋಬೇಡ್ರಿ, ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ. ಬಟ್ ವಿ ವಿಲ್ ರಿಕ್ವೆಸ್ಟ್ ದೆಮ್ ನಾಟ್ ಟು ಸೇ ಆಲ್ ದಟ್. ಬಟ್ ಟು ಯು ದಿಸ್ ಇಸ್ ಅಪ್ಲಿಕೇಬಲ್.
ಲಾರ್ಡ್ಶಿಪ್ ತಮ್ಮ ಈ ನ್ಯಾಯಮೂರ್ತಿಗಳ ಸೇವೆ ದೇಶಕ್ಕೆ ಎಲ್ಲ ಸ್ಯಾಕ್ರಿಫೈಸ್ ಮಾಡೋದು. ಇಟ್ ಇಸ್ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ
ಗವರ್ಮೆಂಟ್ ಏನಾರ ಯಾವ್ದೋ ಒಂದು ಬ್ಲಾಕ್ ಶೀಪ್ ಇಟ್ಕೊಂಡು ನೀವು ಏನ್ ಬೇಕಾದ್ ಮಾತಾಡೋದು ಮಟ್ಟದ ಜಡ್ಜ್ಗಳ ಮೇಲೆ ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಹರ್ಟ್ ಆಗಲ್ವಾ? ನಮ್ಗೆ ಹರ್ಟ್ ಆಗಲ್ವಾ? ಯಾರು ಕೆಲಸ ಮಾಡೋದೇ ಇಲ್ವಾ ಹಂಗಾರೆ?
ಎಲ್ಲ ತ್ಯಾಗ ಮಾಡಿ ಮಾಡ್ತಾರೆ, ಎಲ್ಲ ತ್ಯಾಗ.
ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. ನಾವು ಅವ್ರಿಗೆ ರಾವ್ ಸಾಹೇಬ್ಗೆ ಇವ್ರಿಗೆಲ್ಲ ಬೈತೇವೆ, ನಾವು ಎಲ್ಲ ಮೋಸ ಮಾಡಿದ್ರಿ.
ಲಾರ್ಡ್ಶಿಪ್ ಅದರಲ್ಲಿ ಅಂಡ್ ದೋಸ್
ಮಾಡಿ
ಪಾಸ್ಟ್ ಅವೇ ಅದನ್ನೊಂದು ರೈಡರ್ ಒಂದು
ಯಾರ್ಯಾರು ತೀರ್ಕೊಂಡಾರಲ್ಲ
ತೀರ್ಕೊಂಡು
ಅವ್ರ ಎಲ್ಲಾರ್ಸನ್ನ ಹುಡುಕಿ, ಅವ್ರು ವಿಡೋ ಇರ್ತಾಳೆ ಅಥವಾ ವಿಡೋರ್ ಇರ್ತಾನೆ, ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. ಅದು ಇನ್ನೂ ಇಂಪಾರ್ಟೆಂಟ್. ಇಲ್ಲ ಅದರ್ಸ್ ಡೈ. ಹೌದು,
ಅವ್ರು ತಿಳ್ಕೊಳ್ಳೋ ತನಕ ಅವ್ರು ಸ್ಯಾಲರಿ ಕೊಡ್ಬೇಕಲ್ಲ ತಾವು. ಯಾವ ಟು ಪೇ.
ಅವ್ರ ಪಾಪ ಅವನು ಇಲ್ಲ ಈಗ, ಅವನು ಅವಳ ಅವ್ರು ಎಲ್ಲಾರ್ಸನ್ನ ನೀವು ಹುಡುಕ್ಬೇಕು. ಹುಡುಕಿ ಹೆಂಗ್ ಊಟ ಹಾಕಿ ಉಪಕಾರ ಮಾಡ್ತಿರ್ಲ ಆ ರೀತಿನೇ ಹೋಗಿ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟು ಚೆಕ್ ಕೊಟ್ಟು ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಗೌರವದಿಂದ ಕೊಡ್ಬೇಕು. ಅಲ್ಲೇ ಪಮಿಷನ್ನು ವ್ಯವಹಾರ ಆಗಬಾರ್ದು.
ಇಲ್ಲೇ ತಂದು ಇಲ್ಲೇ
ಅದಕ್ಕೆ ಚೆಕ್ ತೊಂಬರ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ.
ಅಂಡ್ ಲಾರ್ಡ್ಶಿಪ್ ಇದೊಂದು ಕರೆಕ್ಷನ್ ನಾಳೆ ಇನ್ನೊಂದು ಒಂದು ಈಗ ಯಾರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಡ್ರಾ ಮಾಡ್ತಕ್ಕಂಥ ಅದು ಒಂದು. ಎರಡನೇದು ದೋಸ್
ಪೇಮೆಂಟ್ ಶಾಲ್ ಬಿ ಮೇಡ್ ಟು ದಿ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ದ ಡಿಸೀಸ್ಡ್ ಎಂಪ್ಲಾಯಿ ಆಫ್ಟರ್ ಅಸರ್ಟನಿಂಗ್ ದೇರ್ ಕ್ರೆಡೆನ್ಶಿಯಲ್ಸ್ ಆನ್ ಎ ವಾರ್ ಫೂಟಿಂಗ್. ಆನ್ ಎ ವಾರ್ ಫೂಟಿಂಗ್ ಯು ಹ್ಯಾವ್ ಟು
ಸೂಪರ್ ಎನ್ಯೂಷನ್ ಆಗಿರ್ತಕ್ಕಂಥವ್ರಿಗೆ 60 years ವರೆಗೆ ಕೊಡ್ತಕ್ಕಂಥದ್ದು ಮಾಡಿ. ಈಗ ಕೆಲವು
ಕೆಲಸ ಹಚ್ಚಿಲ್ವಾ ಅವ್ರಿಗೆ?
ಕೆಲಸ ಹಚ್ಚಿಲ್ಲ ಅವ್ರಿಗೆ. ಈಗ ಕೆಲವೊಬ್ರಿಗೆ 60 ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
We make it clear that those who have been superannuated on attaining the age of 60 years, their claims will be considered in due course. Due course. The voice of the entire proceeding record is available in the court system. Court system. All the parties, their advocates, government machinery, and public at large can see this. First, earlier order restraining drawing of the salary by the secretary, principal secretary, and secretaries of the concerned departments continues. First, this is a harsh order, but harshness is required to ensure compliance of the court orders nowadays. First off, otherwise, ordinarily we would not have made such directions.
Much obliged.
I heard learned AG. I'm assisted by AG.
Much obliged.
next date ಗೆ ಅವ್ರಿಗೆ ಇರ್ಲಿಕ್ಕೆ ಹೇಳ್ಕೊ on the next date of hearing. The
All the-
principal secretary and secretary shall be present unless
ಇಲ್ಲ, ನಾ ಮಾಡಿ
checks are sent to the court itself.
ಮಚ್ಚು,
ಚೆಕ್ ಇರ್ಲಿದ್ರೆ ಅವ್ರು ಬರ್ಬೇಕು.
ಮಚ್ಚು,
ಅವ್ರಿಗೆ ಹೇಳಿ ನಾವೇನ್ ಮಾಡ್ಬೋದು ಅಂತ.
ಮಚ್ಚು.
Brief them. Generally, we will not order personal presence because 2024 Supreme Court says we should not order. But I hang nadiyalla ಅದು, ಇದು ಸ್ವಲ್ಪ extraordinary case. Okay.
Yeah,
Next.
our stand is that our AJ office, we have taken a decision, we will,
ನಿಮ್ಮ ನಂಬೆ ನಾವು Ahmad, Mr. Ahmad, we have only because of you have made this
Yes.
concession. Only because of you.
ಮಚ್ಚು.
Okay. Yes. Yes, sir. Yes. Rao sir, Mr. Patil.
Matter has to be heard, my lord.
Ah.
It's not an interlocutory applications to be considered at this stage like any other case.
Hmm.
My lord, what has happened, the PDOs, Panchayat Development Officers and Panchayat Extension Officers and grade 2 secretaries, my lord, there is some confusion.
Oh.
There was a merger. And then those who are directly recruited at 67%, 33% within the department itself, my lord. Then the seniority was not fixed properly. Because of that, the aggrieved persons went to the KAT. KAT, my lord, dismissed the petition. They came up here. By consent, a committee was constituted at the suggestions of the learned counsel on either side, including the learned advocate general. The committee gave a report, my lord. Then in the order of this honorable court, it is categorically mentioned if there is a serious illegality, then window of opportunity is open for us to come back to this court and show that. That is how the applications have been filed. One by Sri Rajagopal appears in one case and I appear in the other case, my lord. So these matters have got to be heard. And if some date is fixed, we are ready to argue the matter. my lord.
May I just make one submission? Lords, we have moved the matter.
One niಮಿಷ.
What
Patil.
set of petitions are filed instead of application? We have filed it as writ petition itself, challenging that committee report.
Committee report.
Ultimately, what we are claiming is, for example, what has happened is it's a district level recruitment.
District level recruitment.
Yes. Now a state seniority list is being made of these district level appointees.
So your
Because-
baseline is district level seniority list should be prepared ಅಂತ. ಅಲ್ಲ.
Now they are making it as a state level this thing. What should be the norm to do that? According to us, under the service rules, it is the date of entry which should be the criteria unless something
Else is-
else comes in. What has happened is, for some of the petitioners, order was issued on 22/9/23, suppose, asking them to report on 5/4/23. They have gone and reported on 5/4/23. They don't have the benefit of from the date of the order. But in some orders, they have not given the date for duty report in several districts. Therefore, for them, they are seeking to take that as the date of the order as the date for
Entry.
senior,
Entry.
which we have pointed out, that is not what the court had directed the committee to do. Rule 7A and 5(1) of the seniority rules will have to be adhered, is ultimately
That is the principal submission.
Lords, may I make a sub?
Yes.
Lords, this is a disposed of matter, my lords. By this honorable court, my lords, disposed of the matter, constituting a committee to, my lords, hear the objections, my lords, of all the stakeholders, and then, my lords, give a recommendation. There is a specific finding, my lords, by this honorable court, that the findings of the committee shall be forwarded to the state government. The state government shall not sit in appeal over that. The state government shall implement the report of the committee. In terms of the report of the committee, my lords, a provisional seniority list has been drawn and published, and objections have been invited. At that stage, my lords, this honorable court has also only stated that if the proceedings of the committee are vitiated by a patent illegality, only then they can come. It is not the findings, and court has also given liberty that if anybody, in respect of the seniority that is finalized, if anybody has a grievance, they can, my lords, ventilate their grievances in accordance with law. That is approach the tribunal. But now, my lords, it is only on the ground of patent illegality. There is an order passed by this honorable court stating that they have to file a synopsis with regard to on what grounds they're saying that the proceedings of the committee is vitiated by patent illegality, not the findings of the committee. The findings of the committee vitiated by a patent illegality or any other ground, my lords, is a fresh cause of action for them, my lords, based on the final seniority list that is published. If I request my lords to
So
take,
writ petition is not maintainable. unless-
not only writ petition, even the
Applications
applications
also
also are not maintainable. This honorable court, my lords, had specifically directed them file a synopsis showing the patent illegality, will hear the matter. So only on that limited ground, my lords, matter is required to be heard, with regard to they showing patent illegality in the proceedings.
ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Please.
Lords, if I can, the issue relating to inter se seniority between the direct recruits and the promotees was what was the subject matter of the writ petition which is disposed of. Lords, the order which was passed by this honorable court was a consensual order on the basis of a joint memo. Lords, a joint memo was filed consisting of two parts. One is the procedure to be followed by the committee and the manner in which the committee has to deal with the matter. To the resultant situation where the committee's decision, once it is communicated to the government, what is that the government is required to do? Government on the basis of, because the government cannot sit on judgment over the committee's findings, it has to prepare a provisional seniority list, call for the objections, and then issue the final seniority list. You know, this is the direction so far as the government is concerned. Not so far as the other persons who might be affected, Milords, by the proceedings of the committee is concerned, there were twofold, Milords, remedies I can say, Milords, which was provided for. In the event of there being any patent illegality in the proceedings of the committee itself, then they could reapproach the court is one avenue which was kept open. Milords, the other observation which was specifically made is in the event, Milords, this I'll just kindly pardon me, Milords, if I have to read this. It is made clear that if any individual has grievances, it is open for the parties to seek redressal before the appropriate forum. Lords, any individual grievance which has been addressed has to be addressed before the appropriate forum. Now, so far as the issue relating to the PDO now being rendered as a statewide cadre, and what are the modalities with which the seniority has to be fixed is never the subject matter, Milords, of these petitions. Now to advance an argument, Milords, goes beyond the scope of the limited avenue which was provided for under paragraph number 6 of your Lordship's order.
ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಣಂತೆ.
Lordships, I mean your
ಮಾಡ್ಕೊಂಡು
Lordship's.
ನಾನು
Very well, very well.
ಸಿಂಪಲ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಯ್ತು.
Yes, that's all the issue. Milords.
ಕಾಂಪ್ಲೆಕ್ಸಿಟಿ ಏನಿಲ್ಲ.
Yes.
As Jacob said.
Please, my lords, can it be before vacation? If it is
Before occasion of difficult ಇದೆ. ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ. ನಮ್ನ ಬೇರೆ you have made us to work hard now.
no, only a request.
To
I'll leave it to
keep
them.
matters. Therefore, immediately after vacation, we
Please.
ಮಾಡ್ಬೋದಾ? ಬರ್ಕೊಳ್ಳಿ. Call these matters immediately after vacation.
Because if you, I'm
Some
sorry,
other
Milords, it may be, is it possible your Lordships may only indicate the week, Milords, first week of, Milords, sir.
Well,
Just-
the first week of June 2020. Very good. Otherwise, it may not come.
I understand, Milords.
Grateful.
Ah. First week of June, Mr. Rao sir,
Is it
Party-
possible this side of the vacation?
you know, very difficult. Very difficult. We are in parted matters where some other aspects are being looked into in relation to some recruitment process. We need not specify. Perhaps everybody knows. Therefore, give us a short adjournment to call in the first week of June 2025.
Lords,
Interim
Interim
order.
order. Wherever there is interim order, comma, the same shall be continued
till the next date.
till next date. of-
Please.
Grateful.
Yes. Next. Yes, Mr. Reddy.
For the petitioner, my lord,
ಏನಿದೆ?
lord, there are office objections, my lord, and all the relevant annexures, my lord, for adjudication of this list, my lord, has been marked as annexures in this petition.
Objections in, objections.
Office objection. That is annexures to be provided, but all the necessary annexures, my lord, for the
Produce
adjudication.
ಮಾಡಿದ್ದೀರಾ?
ಹೌದು, produce ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದಾರಲ್ಲ, annexure B ಇದೆ. All annexures ಇದಾವೆ, D ಇದೆ. ಇದಾವೆ. ಅಂದ್ರೆ ಅವ್ನ ಸರಿಯಾಗಿ ಬರ್ಲಿಕ್ಕೆ ಇತ್ತು. Annexure A ಮಾಡಿದಾರಲ್ಲ.
Annexure A is the impugned order.
Accepting submission of counsel for the petitioner, office objections are held as substantially complied with.
It may be posted for preliminary hearing. my lord.
Preliminary hearing ಗೆ ತಳಿ ಬರ್ಕೊಳ್ಳಿ. Learned issue emergent notice. Learned AG is requested to accept notice for respondents 2 and 3. Emergent notice to first respondent.
Please, madam.
Okay. Yes, Mr. Babu Rao.
Lord, I have complied the only translation, annexure A3, my lord, that is not that much relevant.
Translation dispensed with. Yes, brother.
And my lord, the matter pertains to refixation and recovery, my lord.
Refixation of pay scale and recovery.
Recovery.
Ah.
94, my lord, the petitioner was appointed as the JTO.
Refixation or impugned order of the
Annexure A6. sir.
A6.
A6.
So 19 to 2022.
House.
ಏನಂತ ಹೇಳ್ತಾರ?
Now they have issued one more order, one more letter
Ah.
to implement this thing. So far, they have not implemented, they have not started recovery. Now,
ರಿಕವರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ಲ.
ಇವಾಗ
ಯಾವ ಇದು ಕೇಡರ್ ಏನು ಇವ್ರದ್ದು?
JTO.
JTO.
Group C.
Group C.
Group C. And the judgments are very clear, my lord, lordships.
KR Singh ಸಾಹೇಬ್ರದ್ದು ಒಂದು ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು? 2013 14 14
And State of Punjab versus Rafiq Masi ಒಂದು.
ಮಾಸಿ
And
ಮಾಸಿ ಕೇಸ್.
Thomas Daniel.
ರಫೀಕ್ ಮಾಸಿ ಕವರ್ ಆಗಲ್ವಾ?
ಸಿಗೆ ರಿಕವರ್ ಮಾಡಕ್ಕೆ
ಬರಲ್ಲ. ಇವರೆಲ್ಲ ಸೀನಾ?
C.
ಮುಗಿದು ಹೋಯ್ತು, ಮತ್ತೆ ಯಾಕೆ ಮಾಡ್ತೀವಿ? Why that the tribunal did not grant you relief? What is the reasoning of the tribunal?
The reference, my lord, in that order, they have quoted 2012 notification, which this honorable court has set aside. And this applicant, my lord, admittedly, they have not approached in time. So on that ground, only alone delay. Mele, idu ಮಾಡಿ.
Covered by Rafiq
Covered by
Masi.
decision. There are 3 judgments, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ I take notice and
Learned AG issue emergent notice. Learned AG is requested to accept notice for all the respondents. Stay off any recovery pursuant to order that was challenged before the KET. Yeah, till next date of hearing, call in the second week of June. Yes. This interim protection is granted, keeping in view the decision of Apex Court in Rafiq Masi, State of Punjab versus Rafiq Masi.
And
Citation.
Thomas Daniel.
Yes. Citation code. ಬರ್ಕೊಡ್ಬೇಕು.
This.
Next.
There are 2 judgments.
Yes.
Appear in this.
Ah.
This IA
Ah.
also would have memo not.
Nimma, you are not audible to us.
Lords,
Ah.
Lords, in extreme urgency, I had to move this IM along. The matter pertains to staff nurses who have worked. for
Why
a-
all they come here magistrate court ಮುಂದೆ ಎಲ್ಲರೂ
ಇಲ್ಲ.
ಅಪಿಯರ್ ಆಗ್ಲೇಬೇಕು ಅಂತ ಕಾನೂನು ಇದೆ,
ಅವ್ರು-
ಯಾರು ಹೋಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ.
BW ಇಶ್ಯೂ ಆಗೋವರೆಗೆ.
They are outside my office because they've lost the job.
ಕರೆಕ್ಟ್, ಇಲ್ಲಿ ಯಾಕೆ ಬರ್ತಾರೆ? ನಿಮ್ಗೆ ನಂಬಿಕೆ ಇಲ್ವಾ?
I have no control. They think
ಎಷ್ಟು
that,
ತ್ರಾಸ ಆಗ್ತದೆ?
they perhaps think that the lawyer is not doing the job. I'll just mention,
ನಿಮ್ಮನ್ನ ಕಿತ್ತು ಹಾಕು ಅಂತ ಹೇಳಿ ಅವರಿಗೆ.
I'll just mention the facts. Lords. I really didn't have anything to do here. They have come. I just-
ಬೇಸಿಗೆ ದಿವಸ ಇರ್ತದೆ, ಎಲ್ಲ ಹೆಣ್ಮಕ್ಳು ಎಲ್ಲ ಬಸ್ನಾಗ
ಇಲ್ಲ, ಅವ್ರಿಗೆ-
ನಾವೇನು ಅವ್ರು ನೋಡಿ ಕೈ ಮುಗಿತಾರೆ ನೋಡ್ಕೊಂಡು ನಾವೇನು ಅವ್ರ ಪರವಾಗಿ ಆರ್ಡರ್ ಮಾಡ್ತೇವೆ.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ,
ಏನ್
ಇಲ್ಲ.
ಕಾನೂನು ಇರ್ತದೆ ಆ ಪ್ರಕಾರ
It
ಮಾಡ್ತೇವೆ.
is only according to law, and law is entirely on my side, my lords. I'll just place the law as it is, my lords. In fact, I don't know them personally as well. My lords, the matter pertains to staff nurses. The matter pertains to staff nurses. From 2006 onwards, they have been continuously working on a contractual basis, but against existing vacancies. Now, why they have not regularized all that is another aspect, my lords. I'm not going into that. Year on year, their extension of contract was happening. Even during the period of COVID, they are the hardest to work.
ಪಿಟಿಷನ್ ಕೊಡಿ.
Yesterday,
ಹಾಕ್ಯಾರ ಈಗ
ಅವ್ರನ್ನ ಏನ್ ಮಾಡಿದ್ದಾರೆ, in the last round in 2000, I'll just place some facts.
ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. ಸರ್ವಿಸ್ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಇಂದ ಬಂದಿರ್ತೀವಿ.
ಅಲ್ಲ 2017 ಅಲ್ಲಿ one round ಅಲ್ಲಿ there was an attempt to remove them by bringing in some special rules and freshly recruiting people. At that time, this honorable court gave protection and said that they cannot be disturbed. A contempt was also filed in respect to that. That contempt, separately, the state comes and files a
another writ petition and says that we cannot implement for some other reasons, and that contempt which was there was stayed. Now, because we have been pushing that, and the term ends on 31st of March, on 3rd of March 2025, this month, they have a communication between the Secretary of the Health and Family Welfare to the Commissioner of the Health and Family Welfare, saying that from next year onwards, all these people who are working in the state sector project, this can be converted into another project, NHM ಅಂತ ಒಂದು ಪ್ರಾಜೆಕ್ಟ್, NHM ಪ್ರಾಜೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಫ್ರೆಶ್ ಆಗಿ ಓಪನ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಮಾಡಿ. This is a clever ploy, may I state that, my lords, in a convoluted way of again ousting us because we had the gumption, according to the government, to challenge this in the earlier round and even file a contempt. Now, on 31st, my lords, they, despite the fact that no notice has been issued, may I mention one of the gravest cases of violation of natural justice in this, my lords. Recently, your lordship would recollect, may I place only one paragraph, my lords, just for the felicity of language in this, may I place this? A recent decision of our Honorable Apex Court in Jago versus Union of, I think it's State of
Where Apex Court,
Union
they
of
are
India
unable to
Blocks.
understand the
Only
language.
para 14, what it says is, of course, by and large, it is on the aspect of regularization. And it also loads the gig economy that has come in, where the state is also indulging in such a gig economy. Kindly see page 14 at para, I'm sorry, para 14 at page 40.
ಅಲ್ಲ ಈಗ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಅಂತ.
ಇವಾಗ ಏನಂದ್ರೆ that their protection of employment which is there, I have moved this honorable court because I want the stay of two communication which has been sent by the commissioner to the, as from the secretary to the commissioner and from the commissioner to the DHOs, saying that call in all these posts which they had occupied for 19 years, they are ousted, and that is converted into.
Ousting happened when?
Ousting has happened on, that order was passed by the by the secretary on 3rd of March, my lords. But communication to me has, none of us has come in hand even today. So that is where para 14 is clearly violated. Onde ಒಂದು ಚಿಕ್ಕ para ಅದು ಓದ್ಬಿಡ್ತೇನೆ so, because not on other aspects, only on 14 what the Honorable Supreme Court says. May I? Page 48. Ink page 40.
Yes. The claim.
The other next is on 14. The abrupt termination of the appellant services following dismissal of their original application before the tribunal was arbitrary. That is, the termination letters issued without prior notice or explanation violated fundamental principles of natural justice. It is a settled principle of law that even contractual employees are entitled to a fair hearing.
Given an opportunity of hearing, etc., etc.
Nothing is
Even
given.
Supreme
ಅಲ್ಲ,
Court
ಅದು
is-
that's the minimal legal point that I am presenting.
Understood.
ಇದರಲ್ಲಿ ಇವತ್ತಿನವರೆಗೂ ಬಂದಿಲ್ಲ.
Prayer is something else and the argument is for regularization. Prayer is
I am
their
not asking for
non-inclusion in the
regularization.
final select list.
Huh?
Their non-inclusion in the final select list in the recruitment of staff nurses was challenged, madam.
Not
Now they-
regularization.
Not regularization.
In fact, it's covered by judgment of this honorable court. Right? The coordinate bench of this honorable court have passed already an order wherein not the application which was under challenge, not the very set of persons approached this honorable court, my lord. They have this coordinate bench have already passed an order considering the claim of the respondents also. my lords.
ಏನಂತ ಆರ್ಡರ್ ಮಾಡಿ
No,
ಕೊಡಿ.
no. In fact, I have not fully presented. In the facts of my case,
What is your prayer?
my lord, the prayer is communication are one.
No, no, not that prayer. What was your prayer before the KAT?
My lords, the prayer before the KAT was in the, my lord, there are two rounds here. This is slightly convoluted facts, my lords. May I just present it? That's why your lordship's indulgence I see. In the first round of litigation, when I went challenging certain special rules through which I was going to be ousted through in 2017, I filed an application before the Honorable Tribunal. The tribunal held in my favor. Kindly see the tribunal's order is there. This is not the relevant order. This is connected. It may be related to staff nurse. But what concerns me is today's memo which I have given, in which
No, what was your prayer before the KAT?
My lords, the prayer before the KAT was
Yes, please.
that the non-inclusion of me in the final list
That is bad.
and giving of weightage is incorrect. So I went there and the Honorable Tribunal said that I am entitled to be considered and weightage also should be given to the fact that I have served for so many years. That was challenged by some other private respondents before this honorable court, saying that I could be ousted if they are continued in the list. This honorable court said, no, neither will they be ousted, that is us applicants, nor will these private respondents be ousted. The state was heard in the matter. The state presented the existing vacancies which I have presented here.
Where is your order? That order? Which
That order is in my memo which I have filed today, my lords. Kindly see. It starts from page 1. At the relevant page,
How long your clients have been working?
2006, my lords.
Since 2006?
2006,
Now they are ousted from service.
yesterday, my lords. Yesterday, not even with notice,
No, you have said that.
without notice. Only in the communication between the
You have
government.
said that about 3 times you
Please,
repeated.
please. I'm so sorry.
The officer informs me that no such step has been taken.
They are not terminated. Then we'll
They are
record that.
continuing, during the pendency of this case, they have not been. Whether
Then if that is the
those who
case,
are working under the national scheme, they have to be given service weightage or not?
No,
Because
that,
service
I'm
weightage was
very
given
sorry.
only to,
Now,
Please.
during this summer, are you asking them to go home or not is the question? Who is your officer? What is his designation? Name
but he
designation.
categorically says no such step is being taken.
let me do.
Learned counsel, Shri Nitin Ramesh, appearing for respondent employees,
Respondent.
submits that with effect from there is some communication, intra-departmental communication that suggests most possible termination of service of his client when matters are pending, and therefore some protection needs to be afforded. First off, in support of this, he has produced certain documents or orders through a memo. First off, learned AGA
Application.
appearing for the ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರ ನೀವು ಮೆಮೊ ಗಿಮೊ ಈ ರೀತಿ ಪಾಸ್ ಆನ್ ಮಾಡೋದು ನಾವು ಯಾಕೆ ಒಪ್ಪಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರಲ್ಲ ನೀವು ಅದಕ್ಕೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ
ಅಲ್ಲ ನಾವು IAL that is the main argument.
ನೀವು ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್ ಅಸ್ ಟು ಸಿ ದೇ ಶುಡ್ ಸಿ
Please.
ಸಿಂಪಲ್
No, they are challenging the very
learned
fact.
AGA appearing for the state and its functionaries submit that
Instructions.
on instructions of Mr. So and so personally present before the court submits that there is no question of terminating the services of these respondents till after the matter during the pendency of the writ petition. During the pendency of the writ petition. First, therefore, the apprehension of the private respondents is misplaced. First, call these matters in the second week of June 2025. Mugdev.
Let's may one short fact. Lords. The fact is when they go and go for continuation, they have been told we'll be giving you relieving.
It hardly needs to be stated that the said employee shall be continued in service during the pendency till next date of hearing.
So grateful. So good.
With the same terms and conditions as were obtaining earlier. ಎಲ್ಲರನ್ನ ತೊಳಿ ಕೆಲಸ ಮಾಡಿಸಿ ಮನೆ ಕಳಿಸಿರಿ ಎಲ್ಲರನ್ನ ಯಾರು ಬೇಕು ಅವ್ರು ಬದುಕೋದು ಬೇಡ ದಟ್
6.2, filed my wakalat.
ಏನು
6.2.
ಶ್ರೀ ಸೊ ಅಂಡ್ ಸೊ ಅಪಿಯರ್ಸ್ ಪರ್ಸನ್ ಯಾಕೆಲ್ಲ ಬರ್ತೀರಿ ನಿಮ್ ಲಾಯರ್ ಎಲ್ಲ ಇಲ್ಲಿ ಮಾಡೋ ಕೆಲಸ ಸುಳ್ಳೆ ಎಲ್ಲ ಈಗ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಗೇನೋ ಕನಸು ಬಿತ್ತು ಬಂದ್ರಿ ಕೋರ್ಟಿಗೆ ಹೋಗಿ ಕೆಲಸ ಮಾಡಿ ಈಗ ಕೆಲಸ ಮಾಡಕ್ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ ನಿಮ್ ತಗೋಬೇಕು ಅಂತ ಹೋಗಿ ಕೊಡ್ರಿ ಕೆಲಸ ಮಾಡಿಸ್ರಿ ಅವ್ರ ಕೈಯಿಂದ ಫ್ರೆಶ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಮೇಲೆ ನೋಡಂತ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟು ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಪ್ಲೀಸ್.
My lord, I appear for the petitioner, my lord. Case of premature transfer, my lord.
In writ petition number
Well-
195/2025, I undertake to file wakalat in behalf of the respondent number 4.
Balraj,
I appear for the,
you appear for whom?
Respondent number 4 in the writ
Premature transfer.
please, my lord.
Post in. What is the post?
My lord, post is of sub-inspector of police, my lord.
Sub-inspector,
my lord, on 1/8/2023,
when he reported for the duty, particular portionally,
1/8/2023, my lord.
retention period ಏನು?
2 years, my lord.
Court tribunal ಯಾಕೆ ಇದು ಮಾಡ್ಲಿಲ್ಲ?
Tribunal says, my lord, earlier, my lord, in one of the contesting respondent, for her, from my place, she was transferred to some other place, my lord, without posting. And to her place, my lord, I was posted. She has challenged the, by filing an application before the KT, my lord.
ಅವ್ರದ್ದು premature ಇತ್ತು.
ಅವ್ರದ್ದು premature ಇತ್ತು.
I had challenged.
ಆಮೇಲೆ ಅವ್ರದ್ದು
Had appeared.
I had challenged.
ಅವ್ರದ್ದು premature ಇತ್ತು. Since, my lord, I have also not approached the KT in time, my lord, along with that applicant. So, my lord, the court say, the tribunal says that relief cannot be granted. That is the reason, my lord. That is the reason given by the KT, my lord. Kindly see, my lord.
Yes, government advocate. ಒಬ್ರು ಪ್ರಿಮ್ಯಾಚೂರ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದಾಗೆ ಇನ್ನೊಬ್ರು ಪ್ರಿಮ್ಯಾಚೂರ್, ಇದು ಒಂದು ಕ್ಯಾಸ್ಕೇಡಿಂಗ್ ಇಫೆಕ್ಟ್ ಇದು. ಏನ್ ಮಾಡ್ತೀರಿ ಈಗ?
Lord, I'll get instructions in this matter. Matter is listed for the first time.
ಇಲ್ಲ, second time, earlier notice ಆಗಿದೆ.
ಆಗಿದೆ ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ.
Lord, I'll get instructions in this.
ಅಲ್ಲ, ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ R4. ಇನ್ನು I have filed the ವಕಾಲತ್ respondent number 4.
ಗೌರ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು ನಿಮ್ದೇನು, ನೀವೇನು
ಇಲ್ಲ, I have
ಟ್ರಾನ್ಸ್ಫರ್ಡ್
completed-
ಎಂಪ್ಲಾಯೀಸ್.
I have completed in my tenure in the earlier place.
ಯಾವ ಕಂಪ್ಲೀಟೆಡ್ ಯುವರ್
Completed,
ಟೆನ್ಯೂರ್.
yes. Completed tenure.
ಹಂಗಾಗಿ ನೀವು ಬೇರೆ ಕಡೆ ಹೋಗ್ಬೇಕು.
ಹೌದು, ಅವ್ರ ಪ್ಲೇಸ್ಗೆ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರ ಪ್ಲೇಸ್ಗೆ ಹಾಕಿ ಮತ್ತೆ ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
My tenure was completed in
ಅದು ಅವ್ರೇ ಮಾಡಿ, ನಮ್ಗೆ ಅವ್ರದ್ದು ಸಂಬಂಧ. ನಿಮ್ದು ಟೆನ್ಯೂರ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು ಅಂದ್ರೆ ರೈಟ್ ಹುಟ್ಟಲ್ಲ. ಅವ್ರನ್ನ ಕಟ್ ಶಾರ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ. He has right not to be transferred during the retention.
transfer within 3 kilometers.
May I make one
Once-
submission?
The guidelines which are held to have the statutory force, they give right not to be transferred during the retention period. Guidelines do not say, though the retention period is over, they have right to get transferred elsewhere. No such thing.
Lord, may I make one submission?
Ah.
Challenge to the transfer order without reporting for the duty when there was no interest.
ಎಷ್ಟು ದಿವಸ ರಿಪೋರ್ಟ್ ಮಾಡಿರ್ಲಿಲ್ಲ?
3 ತಿಂಗಳು.
3 ತಿಂಗಳು. ಯಾಕೆ ರಿಪೋರ್ಟ್ ಮಾಡಿರಲಿಲ್ಲ?
As per document
ಅಲ್ಲಿ
it said-
ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ KET has said he has reported for duty, application is dismissed ಅಂತ ಒಂದು ಡಜನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದಾವೆ ಈಗ.
That is,
ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆ. ಸ್ಟೇ ಆಫ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಆಫ್ ದ ಪಿಟಿಷನರ್.
my lords, then I am working since October.
They maybe.
My application is allowed where he has not contested.
Sorry, we requires consideration. Yeah, he would not have,
My lords, what happened? I will-
unless he reports for duty, he should not be permitted.
I'll-
He is one view.
My lords, I will tell what happened.
Ah.
I was there in Hassan Traffic 2. He was there in Hassan Traffic 1. This person was there in Hassan Traffic Rural. My lords, I was prematurely disturbed. She was posted to my place. I challenged. Meanwhile, there was no, for me, there was no posting and also premature. That came to be allowed. And in the meanwhile, my lords, because he was posted to his place, my application was allowed. I was allowed, interim order was also there. And my lords, I was told to continue in Hassan Traffic 2. And my lords, he was,
ನಿಮ್ದು ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
ನಂದು ಸೇಮ್ ಆರ್ಡರ್ 1 ವರ್ಷನೇ.
ಅದೇ ಆರ್ಡರ್ ನಿಂದನೇ ಮಾಡಿ.
So he has to go to Hassan Traffic 1, not 2. ಈಗ ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ ಸ್ಟೇ ಅಂದ್ಬಿಟ್ರೆ ನನ್ ಮತ್ತೆ ಹಾಸನ್ ಟ್ರಾಫಿಕ್ 2 ಬರ್ತಾರೆ. ಹಾಸನ್ ಟ್ರಾಫಿಕ್ 1 ಅವ್ರು ಹೋಗ್ಬೇಕು, ಹಾಸನ್ ಟ್ರಾಫಿಕ್ ರೂರಲ್ ಗೆ ಇವ್ರು ಹೋಗ್ಬೇಕು.
ಎಷ್ಟು ದೂರ ಇದಾವೆ ಎರಡು ಪೊಲೀಸ್?
3
ಕಿಲೋಮೀಟರ್. 3 ಕಿಲೋಮೀಟರ್. ಯಾಕೆ ಅಷ್ಟು ಪ್ರಾಫಿಟ್ ಇದೆ ಅಲ್ಲಿ?
Because my transfer my lord on the basis of
ನಿಮ್ದು ಬಿಡಿ, ನಿಮ್ದು ಎಂತದ್ರಿ? ನಿಮ್ದು ಅವ್ರಿಬ್ರು ನಡುವೆ ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಕಾಣ್ತದೆ ಅಷ್ಟೇ. Why you so much particular about particular police station? Same place.
It is not so much, but I have continued through.
It's all right. Another 3 kilometers. ಮನೆಯಿಂದ ಕ್ವಾರ್ಟರ್ಸ್ ಎಲ್ಲಿದಾವೆ? ಇಬ್ರದ್ದು ಒಂದೇ ಕಡೆ ಕ್ವಾರ್ಟರ್, ಸೇಮ್ ಕ್ವಾರ್ಟರ್ಸ್.
ರಿಟೈರ್ ಆಗ್ಲಕ್ಕ 8 ತಿಂಗಳಿದೆ.
ಯಾರು ನಿಮ್ದಾ?
ನನಗೆ 1 ವರ್ಷ ಇದೆ ರಿಟೈರ್ ಆಗ.
ನಿಮ್ಗೆ 1 ವರ್ಷ ಇದೆ. ಜಸ್ಟ್ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಕ್ವಶನ್ಸ್ ಅಪ್ಪ ಇವು. ಏನ್ ಮಾಡ್ತೀರಿ? ಎಷ್ಟು ಸಮಸ್ಯೆ ಮಾಡ್ತೀರಲ್ರಿ? ಒಂದೇ ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ಬೇಕು, ಅಲ್ಲಿ ಅವ್ರನ್ನ ಪ್ರೀ ಮ್ಯಾಚೂರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ, ಇವ್ರನ್ನ ಪ್ರೀ ಮ್ಯಾಚೂರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ, ಅವ್ರದ್ದು ಓವರ್ ಮ್ಯಾಚೂರ್ಡ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕು ಅಂತ ಅವ್ರು ಅಂತಾರೆ. ಹೆಂಗ್ ನಾವು ಕೆಲಸ ಮಾಡೋದು? ಈಗ ಹೇಳಿ, ಎಲ್ಲಿ ಕೊಡ್ತೀರಿ ಪೋಸ್ಟಿಂಗ್?
I'll find out what can be the appropriate solution in this matter.
Call tomorrow. Take it. Call tomorrow. ನಾಳೆ ಹೇಳ್ಬೇಕು. Day after.
Deeply.
Okay.
I'm appearing for respondent number 1, my lord.
Yes, brother.
I'm requesting for passover, my lord.
Passover.
Please, my lord.
ಈಗ ರಜೆ ಇಲ್ಲೆಲ್ಲ ಬಹಳ
Service is awaited on the
Huh?
Lokaayukta, my lord.
ಲೋಕಾಯುಕ್ತ.
And
Lokai-
Lokayukta is, it needs to be heard, although this writ is filed by the government, my lord. One of the grounds on which the tribunal has interfered with the order of penalty is that selective prosecution. Disciplinary
Selective
proceedings have
prosecution.
been held selectively against one of the members of the committee who is alleged to have selected the beneficiaries illegally for a scheme for giving 2 lakh rupees to unemployed educated youth to buy two taxis for tourism purpose. So,
Similar matters treat ಮಾಡಿದ್ವಲ್ಲ.
my lord, Rajit Singh's case,
Singh's case.
para 10, my lord, covers this issue, my lord. Therefore,
And it is a case of no evidence, my lords.
ನೋಡೋಣ.
not,
Await
certainly not
notice
a case
ಇದೆಯಲ್ಲ.
of no evidence, my lord.
Await notice ಇದೆ.
50%
ಯಾರು?
of pension is withheld, my lords. 50% of pension is withheld. I am retired in the year 2020, my lord.
ನೋಡೋಣ. ಅಂದ್ರೆ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್ ಹಾಕೊಂಡಂತ. Mallikarjun Reddy, KS. Accepts notice for all two. Okay. Interim order to continue. Call in third week of June. Okay. Yes.
Hearing for petition. This
Yes,
my lord,
question
office
in-
objection is the translated copies, my lords.
Dispensed it.
Kindly, my lords, inquiry, my lord, in serving the articles of charge.
Huh?
Serving the articles of charge,
ಏನ್ charge?
page, my lord, the 94, saying that my lord, in 2016, in the name of Katragatta Vasu, some Facebook postings were made, making some political statement or a political rivalry against the Prime Minister and a member of Parliament. That is the allegation, my lord. It's for the year 2016, my lord.
2016.
Yes, my lord.
ಎಲ್ಲಿದೆ?
Page 95, my lord. Articles of charge.
ಏನಂತ ಮತ್ತೀಗ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟ್ರು ಚೀಫ್ ಮಿನಿಸ್ಟ್ರು ಇವ್ರ ಮೇಲೆ ಜನರಿಗೆ ನಂಬಿಕೆ ಹೋಗಂಗ್ ನೀವೇನಾದ್ರೂ ಮಾತಾಡಿದ್ರೆ
ಹಂಗೇನಾದ್ರೂ ಒಂದು ವರ್ಡ್ ಅದ್ರಲ್ಲಿ ಇದ್ದು ಅಂದಿರ್ ಸ್ವಾಮಿ. ವರ್ಡ್ ನಾನು ಹೇಳಿದೀನಿ ಅಂತಾನೂ ಇಲ್ಲ, ಅದು ನಂದು ಅನ್ನೋದಕ್ಕೂ ಏನೂ ಇಲ್ಲ.
ಎಲ್ಲಿದೆ ಅದು?
Page 95, notes. Page 95, articles of charge. Mail read. ವಾಸುದೇವ್ KM ಉಪನ್ಯಾಸಕರು ಸರ್ಕಾರಿ ಪದವಿ
ರೆಲೆವೆಂಟಿ ಬನ್ನಿ.
ಸಂಸದರ ಸೋನ್ಸು ಅಪಮಾನವಾಗುವ ರೀತಿಯಲ್ಲಿ 14/12/2016, 1/12/2016, 5/9/2016, 3/9/2016.
ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಬಗ್ಗೆ ಅವಹೇಳನಕಾರಿ ಪೋಸ್ಟ್ ಅನ್ನು ನಿಮ್ಮ ಫೇಸ್ಬುಕ್ ಅಕೌಂಟ್ಗೆ ಹಾಕಿ ಸರ್ಕಾರಿ ನೌಕರರಾಗಿ ಒಬ್ಬ ಪ್ರಭಾರ ಪ್ರಾಂಶುಪಾಲರಾಗಿ ಅಶಿಸ್ತು ಪ್ರದರ್ಶನ ಮಾಡಿರುತ್ತೀರಿ.
Kindly, my lord,
ಏನಂತ ಹೇಳಿದ್ರಿ?
even that is also not spelled out even in the imputation of statement.
ಆಯ್ತು, ನಿಮ್
Imputation
ಪ್ರಕಾರ-
is
ನಿಮ್
reiteration.
ಪ್ರಕಾರ ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಏನಂತ ಐತಿ? ನಿಮ್ಮ
ನಾನು ಏನು ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ದಟ್ ನಂದಲ್ಲ, ಅದು ಫೇಸ್ಬುಕ್ ಅಕೌಂಟ್ ಅಂತ ಹೇಳಿ. Kindly, my lord, page 97, statement of imputation. As per rule 11 subclass rule 3, my lords, they have to give an information, my lord, exact the statement of allegation. This, my lord, reiteration of the allegation. There is nothing, my lord, spell out what exactly the statement, what statement I have given. Nothing, my lords. The reiterated the same paragraph.
ಏನಂತ ಇದೆ ಬ್ರದರ್? ಏನು ಅಲ್ಲಿ ಏನ್ ಮಾತಾಡ? ಯಾರು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಮೇಲೆ ಯಾರು ಮಾತಾಡಬಾರ್ದು? ಹೆಂಗ್ ಏನೋ ಒಂದ್ ಇರ್ತದಪ್ಪ. ದಿಸ್ ಯಾರು ಯಾರು ಬರ್ನಾರ್ಡ್ ಶಾ ಈ ಸೈಡ್ ಇಂಗ್ಲೆಂಡಿನ ಪಾರ್ಲಿಮೆಂಟಿನ ಅರ್ಧದಷ್ಟು ಎಂಪಿಗಳು ಕತ್ತೆಗಳು ಅಂತ ಹೇಳ್ಬಿಟ್ರು.
being a government employee, it would
ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಹೌಸ್ ಇಶ್ಯೂ ಆಯ್ತು. He came and said, no, I withdraw my statement. ಅರ್ಧದಷ್ಟು ಜನರು ಕತ್ತೆಗಳಲ್ಲ ಅಂತ ವಿಡ್ರಾ ಮಾಡಿ. Do you mean to say we should not comment, criticize our ministers, our prime minister, our chief minister, our other ministers, our MPs, MLAs, MLCs, our elected members of the local government?
My lord, being an employee of the government, my lord, it would violate the conduct rules.
ಏನಂತ?
My lord, page 34, the allegations are extracted, my lord. 34.
Lines. Page 95, the articles of charge.
No, in the judgment impugned order, it is extracted. The Vasudeva KM,
ಎಲ್ಲಿದೆ?
page 34, my lord.
34. So and so. ಶ್ರೀ ನೀವು ನಮ್ಮ ಮಾನ್ಯ ಪ್ರಧಾನ
ಆರೋಪ 1, my lord. ವಸುದೇವ ಕಾಲೇಜ್ ಜಿಲ್ಲೆ, ನೀವು ನಮ್ಮ ಮಾನ್ಯ ಪ್ರಧಾನಮಂತ್ರಿಗಳಾದ ನರೇಂದ್ರ ಮೋದಿ.
ಇರ್ಲಿ, ಆಲ್ ರೈಟ್. ಎಲ್ಲಿದೆ? ಏನಂತ ಹೇಳಿದ್ದಾರೆ? ಅವಹೇಳನಕಾರಿ ಪೋಸ್ಟ್ ಅಂದ್ರೆ ಏನು? ಎಲ್ಲಿದೆ? ಅದು ಏನು ಅಂತ ಬೇಕಲ್ಲ. ಈಗ ಎಲ್ಲರ ಮೇಲೂ ಅವಹೇಳನ ಇದೆ ಈಗ. ಯಾವ ಮಿನಿಸ್ಟರ್ಸು, ಜಡ್ಜಸ್ಸು, ಇವರು ಎಲ್ಲರ ಮೇಲೂ ಅವಹೇಳನಕಾರಿ ಅಂತದಿರುತ್ತಪ್ಪ. ಅವ್ರು ಹಂಗ್ ಮಾಡಿದಾಗ ಮತ್ತೆ ಅವಹೇಳನಕಾರಿ ಆಗೋದೇ ಅದು.
ನೋಟಿಸ್ ತಗೋತೀನಿ ಸ್ವಾಮಿ ಬಂದಿರೋದು.
ಏನಾರ ಬೇಕಲ್ಲ ಅಲ್ಲ. ವಾಟ್ ಈಸ್ ದಿ ಬೇಸಿಸ್? ಹಾಗಾದ್ರೆ ನಾವು ಯಾವ ರಾಜನ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಬಾರ್ದು.
As an employee, he would violate the conduct rules.
Rule. Let us read that. Whether employee on employment, whether one will shed all his fundamental rights at the gate of your employment premises. ಏನಂತ ಇದೆ ಮತ್ತೆ ಡೆಮೋಕ್ರೆಟಿಕ್ ಇನ್ಸ್ಟು ಹೆಲ್ದಿ ಡಿಬೇಟ್ ಆಗ್ಬೇಕು, ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಿದ್ರೆ ತಡ್ಕೊಳ್ಬೇಕು, ಹಿಂಗೆಲ್ಲ ಹೇಳಿದ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವ್ರು ಹೇಳಿದ್ದಾರೆ. ನಮ್ಗೆ ಅವ್ರೆಲ್ಲರ ಬಗ್ಗೆನೂ ಗೌರವ ಇದೆ. ಆದ್ರೆ ಸಿಟಿಜನ್ ಅವರನ್ನ ವೈ ಸಿಟಿಜನ್ ಶುಡ್ ನಾಟ್ ಕ್ರಿಟಿಸೈಸ್ ದೆಮ್ ಎಟ್ ಆಲ್ ಅನ್ನೋದಿದೆ ಅಲ್ಲ. ಹೌ ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ಜಸ್ಟಿಫೈ ದಟ್?
Only it applies to a government servant.
ನೋಡ್ರಿ ಯಾರು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಆಫ್ ಮಾಡಿ.
Rule 10 of the conduct rules. No government servant shall in any radio broadcast or in any document published in his own name or anonymously, pseudonymously, or in the name of any other person in any communication to the press or in any public utterance make any statement of fact or opinion, one which has the effect of an adverse criticism of any current or recent policy or action of the government of Karnataka, central government, or any other state government.
Correct.
Provided that nothing contained in this clause shall apply to bona fide.
ಯಾರಿಗೆ ಕ್ರಿಟಿಸಿಸಮ್ ಯಾರನ್ನ ಮಾಡಬಾರ್ದು ಅಂತಿದೆ? ಗವರ್ಮೆಂಟ್ ಅನ್ನು ಮಾಡಬಾರ್ದು ಅಂತ.
Government.
ಮಿನಿಸ್ಟ್ರಿ ಇಸ್ ನಾಟ್ ದಿ ಗವರ್ಮೆಂಟ್.
But also proviso creates an exception also, my lord. May I just further?
ಅದು exception
Which is in favor of them.
First he should fall into rule, then you can travel to exception. He does not fit into rule itself. Exception.
The allegation is also relating to election, my lord.
ಏನು?
ಪ್ರಸ್ತಾಪಿಸಿ ಮಾನ್ಯ ಲೋಕಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಬಗ್ಗೆ ಅವಹೇಳನ ಪೋಸ್ಟ್ ಅನ್ನು ನಿಮ್ಮ ಚುನಾವಣೆಯನ್ನು ಪ್ರಸ್ತಾಪಿಸಿ ನಡೆದ
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಸರ್ಕಾರವನ್ನ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಬಾರ್ದು, ಸರ್ಕಾರದ ಧೋರಣೆಗಳನ್ನ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಬಾರ್ದು. ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಬಿಕಾಸ್ ಗವರ್ಮೆಂಟ್ ಬಗ್ಗೆ ರೆಸ್ಪೆಕ್ಟ್ ಇರ್ಬೇಕಾಗ್ತದೆ. ಅದರ್ವೈಸ್ ನೋಬಡಿ ವಿಲ್ ಒಬೇ ಗವರ್ಮೆಂಟ್. ಇದೆಲ್ಲ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಮಂತ್ರಿಗಳನ್ನ ಕ್ರಿಟಿಸೈಸ್ ಮಾಡಬಾರ್ದು ಅನ್ನೋದೇ, ಮಂತ್ರಿಗಳೇ ಸರ್ಕಾರನ, ಹಂಗಾಗಲ್ಲ ಅದು. ಗವರ್ಮೆಂಟ್ ಈಸ್ ಡಿಫೈನ್ಡ್ ಅಂಡರ್ ದಿ ಜನರಲ್ ಕ್ಲಾಸಸ್ ಆಕ್ಟ್. Under General Clauses Act, government is defined. There is one case in our High Court where during emergency they said that's a reported case actually. Avaru ಏನು ಹೇಳಿದ್ರು ಅಂದ್ರೆ down Indira Gandhi. Therefore, that was challenged before this court. The division bench of this court said Indira Gandhi is not government. On that ground, relief was granted. There is a reported case. ಆ ರೀತಿ ಒಂದು ವಾಟ್ ಈಸ್ ದಟ್ ಹಿ ಹ್ಯಾಸ್ ಡನ್ ಎಲೆಕ್ಷನ್ ಅಂತಂದ್ರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
In reference to the election, he has made these allegations. The very first allegation,
ಯಾವುದು?
ಮೈಸೂರು ಜಿಲ್ಲೆಯಲ್ಲಿ ನಡೆದ
ಹೆಸರು ಯಾವುದು ತಗೋಬೇಡಿ.
MPMC ಚುನಾವಣೆಯನ್ನು ಪ್ರಸ್ತಾಪಿಸಿ ಮಾನ್ಯ ಲೋಕಸಭಾ ಸದಸ್ಯರ ಮತ್ತು ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಬಗ್ಗೆ ಅವಹೇಳನಕಾರಿ ಪೋಸ್ಟ್ಗಳನ್ನು ನಿಮ್ಮ ಪೋಸ್ಟ್ ಫೇಸ್ಬುಕ್ ಅಕೌಂಟ್ಗೆ ಹಾಕಿ ಸರ್ಕಾರಿ ನೌಕರಿಗೆ ಒಬ್ಬ ಪ್ರಭಾರ ಪ್ರಾಂಶುಪಾಲರಾಗಿ ಅಶಿಸ್ತು ಪ್ರದರ್ಶನ ಮಾಡಿರುತ್ತೀರಿ. ಇದು ಕಾಂಡಕ್ಟ್ ರೂಲ್ಸ್ ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ ಬರ್ತದೆ.
ಎಲ್ಲಿದೆ ಅದು? ಕೇಸ್ 34.
34, madam. There are 4 allegations, my lord.
Notice ತೊಳಿ.
Please.
Issue emergent notice. Learned AG is requested to accept notice for all the respondents.
All the
respondents.
All the
Did you have interim order at the hands of the tribunal?
No, my lords. Now, my lord, the inquiry, now they have issued notice, my lord. They
Started.
are called upon to Monday.
Inquiry, the intended inquiry shall go on short of drawing the inquiry report.
The same matter, my lords, on Thursday, motor vehicle inspectors, the
Ah.
lordship has already passed an order.
That petrol engine.
ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದೆ ಅವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ. Can I
ಅಲ್ಲಿ
just-
ಎರಡು ಪೋಸ್ಟ್ ನಾವು ಇದು ಮಾಡಿಬಿಟ್ಟಿವಿ.
ಮಾಡಿ ಆಗಿದೆ. That
ಬರ್ಬೇಕು.
same order maybe.
Issue emergent notice, Lieutenant AG is requested to accept notice for respond, official respond, private ಇದರ?
KPSC ಇದೆ.
Shri R3 M.R. Sinchana. Call this matter along with WP number,
ಕೊಟ್ಟಿದೆ.
signs, full stop. Since two vacancies are directed to be not filled in the companion case, comma, that will take care of interim relief column. Okay,
Translation.
translation dispensed.
Great.
Next.
This objection
Yes,
is
Naveen.
At page 12, your lordship.
Ah.
The managing director is before your lordship and he has not made the director as a party. Page 12, your lordship.
Managing director, you have made the party,
Also, I am the managing director of the
company.
Yes.
Ah.
The director is not made as a party because I am ready to pay the amount.
You are ready to pay the money.
Lordship, the dispute is, I
Ah.
collected 18 lakhs, my lordship, with assurance that means I will construct an apartment.
Ah.
Due to some reasons, my lordship, the project was not commenced.
Ah.
A complaint was filed.
Ah.
And for the recovery of rupees 18 lakhs.
What is the order now?
Lordship, order to pay the, lordship, 18 lakhs with interest, your lordship.
Are you ready to pay that now?
Lordship, page 18 for a moment, your lordship.
1/8.
This is the execution petition. Principal amount is 18 lakhs. Interest is 34 lakhs 56,000.
ಮತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಬರ್ತದೆ ಅದಕ್ಕೆ.
Like negotiation ನಡೀತಾ ಇದೆ. In the meanwhile, arrest warrant issue ಮಾಡಿದ್ದಾರೆ. I will
Correct
deposit,
ಮಾಡಿದ್ದಾರೆ.
deposit ಮಾಡ್ತೀನಿ sir.
Builder, you are a builder. You are not some Kallegowda or Ramegowda working in the farmland. You are a builder. You have taken money.
Please,
You have to give back with
I will
interest.
give back your lordship.
good.
I need some time, your lordship. That is.
ಅಲ್ಲೇ ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ. What was your stand?
Lordship,
Stand ಇಲ್ಲಿ ನಿಮ್ಮ bonafide stand ಇದೆಯಾ? ತೋರಿಸಿ
Sir,
ನಿಮ್ಮ
I have
objection, ನಿಮ್ಮ
I have not filed objections.
not filed objection at all. Then it's worse.
That is the reason.
It's worse. You should have said, ನಾನು ತಗೊಂಡಿದ್ದೀನಿ ಮತ್ತೆ ಎಷ್ಟು ವರ್ಷ ನಡೀತು ಕೇಸ್? How long it went?
It is,
19 of 2020. 5 ವರ್ಷ ನಡೆದಿದೆ.
Need only time, your lordship. I will deposit.
Huh?
And I will deposit, your lordship. I request for a time.
ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
Entire amount of the need some time, your
What
lordship.
is your ನಿಮ್ದು ಫೈನಾನ್ಸ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ? ITR ಎಲ್ಲಿದೆ? Where have you stated? What is your financial status?
Sure, that I have not produced, your lordship.
Then we will not grant any relief to you.
Because, my lordship, I will.
Where is the question of hardship to the developer unless you plead that I have my business has failed, coercive proceedings are taken, my bank account is zero. Where are the the governments ಎಲ್ಲಿದೆ?
Project was not take off, my lordship, due to certain reasons. my lordship.
ಅಲ್ಲಿ ಕರೆಕ್ಟ್. ಈಗ ನಮ್ಗೆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೇಳಲಿಕ್ಕೆ
20 ನಲ್ಲಿ ಅದು ಕೋವಿಡ್ ಬಂದಿರೋದು.
ನಿಮ್ಮ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಲ್ಲಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನು ಕೇಳಿ, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ ಕೇಳಿ. ಅವ್ರ ಪರ್ಸನಲ್ ಅವ್ರದ್ದು, ಅವ್ರ ಮನೆಯವ್ರದ್ದು, ಮಕ್ಕಳದ್ದು ಮತ್ತು ಕಂಪನಿ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಅಂತ ತೋರಿಸಿ ಕೇಳಿ. ವಾಟ್ಸ್ಆಪ್ ನ ತರಿಸಿ. ಇಫ್ ಅಂದ್ರೆ ಏನಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡೋಣ. ಎಲ್ಲಾ ದುಡ್ಡು ಇಟ್ಕೊಂಡು ಬೇರೆಯವ್ರದ್ದು ಅವ್ರಿಗೆ ಸ್ಟೇ ಕೊಡು ಅಂದ್ರೆ ನಾವು ಕೊಡಲ್ಲ.
ಇಲ್ಲ, I am ready to deposit.
ಈಗ 25 immediately 38 ಇದೆ ಒಟ್ಟು.
Is your lordship.
38 lakh.
My lordship, total is 54 lakhs.
54 lakh.
Principal amount is 18 lakhs, your lordship.
ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್ ಅಂತ ಹೇಳ್ಬೇಡಿ ಅದನ್ನ. ಅಲ್ಲಲ್ಲ.
Interest part 30
ಇಂಟ್ರೆಸ್ಟ್
lakhs.
ಬರ್ತದೆ.
Interest
13
part,
years.
interest part 30 lakh ತಕ್ಷ ಬಂದಿದೆ. ಇಲ್ಲ, ಈಗ ನೆಗೋಷಿಯೇಷನ್ ನಡೀತಾ ಇದೆ. 40 lakhs ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ.
ಆಗ್ತದೆ. 40 lakhs ಇಲ್ಲಿ ಕೊಡಿ. ಮುಂದೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾತಾಡ್ಕೊಳ್ಳಿ.
5 lakhs ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ.
No wrong with the order.
My lordship, kindly.
Where have you pleaded? Equity ತೋರಿಸಿ. Where have you pleaded? Ojers pleadings ನಲ್ಲಿ.
I will agree.
ಏನ್ equity plead
Yes,
ಮಾಡಬೇಕು
I
ಅಂತ
will-
show that.
I will agree, my lordship. I have not appeared. My lordship, I have appeared, filed wakalat, but I have not contested.
ಮತ್ತೆ
My lordship, I am ready to deposit, my lordship, only seeking a time before your lordship. That is
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಿ?
seek on 5 lakhs deposit.
ಏನು ಉಪಯೋಗ? 5 lakhs. We'll dismiss the petition
Yes.
unless you are
I'm not sure. I'll leave it to you, lordship.
dismissed.
Lordship,
Nothing.
10 lakhs deposit.
25 lakhs ಪೇ ಮಾಡ್ತೀರಾ? ಇನ್ನಿಲ್ಲ.
Time ಬೇಕು sir.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ 10-10-5. To 1 week ನಲ್ಲಿ 10. Next week another 10. Following week 5.
Yeah, I pray for 2 weeks.
Issue emergent notice. stay of execution proceedings, including arrest warrant, subject to petitioner depositing a sum of rupees 20 lakh as under 10 lakh 2 weeks, 10 lakh 1 lakh 1 week, 10 lakhs 2 weeks, next one, 5 lakh 1 week, comma, failing which not only interim order stands rescinded, but writ petition itself will be dismissed with exemplary courts on that ground per se.
Office objection, so non-making is.
For the time being, office objections are kept in suspended animation.
Obliged.
Okay.
Here for petitioner's counsel.
Yes.
There is one office objection regarding translation, not
Dispense.
It is yet another case where, my lord, the petitioner is a DFO. Allegation is that he has made certain statement against chief minister. Therefore, he has been suspended, my lord, at annexure A1, my lord, page 25.
25.
Yes, my lord. Lord, the allegation is at page 26. Shivamogga ಅರಣ್ಯ ವೃತ್ತ ಪ್ರಾದೇಶಿಕ ಅರಣ್ಯ ವಿಭಾಗದ ಶಂಕರ ವಲಯದ ಕಸಬಾ ಹೋಬಳಿ ಅರಣ್ಯಾಧಿಕಾರಿ ನರೇಂದ್ರ ಕುಮಾರ್ ಇವರ ಆಡಿಯೋ ಸಂಭಾಷಣೆಯಲ್ಲಿ ಸನ್ಮಾನ್ಯ ರಾಜ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಹಾಗೂ ರಾಜ್ಯ ಶಾಸಕರಿಗೆ ಅಗೌರವ ಹಾಗೂ ಇತರ ವಿಷಯಗಳ ಕುರಿತು ಮಾತನಾಡಿರುವ ಬಗ್ಗೆ.
ಶಾಸಕರು ಬಿಡಿ, ಮುಖ್ಯಮಂತ್ರಿಗೆಲ್ಲ ನೀವು ಅಗೌರವ ತೋರಿಸಿದ್ರೆ ಏನ್ ನಮ್ದು ವಾಟ್ ಅವರ್ ಇಂಡಿಯನ್ ಏನ್ಷಿಯಂಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಲಾ ಸೇಸ್, ವಾಟ್ ರಾಮಜೋಯ್ಸ್ ಹ್ಯಾಸ್ ರಿಟನ್, ರಾಜಾಹ ಪ್ರತ್ಯಕ್ಷ ದೇವತಾಹ ಇನ್ Kallana's Raja Tarangini. He said the subject should believe that the king is that is king, that is the English doctrine also. King can do no wrong. What is that? Only God can do no wrong. If you speak ill of chief minister, tomorrow another person will speak of ill of prime minister. ಅವ ಹೆಂಗೆ ಗವರ್ಮೆಂಟ್ ಮಕ್ಕಳೆಲ್ಲ ನೋಡ್ತಿರ್ತಾರೆ ಮಾಡ್ತಿರ್ತಾರೆ.
My lord, there is a complaint, my lord. He filed, my lord, making allegation against 3-4 aspects. The other part, my lord, has been, my lord, exonerated. Not the show cause notice at page 2. Not I have given my explanation.
ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಮೇಲೆ ಏನಂತ ಹೇಳಿರಿ?
Chief minister ಮೇಲೆ
ರಾಜ್ಯದ ಮುಖ್ಯಮಂತ್ರಿ
ಏನ್ ಹೇಳಿದೀವಿ ಅಂತ ಇಲ್ಲ, ಆಡಿಯೋ ಸಂಭಾಷಣೆ ಇದೆ ಅಂತ my lord. The person alleged to have been
ತರಿಸ್ರಿ,
the person.
ನಾವು ನೋಡ್ತೀವಿ ಆಡಿಯೋ ಸಂಭಾಷಣೆ. ನಾಳೆ ತರಿಸ್ತೀರಾ? ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? ಈಗ ಒಂದು ಸಿಂಪಲ್ ನಾವು ಕೇಳಿಕತ್ತೀವಿ. ನೀವೆಲ್ಲ, do you know, you have read that Will Durant's story of philosophy? Why Socrates was given hemlock? We always praise Socrates. Socrates was given hemlock because he started preaching to the youngsters that what all government is doing is contrary to law. And you should not have respect for mortals. How government will run? Government runs because collectively we believe that government will do certain things for us. On that basis, that is the meaning of Raja Pratyaksha Devata. That is the meaning. ಈಗ ಆ ರೀತಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಮೇಲೆ ಏನಾರ ಮಾತಾಡೋದು, ಮಿನಿಸ್ಟರ್ಸ್ ಮೇಲೆ ಮಾತಾಡ್ತಾ ಇರೋದು, ಮೊದಲೇ ಈಗಿನ ದಿವಸದಲ್ಲಿ ಭಾಷೆ ಯಾರ್ದು ನಮ್ಮ ಕಡೆದು ಹಂಗಾಗಿದೆ. ಶುದ್ಧತೆ, ಒಂದು ಸೌಜನ್ಯ, ಇದೆಲ್ಲ ಕಳೆದು ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಇಲ್ಲಿ ಏನೋ
ಭಾಷೆ ವಿಜೃಂಭಿಸ್ತಾ ಇದೆ ಎಲ್ಲರ ನಾಲ್ಗೆ ಮೇಲ್ಗಡೆ, ಎಲ್ಲರದು ಬೈ ಅಂಡ್ ಲಾರ್ಜ್.
The allegation is that this conversation has taken place with one Fazluddin. The department has issued, my lord, 3-4 notices. They pasted notice to his door, my lord. But he has not turned back, my lord.
ಮತ್ತೆ ಮಾಡಿದ್ವಲ್ಲ ಕೇಸ್ನಲ್ಲಿ, ಕೊಡಿ ಆ ರೀತಿ ತಂದು ಕೊಡಿ. ಯಾವತ್ತರದು?
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
ಯಾಕೆ ಅಷ್ಟು ದಿವಸ? ಎಲ್ಲಿ ಇಂಗ್ಲೆಂಡ್ನಿಂದ ಬರ್ಬೇಕು? ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್, ಅದಕ್ಕೋಸ್ಕರ.
ಇರ್ಲಿ, ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದ್ದಾಗ ನೋಟಿಸ್ ಕೊಡ್ತೇವೆ. ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು?
He was in Shivamogga, my lord, posted working in Shivamogga.
Not Thursday. Not Thursday. Tira, gagging is also not good.
Can it be on Friday, my lord? Because
Friday?
Thursday there is another.
But Friday ನಮ್ಗೆ ಬೆಳಗ್ಗೆ. All right, Friday ತರಿಸಿ ಅಂತ ಅದೇನು ಮಾತಾಡ್ಯಾರ ನೋಡೋಣ.
Please.
ಹಿಂಗೆಲ್ಲ ಮುಖ್ಯಮಂತ್ರಿಗೆ, ಪ್ರಧಾನಮಂತ್ರಿಗಳಿಗೆ ಹಿಂಗೆಲ್ಲ ಮಾತಾಡಬಾರ್ದು. ಅದೇ ಇರಲಿ, respect. We don't know.
Yes,
we don't know.
My defense is, my lord, I have not spoken anything.
Let us see.
That is my defense.
All right, bring
and my
audio.
lord,
Please.
Bring
the
that
important
audio.
aspect is, my lord, the person with whom the conversation has taken place is the allegation. He has not supported, my lord, the version of the comment.
Next. 3-4 minutes. Victor. Yes. Ah, yes, brother.
My lord,
Yes, Balram.
this honorable court
Ah.
on 21/2025, my lord, has passed an order directing me to.
Court fee is not paid.
Court fee has been paid, my lord.
Paid.
It's paid.
You have paid it.
Paid.
ಮತ್ತೆ ಬೇರೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ
I'll undertake to comply it, my lord. I'll undertake to comply it. And this is an educational institution, my lord. And there is my appeal has been dismissed by the honorable DRIT because I did not comply the pre-deposit condition in full, my lord. I have come before this court and this honorable court on 21/2025, my lord, at page 63 has extended my payment time to make the payment, my lord. 63, my lord. My lord, in fact, on 17th of March, my lord, I was supposed to pay about 4 crore rupees, my lord, before the DRIT.
Yes.
I was ready with 1 crore rupees amount, my lord. I sought an extension of time for, as the paid.
Take out Dr. Vijay Mallya versus Bank of India, State Bank of India. That answers against you.
My lord, in fact, I'm completely agree that I'm not requesting the court to waive off my obligations to pre-deposit, my lord. My submission, my lord, is only to extend the time, my lord.
How much time?
I prayed, my lord, in fact, before 25th of this month, I'll pay 1.5 crores. And May 25th, I'll pay another 1.5 crores. I'm an education institution, about 1,050 students are studying. It is an
That's all
education
right.
time.
But how that the appeal becomes entertainable after compliance with the deposit, pre-deposit?
My lord, in fact, we file an appeal and.
Have you seen Dr. Vijay Mallya?
Yes, my lord.
You have not seen. Had you seen, you would not have argued like this.
My submission.
Take out ILR 2018-19. Myself and Maheshwari Saab, affirmed by the Supreme Court.
Yes, my lord. In fact, there is an obligation of mine.
You have not read that.
No, my lord, in
Don't
fact.
believe that you.
Proviso to section 18, my lord. It leaves with with a direct discretion of the learned chairperson of the DRIT, my lord.
Correct.
To impose either 50%.
Up to particular. Below that, no restriction no discretion at all.
Yes, my lord. I'm agreeable for payment of 25% deposit, my lord.
No, yes, payment part.
I have paid. Now I'm ready with 1 crore rupees deposit, my lord.
Just
With
put
the
back.
DD. I have to pay another 3 crore rupees, my
What
lord.
about it?
No, my lord. In fact, I can my collections only by 25th of April.
Where is
I'll
your bank account of the college? Give copy.
I'll furnish, my lord. In fact, and in fact,
we don't know. Where is the bank account of the last 1 year, the bank account?
it has not been produced, my lord, but I've produced the statement of how much I paid.
Tarsi, WhatsApp ne Tarsi. Go and bring. Password. ಆಮೇಲೆ ಅವ್ರ ಪರ್ಸನಲ್ ಯಾರು ಡೈರೆಕ್ಟರ್ಸ್ ಯಾರು ಇದ್ದಾರೆ ಅವ್ರ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಬೇಕು. ಓಕೆ.
14, my lord, the office objection is regarding translation and production of a Bear Act, my lord, which I am not relying on. But though matter is covered by your lordship's order and also the judgment of the Honorable Court regarding land grant, land grabbing.
What is this matter?
I will demonstrate how, my lord, the entire proceedings are abuse of process of court. There was a public action in respect of a property in Malleshwaram called Raja Mill. About 18 acres of land was put to public action in 2003.
Date, tell me the public.
The public action was 5/4/2003. That the National Textile Corporation property called Raja Mill was put to action on 5/4/2003 at page 65. The extent, my lord, which was put to action under the action notification is 18.69 acres. Then, my lord, 2 sale deeds were executed. 9/1/2000.
You are the auction buyer.
Yes. 9/1/2004 and 27/5/2004.
for the entire extent of property I purchased by paying the.
Two sale deeds.
Yes, madam. 9/1/2004 and 27/5/2004, about 21 years ago. Now occupancy certificate was issued. There, my lord, we constructed a mall called Mantri Mall, and occupancy certificate was issued on 11/2/2010.
Yes.
Then thereafter, my lord, for extraneous reasons, some proceedings were initiated by BBMP that you encroach the road, you encroach that, they started demolishing the property. This honorable court, my lord, the single judge of this honorable court held there is no encroachment, quashed every proceeding. Matter went before the division bench and also the honorable Supreme Court.
Where is that judgment?
But that your lordship get at, my lord, page number 97, the judgment of this honorable court dated 26th of June 2014, page number 97.
In respect of very same property?
Very same property.
Well, then that-
Kindly
that's
see the single judge's order quashes every notification, but I will only draw your lordship's attention to the division bench order, which renders a categorical finding at page number 153. 153.
53.
Yes, ma'am. The paragraph 5, my lord, the honorable single judge has found that there has been no encroachment upon discussions in detail of the issues raised. It is not possible in the.
It is not possible in the writ
Yes,
petition to
petition
decide the question of
encroachment.
encroachment.
Yes, yes, sir, certainly.
Huh.
No, I'm not just passing observation. That's all. I'm not relying on this order. Then the matter went to Supreme Court. Supreme Court also dismissed the SLP.
What the learned single judge said?
Single judge says, my lord, that the BBMP has come forward claiming this property, saying that the property of railways, property of the government, and property of the KDB is encroached. The single judge says the number one, BBMP has no power to initiate such proceedings. And even on merits, my lord, the sale deed holds valid and all that. I'm not heavily relying on these proceedings for the time being. The matter ended in 2018. When the SLP came to be dismissed in 2018, the SLP came to be dismissed. Now there is an interesting scenario.
1 second.
Yes, ma'am.
Kindly come to 145.
Yes, ma'am.
In the result, WP number is allowed in part.
Yes, ma'am.
Means what? And WP number so and so are allowed. Means what? Impugned orders, notices and joint committee report are quashed. What are they?
But they pertain to cancellation of kata and non-issuance of TDR renewal, etc.
But not encroachment.
Encroachment, the TDR was refused on the ground that I have encroached the road, certain portion was demolished. As a matter of fact, I have surrendered 5 acres of land free of cost to Metro because the Metro passes in between the building and 18,000 square feet was given
That's
to.
all right. But division
But I'm not
bench-
relying on for this for a moment. I'm not relying on this for a
Yes.
moment. Now, the interesting development takes place in 2017, just before the SLP. One corporator belonging to a political party raises an issue in the assembly of the corporation saying that Mantri developers have been involved in encroachment of land both in Malleshwaram as well as in Lalbagh Port. That was a press report. Based on the press report, the honorable revenue member of the Karnataka land the court prepared a note saying that there is a allegation against this one by corporator. Please investigate. A suo motu cognizance was taken by the land grabbing court.
Yes.
Then, my lord, the report was prepared. This is very interesting. The report was prepared by the BBMP on 14/3/2023, page number 163. But the entire gamut of the proceedings revolves around this report, which
14?
is 14th. My lord, this is dated 14th of March 2023, page number 163. I'll only read 2 paragraphs, my lord. How on the face of it, how your lordship got paragraph 4 at page number 163, my lord. The
To
land in
Registrar
question.
Karnataka Land Grab Prohibition
Yes,
Special Court.
this is the report on the basis of which my application is dismissed. Kindly see, my lord, paragraph 4, my lord.
Maharaja of Mysore.
Yes, Maharaja of Mysore granted 13 acres, 1 gunta. Then kindly see the next page. Next page, paragraph 5. Facts being so, the NTC, by publishing incorrect action, that is 20 years ago, in Prajavani Daily dated 5/4/2003, has sold 18 acres, 69 guntas in favor of Hamara Shelter. That is subsequently it become a monthly development. Bengaluru budget 2 sale deed dated 9/1/2004 and 27/5/2004 respectively. Said publication is produced B. Copy of the sale deeds are produced. Though NTC had no right to sell the property, however, it is incorrectly and without power sold the extent of land which was not at all in possession of such extent of land.
In fact, it had no right to alienate such extent of land. This they are saying after 20 years. Then, my lord, they rely on some village map and all that. Then, my lord, paragraph 12, page.
Yes, brother, what do you say? A public auction takes place.
Yes.
Auctional, he bought entire property.
My lord,
That was 18 years ago. And now you say, no, they have no power to sell it.
I am not
Public
claiming
auction.
a single.
yes,
inch
my
more
lord,
than
public
this.
action was taken place in respect of 18 acres of land, my lord.
Correct.
My lord, out of that, my lord, kindly see the paragraph number 6, my lord. In that, my lord, page number 164, my lord. It is noted here that out of the land held by the Mysore Spinning and Manufacturing Company, the land measuring 1 acre 23 guntas of sold to ITC land owner of Sampigate Takis under 2 sale deeds, even more than the land sold the third party.
Now,
to
one
the
second. What was the extent of land the Maharaja had granted to NTC?
13
That's the
acre.
main dispute, my lord.
They say 13 acre, 1 guntas.
13 acre,
1 gunta.
1 gunta.
No, this is not forthcoming. This document,
Where is that?
this document is not forthcoming because what is relied upon by the officer in para 5 is publication.
Where are your sale deeds?
Sale deeds are produced
Tell
at,
it.
I have produced the sale deed before your lordship, my lord,
Those-
page number 66 and 75. 66, page number 66 is the beginning. The schedule to the sale deed is at number page 73.
What is the extent?
Extent, my lord, here is 13 acres, 592 guntas,
13 acres.
13.592 acres, page 73. That is one sale deed.
One
And-
is 13 acres plus. Where, let us see the, say. this-
Second sale deed.
One
but,
second.
para 7, page-
13.592 acres.
Yes, ma'am. This
Means
is
13 acres, 592 gunta, it must be.
something like that. I do not know. because-
Otherwise 0.592 ಅಂತಂದ್ರೆ ಮತ್ತೆ ಅರ್ಧ 13.5 ಎಕರೆ ಮೇಲೆ ಆಗ್ತದೆ.
No, this is the extent shown in the public notice also, Prajavantinalli.
Ha,
The next
all right.
document, page number 83, is the schedule. The next
ಇನ್ನೊಂದು ಶೆಡ್ಯೂಲ್ ಯಾವುದು?
page number 83.
ಅದೆಷ್ಟಿದೆ?
ಅದರಲ್ಲಿ 5.098 acres. Together, it matches with the paper publication.
18 acres plus ಆಗ್ತದೆ.
Yes, paper publication at page number 65, that is 18.69 acres. So, in other words, 75,624.22 square meters. I am not claiming a single inch more than this. I have given
ಅವ್ರು
a-
ಏನ್ ಹೇಳ್ತಾರೆ ಇವರು 227 ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
227, they say there is a report. You have to prove how the report is wrong. Kindly see, my lord, it makes an interesting reading at page number 32 of the order. Relevant page is at number page 36. This is
Para-
suo motu proceedings.
Para 10,
Para
11.
Para 11. No,
On
on
the
the contrary, standing council so and so brought to notice, report filed by the Joint Commissioner BPMP West Zone dated 14/3/2020, that just now I read out. In the said report, it is specifically stated that Hamara Shelters accused number 1 so and so have encroached a huge property of BBMP and taking necessary steps for removing the encroachment. When there is encroachment alleged to have been made by accused number 1 and 2.
ಆ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ?
This is the one I read, that they rely on 20 years ago, the NTC sold extra land.
ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್.
Yes, the one just now I read, my lord, that is dated,
That itself.
yes, 14/3/2023 at annexure R, just now I read. This is the report the court relies on.
How, brother, how he is having sale deeds much before the act came into force. 2012 act came into force in 2014,
Yes, my lord.
August 2014. But these are all the 2004 sale deeds, public auction. How can you proceed against him? Where is the discussion by the 227 court?
This is for first time, my lord. I'll seek instructions and submit, my lord.
Issue emergent notice. Learned EGA is requested to accept notice for first respondent. Learned panel counsel Shri. ಯಾರಿದ್ದಾರೆ ಕೇವೇಟರ್? ಅವ್ರು ಬೇಕಲ್ಲ ಇಲ್ಲಿ. ಮೇಡಮ್ ಶಾಂತ. Counsel for the caveator respondent number 2 BBMP is absent. Absent. First. Learned senior advocate Mr. S. Basavaraj appearing for the petitioner draws our attention to two sale deeds dated 9/1/2004 and 27/5/2004, correct?
Yes, yes.
2004 together comprising about 18 acres plus land
6-9.
bought in a public auction held on 5/4/2003. And therefore, the encroachment proceedings, the subject proceedings, it cannot be maintained. First off, he also notifies to the court division bench, single judge bench judgment in so and so, holding that where the acquisition of title and possession precede the enactment 2012 Act, which came into force in 2014, comma, no proceedings can be undertaken by the special court. First up, matter requires deeper consideration, and therefore warrants issuance of interim protection. First, in the above circumstances, issue emergent notice. Learned AG is requested to accept notice for the first respondent. The second respondent is has entered caveat through her counsel, its counsel, who is absent when matter is taken up for consideration. First, issue interim order as prayed for till next date of hearing, call in the second week of June 2025.
Next matter 15.
Ah,
It's a classic case of comedy of errors. 9/2/2012, I purchased. 9/2/2012. I purchased 3 properties in Lalbagh Road, 69, 69/1 and 70. Total measurement was 1,18,896 square feet.
pade. $339, $227 scope ಏನೇನಿದೆ? What is the scope of 227 CRPC and 239?
It need not be a judgment on merits, no doubt about it. Prima facie, there should be investigation regarding the crime. Prima facie.
Discharge.
Discharge application.
At least application of mind. 9th of August 2012, I purchased about 1,18,896 square feet in Lalbagh Road. 3 properties, 69, 69/1, 70. Now it is 69. Now the number is 69. Now what has happened, Ballard, by mistake, page 103 may kindly be. Sale deed is produced at page number 27. The area is not in dispute. But after purchase, Millard, the kindly see page 103, Millard. Sale deed, Millard, I may bring to your lordship's notice the sale deed at page number 27. It speaks about 1,18,896 square feet.
This again auction.
No, it's a direct purchase. Direct purchase from the erstwhile owners who already put up constructions and all. Now I have put up about 175 apartments. Now 27 is the sale deed. Now what has happened, after the purchase, there was a mistake at page number 103, may kindly visit, 103. Instead of 118, because the measurements were actually not correct either in the sale deed or in the khata. In the khata certificate at page 103, in 2007,
Where is your sale deed?
yes, kindly see the sale deed at page number 27, Millard.
27.
Yes, ma'am.
What is the extent of land?
The extent of land mentioned in the sale deed is 1,18,896 square feet. Page 50 is the relevant portion.
50?
50, schedule. 1,18,896. There was some built-up area and all three sites were amalgamated subsequently, consisting of site measuring 1,18,896 square feet, together with the construction in the form of structure consisting of so and so, so and so, so and so. So it is 1,18,896 is the total built-up, total siteal area.
No, this is the sale deed by which you bought the property.
Yes, yes, yes. I
One
purchased
lakh
the property
eighteen
from the
thousand
SBL.
896 square feet.
Yes, with the built-up area.
Construction.
Yes, ma'am. From.
One
global
lakh
tech-
18,896 will be how many acres? 2 acres plus it will be.
Nagpur
43,000?
Nagpur 3 acres more than 3 acres.
ಹೆಂಗತ್ತೆ more than 1 ಲಕ್ಷ
40,000 square feet.
43 43,000 odd. ಎಷ್ಟಾಗ್ತದೆ? ಎಷ್ಟು
3 ಎಷ್ಟಾಯ್ತು?
3 ಎಕರೆ.
9.
2 ಎಕರೆ ಚಿಲ್ಲರೆ ಬರುತ್ತೆ.
2 acres
2,000 ಅಡಿ ಕಡಿಮೆ 3 ಎಕರೆಗೆ.
Almost
1089 into 12, 40.
that. By the time I constructed, there was already construction.
Now what happened?
Now kindly see page 103, Miller. After I purchased the property, before I purchased the property on 9/2/2012. By mistake, the khata of these 3 sites were shown as 1,13,784. That your lordship get at page number 103.
1 lakh?
1,13,784.
So 5,000 you will be buying in
This was
excess.
rectified by the corporation itself. The last documents may kindly be seen.
Corporation gave the sale deed.
Yes, yes. Corporation made the corrections in the documents. Kindly similar the last
No,
page of.
the 3 property numbers are mentioned.
Yes,
Come,
yes.
Please come to page 50.
50, yes,
69, 69.1 and 70.
Now it is amalgamated to 69.
All right.
Yes,
What is the extent of each of these sites?
yes, ma'am. That your
Tell us.
lordship get page number 27.
Each site will measure how much?
Lord, I will read this case schedule itself. No?
Huh.
All that piece and parcel of the property available in the 4 boundaries detailed below and earlier bearing number 69, 69/1 and.
No,
70.
those sale deeds ಕೊಡ್ಬೇಕು. ಅವುಗಳದ್ದು ಇದನ್ನ ಕೊಡ್ಬೇಕು. ಅವುಗಳ extent ಕೊಡ್ಬೇಕು. Then you will be able to know. Otherwise, Memo debt code and habitat comes to you.
ಇದೊಂದು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಡ್ತೀನಿ. This 118,000 ಇದ್ದಿದ್ದನ್ನ by mistake it became
113 ಮಾಡಿದ್ರು.
Now it is rectified.
ಅದಾದ್ಮೇಲೆ 118
Kindly
ಮಾಡಿದ್ರು.
sir, last.
But we want to know 69, 69.1 and 670.
Yes, ma'am.
How much they measured? ಅಂತ ತೋರಿಸಿ.
They were already amalgamated into.
No, that's then we will come to
Yes,
calculation.
certainly.
It's a matter of
Correct,
computation.
correct. Lord, I will only draw page number 142. ಒಂದೇ ಒಂದು ನಿಮಿಷ. I will not take more than 20 seconds of your lordship.
140.
142. This order of the city survey has become final.
No, that will not give title to you.
No, certainly, my lord. But at least the area mentioned.
You mentioned,
Now,
you
instead
give
of.
the extent of each of the sites.
Yes, certainly,
You
certainly.
will know everything.
Now, this was rectified and the measurement shown,
Deed is not rectified. It is only. the
even assuming that.
official
my lord,
records are-
Yes, certainly. What I own,
You give the extent of
Page
each of
number,
the sites.
page number 35.
what I own at least now is 118,000. They rectification is to the extent of.
Depends upon
Yes, ma'am.
the aerial measurement of each of the sites.
Tomorrow it's.
Sorry.
Yes, ma'am.
Page number 35, my lord.
35.
35. Ali.
The property, second parameter. The property comes within the limits of Bruhat Bengaluru Mahanagarapalike was assigned with municipal number 69 and 69/1 as evident from the Kata certificate, Kata extract so and so, so and so. 69 indicates an area 1,19,000.
10,000.
Supports my case.
1,10,000, my lord.
ಯಾವ para?
1,10,000. Second parameter, 39.
55. Yeah.
1,10,000.
1,10,000.
And 69/1, 2,940 square feet.
ಎಷ್ಟಾಗತ್ತೆ ಕೂಡಿಸಿ ಎಲ್ಲ?
4th paragraph.
1,10,000. 1 lakh and 10 alone. 1 ಲಕ್ಷ 10 foot.
10,000.
10 foot.
10 ಅಡಿ.
ಹಾ.
ಆಮೇಲೆ 2,940 ಅಡಿ.
ಅದು ಯಾವ್ದು ಇನ್ನೊಂದ?
69/1.
70 include ಮಾಡಿಲ್ಲ. 70 include ಮಾಡಿದ್ದು next ಅಲ್ಲ next page, next para. The sellers made an application for amalgamation of the Kata 69/170 and by order dated amalgamation 2007, Bruhat Mahanagarapalike identified the total extent of 1,19,150.
70 ಬರೆಯೋದೇ ಇಲ್ಲ ಇವ್ರು ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್
70 ಇಲ್ಲಿ ಎಷ್ಟು ಅಂತ
70
ಗೊತ್ತಾಗಬೇಕಲ್ಲ? 70
ಬರೆದಿಲ್ಲ.
ನಾಳೆನೇ ಸೆಲ್ಡಿಡ್ ಹಾಕ್ಬಿಡ್ತೀನಿ.
ಕೊಡಿ.
ಸೆಲ್ಡಿಡ್ ನಾಳೆನೇ ಹಾಕ್ಬಿಡ್ತೀನಿ.
ನಾಳೆ ಕೊಡಿ. Learned senior advocate, Mr. Basuraj wants
Can it
to.
be taken up tomorrow is the appearance, that's what the problem.
ಏನಂದಿಸ್ತು ಇದು? ಅಪಿಯರ್ ಆಗಿ ಬನ್ನಿ, ಏನಾಗಲ್ಲ. ಅಪಿಯರ್ ಆಗ್ಬೇಕು.
ಅಥವಾ ಒಂದು exemption ಆದ್ರೂ ಹಾಕ್ತಿದ್ವಿ. It's a, as I said, it's a comedy of errors because
ಅದು ಏನಿಲ್ಲ. ಅವ್ರು ಏನೋ
no, the report, what happened?
ಇಂಪ್ರೆಷನ್ ಬರೋದು ಇದನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ ಎಲ್ಲೋ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದನ್ನ ಮಾಡಿದಾನೆ.
ಇಲ್ಲ, 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 ಇಲ್ಲ. I mean,
Anyway,
we have invested 100
give-
crore on
we
this
don't know.
property. Why should
We don't know. ನೀವು ಕೊಡಿ ನೋಡೋಣ.
The report says, no, the report relies on the earlier kata, which may wrongly mentions as 113. That is the only reason.
ತೋರ್ಸ್ಕೊಳ್ಳಿ. But 70 ದಲ್ಲಿದೆ ಮೆಜರ್ಮೆಂಟ್. He has pointed out. 70 ಮೆಜರ್ಮೆಂಟ್ ಇಲ್ಲ.
Certainly, we will
ಅದನ್ನ ಕೊಡಿ.
produce the
70
sale deed
measurement
itself.
ಕೊಡಿ.
Sale deed itself we will produce. So built up area we purchased.
ನೋಡೋಣ. 70 ಎಷ್ಟು ಅಂತ ಹೇಳ್ಕ. ಅಲ್ಲೂ ಆ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಬರೇ 69, 16.19,
But
17
each
ಇಷ್ಟು
sale
ಮುಗಿಸ್ಬಿಟ್ರಿ.
Each sale deed for all these three properties will produce.
But
And certainly, my lord, we should
very
produce.
good.
Tomorrow.
Amalgamation order.
ಅಮಲ್ಗಮೇಷನ್ ಆರ್ಡರ್ನು ಅಲ್ಲ. 70 ಕೊಡಿ.
Amalgamation
amalgamation
order which shows 1,19,000 actually. It is more than the sale deed
right.
itself.
Where the extent must have been.
Certainly, it
Ah,
is
sale
more
deed.
than the sale deed itself. Not, we have not encroached even an inch of land.
That's
Because
how, of course, you should say like that only. Can you say, no, my client, how can you say that? Judges, we are entitled to, going by our common sense, although it may be little low, but it is rebuttable also. What we say is rebuttable also. Because, yeah? Learned counsel on record, appearing for the petitioner on record to produce the sale deeds which comprised survey, site numbers 69,
69.1 and 70.
79.1 and 70. 70. And also the amalgamation order, whereby all these sites have been club, formed into one unit. One unit. All. Post this matter, when those copies are produced before the registry.
ಅಲ್ಲ, ನಾನು
ಕೊಡಿ ನಮ್ಗೆ ಯಾವತ್ತು ನೀವು ಯಾವತ್ತೇ
tomorrow itself,
ನೀವು ಕೊಟ್ಟರೆ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್
at least day after two.
day after two. All day after two. Non-production may result into heavy adverse inference being drawn against the petitioner. Next. Yes, Shamil sir.
Is a petition, my lords, filed by the Public Service Commission challenging an order passed by the tribunal. My lords, where the tribunal, the petition, recruitment pertains to Hindi teachers, postgraduate Hindi teachers in Navodaya schools under the Department of Minorities. So,
Will not be maintainable.
Why can't you allow him to speak? Kindly take your seat. We'll call you. We will not pass any adverse order against you. Be assured. Without hearing you, we will not pass any order. Kindly be seated. ಕೂತ್ಕೊಳ್ಳಿ, ಸಮಾಧಾನವಾಗಿ ಕೂತ್ಕೊಳ್ಳಿ.
Filing my objections, my lord.
Huh?
Why?
lords, respondent number 1 and 2, my lords, for the respondents number 1 and 2 for the applicants, my lords, in response to the notification.
They were applicants.
They were applicants, they had applied
Of
for the post of postgraduate Hindi teachers
PG Hindi teachers.
in Navodaya schools under the Directorate of Minorities.
Under the
Directorate of Minorities,
Okay.
under Department of Minorities. Now, my lords, the minimum qualification prescribed was a postgraduate qualification MA degree in Hindi.
PG MA.
Please, my lords. In Hindi. And my lords, a BA degree with teaching method in Hindi.
BA degree with the teaching method in Hindi.
Hindi.
Hang degree ಇದೆಯಾ?
Please, my lords, teaching methods, my lords. And in lords, since they did not possess the BA degrees,
B.Ed they did.
they had most postgraduate MA degree in Hindi.
Those who are having PG
Please, my lords.
in Hindi,
Please.
they need not have B.Ed. Can it
No,
be
no, it
used?
is both
The requirement is concurrent.
concurrent.
B.Ed.
Please, my lords.
What is that B.Ed?
My lords, B.Ed, B.Ed degree.
B.Ed.
B.Ed, Bachelor of Education.
Only B.Ed degree.
B.Ed degree with Hindi, with teaching method as Hindi. No, admittedly, they don't have BA degrees.
They don't have.
They don't have my lords. Their entire cases. So therefore, their names were not found in the final select list. They approached the tribunal, my lords. Tribunal, my lords, has directed us to consider their cases, my lords, on the premise that they possess equivalent qualifications, which are certificate courses, my lords, that have been issued.
Who equalized them?
There is no equivalence. The state government has not issued a section.
Who is the authority to equalize them?
My lords, under the general recruitment rules, it's the state government.
In general recruitment, it is state government.
It is the state government. Equivalent qualification is defined as qualification that has been declared as equivalent by the state government.
Which is that rule?
My lords, 2H, my lords, of the general recruitment rules.
GR Kodi. Equivalence declaration agilla.
Agilla. And in fact, my lords, there is a, in so far as one person's qualification is concerned, there is a declaration, my lords, that it is not equivalent.
There is already a declaration.
But it is in the context, my lords, of primary school teachers. The tribunal, my lords, there is also one more post that was notified. My lords, in respect of graduate Hindi teachers.
Not postgraduate Hindi.
Not postgraduate. There are two, in the same notification, we have postgraduate teachers, we have Hindi graduate teachers also. For Hindi graduate teachers, the recruitment rules provided for equivalent qualification. 2H, my lords.
By the government to be equivalent to a qualification prescribed in respect of any post in the rules violating recruitment to any state civil service. 2H. How tribunal?
Lords, tribunal actually, in respect of Hindi graduate teachers, there is, in the notification itself, there is a provision, my lords, for equivalence.
Notification itself.
And notification itself, there is a provision for equivalence in respect of graduate Hindi teachers, not postgraduate Hindi teachers. Illi notify madbekare, we have not said or equivalent qualification anta.
That equivalence is confined to only UG, graduate Hindi teachers.
Even there also equivalent qualifications are illa, but by considering that prescription, tribunal, my lords, fell in error, my lords. I'll just take, my lords, to the 2 pages. In fact, there is an interim order operating in our favor. A matter has to be heard, my lords. We are ready.
Yes, but here,
Lord, this petition is not maintainable.
Why?
For this reason. That, Lord, there is a coordinate bench of this court. Says this already dismissed this petition. I will give you a
Is it
short.
true?
My lords, the KPS's petition is, my lords, there is an interim order in the KPS's. Where the private respondents who were made parties, my lords, before the tribunal, where, my lords, no relief was granted, setting aside their appointments, they challenged that order. This honorable court, my lord, said that it is misconceived. No notice was issued to KPSC, and my lord has dismissed that.
No, your KPSC was a party to that.
KPSC was a party.
Part number 3.
Number 3.
Please, my
Were
lords.
they represented?
They were not represented. No notice at the admission stage itself, my lords. It was
Presented. Where is this? Show that.
They were not represented. My lord, I am for the private parties, my lord. I am producing the judgment. Along with my statement of objections to their vacating stay.
Do you still hold that they were represented?
No, my instruction is they were represented. I have
Can we
just
see the order? What your question of instruction will not arise when there is a matter of record.
There is no mention of their making observation.
They say that it was dismissed. It was not dismissed. It was dismissed.
The point is that under.
I have produced the judgment, your lord.
Daria versus UP, any judgment will serve as res judicata and.
Provided he is heard in the matter.
What I would then suggest, Lord, if he was not heard in the matter, then the right course for him would be to file an SMP. That's the only course of action, Lord, because Lord, Daria versus State of UP is very clear. Here they file a writ of certiorari, and that's the note which I am now reading to you.
I can just clarify.
The present petition. Present petition.
We have taken the view that where a party's name appears in the cause title, but no notice was ordered to him, then res judicata would not apply. We have taken that view. That view is affirmed by the Supreme Court.
But Lord, may I read the small? It's a short note. Besides this, there are several other issues. The present petition assails the order of the KAT dated 8/2/2023. A coordinate bench of this honorable court in WP number so and so has upheld the order of the tribunal with the present petitioner being party to the proceedings. Well, whether they are party or not is a different matter.
Why, if they are not parties?
Very well. Very well. Let's take it for granted that they are not. The petitioner KPSC chose not to contest the issues raised therein because my instruction is not that on every occasion, whenever a matter comes up, the PSC is represented. If-
See the order, whether notice was ordered to PSC at all. It's a question of record. That cannot be settled by argument.
These issues may be ignored from this court. The petitioner chose not to contest the issues raised herein before a coordinate bench of this honorable court and instead chose to file a writ petition afresh after the passage of nearly 8 months of the order of this honorable court in WP number so and so dated 33/2023. Neither has it been disclosed in the body of this petition that a coordinate bench of the High Court has already decided on this issue. Therefore, petitioners are guilty of suppression of material facts. The petitioners, by adopting this procedure, have contributed to multiplicity of proceedings and instead ought to have approached the Supreme Court under 136. Further, this petitioner suffers from lack of application of mind purely because it is not at all a fit case to issue a writ of certiorari. It is well established principle of law that the writ court can exercise its writ jurisdiction and grant a writ of certiorari only under limited circumstances. In matters of certiorari, a writ court sits in a supervisory jurisdiction of all the judicial forums below it. This honorable court can exercise this jurisdiction and issue a writ of certiorari in instances, inter-alia, where there is a want of jurisdiction. An error apparent to the face of record in the order passed by a judicial forum where principles of natural justice do not follow. The same has been held with the Honorable Supreme Court as follows. And this is AR 1967 SC 1450. It is true that the issue of the writ of certiorari is largely a matter of sound discretion. It is also true not be granted if there is such negligence or omission on the part of the applicant to assert this right as taken in conjunction with the lapse of time and other circumstances causes prejudice to the adverse party. The principle is to a great extent, though not identical, it's similar to the exercise of discretion of the Court of Chancery. On an examination of the authorities of this court as also of the courts in England, it was pointed out that one of the grounds on which the jurisdiction of the High Court on certiorari may be invoked is an error of law apparent on the face of the record and not every error, either of law or fact, which can be corrected by a superior court in exercise of its statutory power as a court of appeal or revision. It was also remarked that an order of certiorari was not meant to take the place of an appeal, and that its purpose was only to determine.
Requires consideration. We'll fix a date, that date.
It's not only that. In the finding in the earlier cases, the tribunal has not granted any relief, which is adverse to the interest of the petitioners. The parties, private parties who are made parties. In that way, we are of the considered opinion, writ petition is misconceived anta ಮಾಡ್ತಾರೆ.
Not
We are
only
arguing.
misconceived, they had suppressed the fact
Please.
of suffering an order earlier. That weighed with the court.
No,
That's
we
the-
have-
anyway, matter requires.
No, we had not suppressed anyone.
We, learned friend read that
Atla-
matter. We'll
My
fix a
learned
date.
friend's submission is the writ petition was dismissed. The Lordship may kindly say it was
Not
disposed of.
dismissed.
It was disposed of.
Brother, dismissed, disposed of, allowed,
No,
put to
the
rest.
Lordship may kindly say that.
Why can't you hear a judge also? You should permit the judge to argue.
Please.
AIR 1993 Karnataka Division Bench. Disposed of, dismissed, rejected, allowed. Those words should not be looked into. Justice Swami held like this. You should read whole judgment, then arrive at a conclusion. Not reading some words. Words are very, very slippery things. They take their color depending upon the company they keep it. Therefore, since you have not read that query given from my notes, let him read and come back. He is repeating that again and again. AR 1993 Karnataka.
My only problem, just to.
You have
is
said that we have.
I'm way ahead of his clients, way ahead in the list of.
No, short question, brother. On legal principles, what you said is correct.
But
The point is,
I've been kept out for 3 long years. That's my only.
so we'll fix a date.
Anyway.
2H gives power to the government to declare equivalence of qualification. That is done in respect of graduates, not postgraduate.
I will show that.
That's why,
I will show
that's
that. Even on merits, I will show.
all right. Which date will be convenient to you in June?
Any date of my
June,
lordship.
indeed.
Any-
Second week of June 2025, interim order to continue.
Grateful.
Yes. Yes.
Chief's permission.
Ah.
I represent the petitioner.
Ah.
I filed an application
Ah.
to release the amount that was deposited by me, where I had deposited 30 lakhs subsequent to the order of this honorable court. My lords, the issue is, my lords, if I may submit,
Who has deposited
I have deposited subsequent to the order of past.
pursuant to court order?
Yes, yes, yes.
Now you want that money back?
No,
Huh?
I'm not saying that, my lords. I'm just, there was an agreement. There was an agreement of sale,
Agreement?
agreement of, of sale on 7th, agreement of sale.
No,
Is
agreement for sale. You're a
Sorry.
youngster.
agreement
For
for
senior, say whatever, read section 54
Yes.
of the Transfer of Property Act.
transfer of property. I stand corrected, my lord.
Yes.
Agreement for sale on 7th of June
But
20.
deed itself says that way, agreement for sale,
That's right.
pays the 30.
Yes,
There is difference.
yes.
Chitty on contracts, read standard books, not substandard books, chitty on contract. Cheshire, Fifoot and Firmston on contract.
Yes, ma'am.
There is Anson's contract, AG gets Anson's contract. Agreement to sell is one thing. Agreement for sale is equivalent to agreement to sell. Agreement of sale is not an executory agreement, but an executed one. This paragraph appears. They have many consequences, not just language. They have legal consequences because of 54 part 2.
Transfer of property.
That's the reason.
That's
Anyway.
yes, my lords. There was an agreement for sale on 7th of June 2010 between respondent number 1 and petitioner for sale of the scheduled property. And my lords, subsequently, the very same scheduled property in the year 2015 was alienated.
Now you have interim order now.
Now I have an interim order.
Interim order.
Yes, yes.
Because I filed an application. I am
For?
the decree holder for the release of the funds. Subsequently, when the matter was pending, pardon me. An appeal was filed before the National Commission 2, please, minutes, and that appeal is also dismissed. Now, minutes, the execution is stayed. I am a retired naval officer, minutes, and my entire life savings have been invested to purchase that flat. That flat, when there was an agreement with me, subsequently was sold to a third party, minutes. I went before the National State Commission, minutes, and I have a favorable order. Now, minutes, the order that is challenged
He's
here,
a naval officer.
retired naval officer.
Yes, brother, argue. Start. For soldiers, defense people, they are entitled to preferential treatment because they guard us.
Definitely.
The very risk of life.
Before-
Yes,
be-
read.
Before that,
Others need not wait. We are taking up this matter. Read.
yes,
Start.
before that, I have one submission, my lords. Only one this.
Ah.
I've already deposited 45 lakhs.
Yes.
That is the sale consideration amount. Well, it's 30 lakhs before this court,
Correct.
which they are seeking disbursement. Prior to that, he has received 15 lakhs.
Yes.
So whatever the amount that is liable to be paid as per agreement of sale is already paid. Now, my lords, with respect to the interest portion, what he's claiming in the execution petition
Yes.
is only required consideration before your lordships.
Why? You have no interest in abiding by the agreement.
No.
But you are interested in seeking waiver of interest in your favor. What kind of interest it is? You have no interest in abiding by the principle, pacta sunt servanda. What is agreed upon, we should abide by.
Yes, my lords.
And you want interest in your favor.
Only
Oh.
I'm only seeking indulgence before your lordships.
Where is the grounds for the naval officer,
Yes.
retired officer? You had undertaken to do all that.
Yes,
You
ma'am.
did not do it. You sold it to someone else. You lost the case in state commission.
Yes, ma'am.
You lost the case in national commission.
In-
And
in
what
the-
he
in the-
should do in the evening of his life.
Yes, sir. In the consumer forum, my lords, I was represented, but no statement was filed.
You lost before the national
Yes.
commission.
Yes, my lords.
Anyways,
And now the only, my lords, execution is filed.
that should be
Seeking-
executed.
Yes, my lord.
Nothing.
Agreement of sale, my lords, is 7th of June 2010. And my lords, I have insistently requested the, my lords, respondent number 1 for the registration of the sale deed.
Why did you sell that to some other person?
It has been, my lords.
Why?
It has been sold to some other person.
Why?
On the ground, my lords, he was not coming forward. Also, I admit, my lords, subsequently I have remitted back whatever the amount I had received. from-
He gave money to you,
Yes, my
not
lords.
for getting it back. He gave money
Absolutely.
because he wanted flat.
Absolutely, my lords.
Huh.
But he does not take any steps to come forward for the registration of the sale deed.
Why, but money was paid to you.
Money was paid to me.
Why did you sell it to other person? You had received the money.
Yes, my lords.
Yeah, equitable interest was created
Absolutely.
in his favor without conveyance.
Yes, my lords.
Then why did you sell that? It's a fraud. It's a fraud on the novel officer.
No, in fact.
And under the
Yes,
Transfer
my
of
lords.
Property Act,
Yes, my lords.
where entire consideration is paid, even in the absence of a sale deed, equitable interest is created
Yes,
in favor of the buyer.
yes.
Why you sold that? It's a fraud.
No,
Your client appears to be a cheat.
I'm sorry. my lords.
He is, because he sold his property having received the money
Subsequent, yes, my lords, my lords, I understand what your lordship
with
says.
cost of rupees 10 lakhs.
My lords, if I may submit, only 2 submissions.
Why can't you keep quiet when court is in your favor? Or
Pardon
you
me.
want to spoil the case?
Yes, please.
You want to spoil?
No, definitely.
Then be seated.
Yes, please.
There were
You
those-
have played fraud on the soldier of the country.
If I may submit, my lords, in the
We are asking simple question.
Yes, my lords.
We have adopted English law.
Yes,
English law of property we have adopted.
yes, my lords.
It says, English law says, where the buyer has remitted entire money, equitable estate is created in his favor, notwithstanding absence of a conveyance. We have adopted it. Supreme Court has adopted it. Then why did you sell that property to another person? For what consideration you sold it?
Sale deed at page 37, it was sold.
ಎಷ್ಟು amount? ಇವರಿಂದ ಎಷ್ಟು amount ತಗೊಂಡಿದ್ರಿ?
You're in the 44 lakhs 50,000.
44 lakh 50,000. As on which date?
This is on, as on 7th day of June 2010.
2010.
Yes. This
You
registered sale deed on
you
25th day of March 2015.
having received entire money, you sold it to another person.
Another,
That is dated, sale deed dated
25th day of March 2015.
25/6/2015.
25/3.
25/3.
3.
What is the sale price you have shown?
This is 46 lakhs.
46 lakh.
Yes, my lords.
Because he paid 1.5 lakh more than what this gentleman had paid. This is a guideline value,
Yes, my lords.
but there will be underhand dealing also. Yes, guideline value is
Yeah.
always less than market value.
Yes,
That's what Apex Court said in 2017. Court should take note of that.
yes. my lords.
Apex Court said, Justice Sapre said, court should take judicial notice of realities that happen in the sub-registrar's office. So if a sale deed is executed and registered on guideline value, court should assume that it is always less than what the market value is.
No, my lords.
Anyway, he has guarded our country.
Considering what the respondent is and what the submission is made, I seek my lords for passover because I will see what we can immediately.
Dismissed with a cost of rupees 5 lakh. Since admittedly the respondent consumer had paid rupees 44.50 lakh as on 7/6/2010. And thus the equitable interest in the subject flat was created. First, that being the position, there was no saleable interest in favor of the petitioner at all, comma, the absence of due conveyance in that regard notwithstanding. First, despite that, he sold this property to another person while registered sale deed dated 25/3/2015 for a higher sum, that is rupees 46 lakh. First, court also has common sense, and that tells that the market value is always more than, almost invariably more than what the guideline value that are operated while registering the conveyances. First, the conduct of the petitioner does not merit exercise of writ jurisdiction in his favor. More particularly when the state commission and thereafter national commission, having examined the matter, have turned him out. First off, the writ jurisdiction is not for cheats and frauds. That is not the object with which the Constitution is drafted, granting such extraordinary power to this court. First, we have an ex-naval Navy man who served the country for how many years?
He is attained superannuation.
We are asking you how many years he served the country.
Over 15 years he has served.
Who has served,
Detailed.
who is said to have served the country for more than a decade and a half. First off, there is no culpable conduct demonstrated as against him. First off, in the above circumstances, petition is dismissed with an exemplary cost of ₹5 lakh. Petitioner being a builder. Amount, what should happen to the amount in deposit now?
I filed an application to release it in my
The
favor.
amount deposited in this court, in the registry of this court, shall be remitted to
The first respondent.
the first respondent, ex-Navy man, immediately. First, execution is going on.
Yes, my lords, it has been stayed because of the order of the
The stay granted against the execution proceedings is lifted. First off, the executing,
State Commission.
the state commission is requested to accomplish the execution on a war footing, keeping in view the decision of apex court in Rahul Shah versus. But why are you coming to court? To intervene when we are talking with the other counsel? Which is that judgment?
Rahul S. Shah.
Rahul S. Shah versus so and so, 2021, 22, yeah? Huh?
23.
23. So and so. All. Cost to be remitted by the petitioner within 1 month. Failing which, additional cost of ₹500 for the first 1 month and ₹1,000 for the period next following. Okay.
Grateful, my lords.
All.
Seek for short accommodation, my lords. Can I request, my lords, for 15th or 16th of this month?
15 is very difficult, Manesh Kumar.
16th.
We call this matter in the first week of.
Second week, my lords.
Second week of June. All.
Interim order to continue.
Interim order to continue.
So,
Yes.
Okay, for the respondent number 4, my lord. Before my learned friend starts, my lord, this is a transfer matter wherein I had challenged her transfer to my position. Now I have been given posting at the same place, my lord. So I don't want to disturb the petitioner. Only my grievances with respect to the salary, my lord. From September 2024, salary is not paid.
Fact,
ಅಲ್ಲ,
yes,
ಅವ್ರ-
that is
ಅವರೇ
not
ಸಮ-
of our concern. In
ಹೌದು.
fact, that is
ಅಲ್ಲ,
not of
I'm-
our concern.
No, I'm requesting the government.
Yes. In fact, even my salary has not been paid.
That's protected. Why are you
Very-
wasting time of the court now? Yes, brother. Why are you not giving the salary to him? Huh?
Let them make a representation. but let
No,
them-
it-
We are not representation. ಅಂತವೆಲ್ಲ ಮಾಡ್ಕೋತ ಕೊಡಕ್ಕಾಗಲ್ಲ. 2:30 ಕರಿತೀನಿ, ಅವಾಗ ಹೇಳ್ಬೇಕು. At 2:30, you are protected.
Yes, no, I just wanted to say that ultimately his own application before the KSAT therefore is now rendered infructuous, against which I filed an appeal. Therefore, in light of this, that he's already got his posting, this matter may be recorded and closed. If he wants to.
No, not close it. We have to keep it because once we close it, we can't take any action for salary.
No, but that salary was never a claim even in his original petition.
Let us see. It's a matter for them, between them.
Very good. Then in that case,
Huh? ನಾಳೆಗೆ.
Day after it can be taken. Tomorrow I'm not in station.
Day after.
Yeah.
Yeah.
Great.
In the meanwhile, the government lawyer to confer with the department as to why the salary of a private respondent has not
And
been.
me,
Respondent number
both persons. Yes, even our salaries, let them respond to both.
The
Even my
salary of both the petitioner and the private respondent is not paid, is not paid. Salary ತಗೊಳ್ಳಿಕ್ಕೂ ಏನ್ರ ಇರ್ತದನೋ ವ್ಯವಹಾರ ಇಲ್ಲ ಹ? ಇರ್ಬೋದು.
ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿರಲ್ಲ ಅಂತ
ಅಲ್ಲ ಆದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿ ಇದೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ತೀರಿ, ಇವ್ರಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡಲ್ಲ, ಹಿಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರುತ್ತ. ಸ್ಯಾಲರಿ ಇಸ್ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದಿ ಸರ್ವೆಂಟ್, ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್, ಕೊಡ್ಬೇಕು. ಅವತ್ತು ಮತ್ತೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಮೊದ್ಲು ಹೇಳ್ಬಿಡಿ. All right, you will get that
Yes,
also.
interim order to
Interim
continue.
order to continue.
Grateful.
Grateful.
Call day after tomorrow for further hearing. Okay.
Reply not filed.
Your reply, WS not filed. Can you direct him to file the WS? Argue within your.
Monday, next Monday.
ಇಂಥವೆಲ್ಲ ಹೇಳ್ತೀನಿ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ಕಾಲ್ ಇನ್ ದಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜೂನ್ ಎಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿದೆ.
Notice ಆಡ್
ಏಜಿ ಇದ ಹಾ
ಆಗಿದೆ.
ಆಗಿದೆ.
Notice.
ಏಜಿ ನೋಟಿಸ್ ತೊಳಿ 1 ಹಾ 21 ನೋಡಿ ಕರ್ನಾಟಕ ಅವರಿಲ್ಲ ಈಗ
Isabel.
ಅಲ್ಲೇ registry to show the name of Anthony Joseph in the place of Mr. Ashwini S. Hallard, who is permitted to retire. Yes. Yes,
Petition, my lord.
Prasanna Shetty.
Please, my lord. Petition filed by the Lokayukta, my lord. The Honorable KSAT, my lord, quashed the entrustment order on the ground.
Entrustment order is quashed.
Please.
Darwad decision.
But
Darwad decision applies.
applies, my lord. But however, not only on the ground that, my lord, there is an alternative remedy available under section 1B, 81B of the Karnataka Lokayukta Act. My lord. On that ground, the entrustment order was quashed by the KSAT. But here, the complaint allegation, my lord, insofar as, my lord, illegal construction of a building, notice was not issued, my lord. In fact, first time it is listed.
First time it is come. Sorry. Issue. Note, ಅದು ಧಾರವಾಡದ ಒಂದು judgment copy ಕೊಡಿ.
ಹೌದು, ತಮ್ಮದೇ judgment ಇದೆ.
Issue emergent notice to respondents.
3 to 5, my lord. 3 to 5.
3 to 5,
Please. Sorry, 1 to 3.
1 to 3.
1 to 3. 2 and 3, 4 and 5 government.
AGA for 4 and 5. ಎಷ್ಟು ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಇದಾವ ನಮ್ಮ ಸ್ಟೇಟ್ ನಲ್ಲಿ? ಏನ್ ಹೇಳಿದ್ರು? ಆಲೂರು ವೆಂಕಟರಾಯರು ಅಲ್ಲ, ಕರ್ನಾಟಕ ಗತವೈಭವದಲ್ಲಿ.
What had happened before the KAT, my lord, 2 names. I am sorry, my lord.
ಅಲ್ಲೇ ಹಂಗ್ ಮಾಡಿದ್ರು ಅಂತ.
ಹೌದು, ಅಲ್ಲೂ ಹಾಗೆ ಮಾಡಿ, ಅದೇ ಮಾಡಿ ಅಂತಾರೆ ಇಲ್ಲಿ.
ನೀವು ಸರಿ ಬರೆದು ಬರೀಬೇಕು. ಈ ರಾಜ್ಯದಲ್ಲಿ ಒಂದೇ ರಾಜ್ಯ ಇರೋದಕ್ಕೆ ಹಂಗ್ ಮಾಡಕ್ ಬರ್ತದೆ ಅಂತ. This is how the state will be divided.
I'll correct, my lord. Now itself I'll make correction.
All right.
Please.
Yes.
ಅಲ್ಲ my lord.
ನಾಗರಾಜಪ್ಪ, ಮಧ್ಯಾಹ್ನ ನೋಡ 20 ಮಧ್ಯಾಹ್ನ. Day after tomorrow. ನಾಗರಾಜಪ್ಪ day after tomorrow.
Lords, may I make one submission?
Ah.
Lords, serial number 34.
34.
I had moved the matter. ಅವ್ರು ಬಂದು adjournment ಕೇಳ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. After vacation ಆಗ್ಬಿಟ್ಟೆ somewhere in the month.
ಹೆಂಗ್ ಮಾಡಕ್ ನೀವು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೊದಲೇ ಹೇಳ್ಬೇಕಿತ್ತು. ಅದ್ರ ಆರ್ಡರ್ ಬರ್ದಾಗಿದ್ಯಾ? ಆಗಿಲ್ಲ.
ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರು.
ಎಕ್ಸ್ಟೆಂಡ್ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು.
No, against me. I am for the respondent. I had moved the matter.
ಏನು?
Seniority, my lord.
ಸೀನಿಯರ್ ಬಿಡಿಗೆ
Promotion ನಮ್ಗೆ ಕೊಡ.
I am ready. Hold us up. How long will your remaining matters take?
ಅವ್ರಿಗೆ ಕೇಳಿದ್ರೆ ಅವ್ರು ಖಾಲಿ ಇರ್ತಾರೆ ಫೋನ್ ಮಾಡಿದ್ದಾರೆ ಆಕ್ಚುಲಿ ಆ ಡಿಎಂ ಬ್ರಾಂಚ್ ಸೈಲೇ ಬೇಡ ನಮ್ಗೆ ಯಾಕಂದ್ರೆ ಅದು ರಾಂಗ್ ಕನೆಕ್ಟ್ ನಮ್ಮ ಮೆಮೋ ಆನಂದ ಅಂಡ್ ಅದರ್ಸ್ ಸ್ಟೇಟ್ ಆಫ್ ರಿಪಿಟೇಷನ್ ಹೋಗಿದ್ದೆ ಜಿ ಎಂ ಬ್ರಾಂಚ್ಗೆ ಹೋದೆ ಸರ್ ಅದೇ ನೋಡ್ತಾ ಇದೀನಿ ಅಂತ ಅವ್ರು
And in fact, senior litigation. ನೀವು ಇರ್ತೀರಾ ಯಾರಿದೆ
Reconsideration provided reconsider ಮಾಡೋದಕ್ಕೆ reinstatement ಬೇಡ ಅಲ್ಲಿ. Temporary report ಅಲ್ಲಿ ಒಂದು ನಮಗೆ evidence free ಮಾಡಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ. Actually, ಒಂದು ಅನೇಕ I was the one who moved them. After vacation, after call. ಕೋಟಕ್ ಸರಿ ಅಂದ್ರಪ್ಪ ನಾಳೆ ಸಾಯಂಕಾಲ ಹೇಳಿ 5th ಮಾರ್ಚ್ ಮೂವ್ ಮಾಡಿದ್ರು ಫಸ್ಟ್ ಡೇ ಆಫ್ ಸೆಕೆಂಡ್ ಡೇ ನಾನು ಇದು ನಿಂಬಾಳೆ ಇತ್ತು ನಿಮ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಂಡು ಹೋದೆ. ನಾನು ನೋಡ್ದಂಗೆ ನೆನಪು. ಇವಾಗ ಎಂತ ಜಜ್ಮೆಂಟ್ ಮಾಡಿಸಿದ್ಯಾ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹತ್ರ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ಬಿಲೋ ಅಥಾರಿಟಿ ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಗೋಪಿನಾಥ್ ತೆಗೆದೇ ಇರ್ತಾರ ಗೋಪಿನಾಥ್ ಟಿಕೆಟ್ ಇವತ್ತು ಕಂಟೆಂಟ್ ಓಪನ್ ಕೊಟ್ಟಲ್ಲಿ 20 ಬೇರೆ ಡಿಕ್ಟೇಷನ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲರೂ ಎಲ್ಲ ಆಗಿದೆ.
ಇಲ್ಲ continue. You have paid. ನಾನು ಅದನ್ನ ನೋಡ್ತಾ ಇದ್ದೆ. ಕರ್ತೀನಿ ಸರ್ ಇನ್ನೊಂದ್ಸರಿ. statement
of
the institution and also the directors of the institution, my lord.
ಎಷ್ಟು ಅಮೌಂಟ್ ಲೋನ್?
My lord, in fact, the total liability is about 16 crores, my lord. The 4 crore rupees to pay to deposit to the DRIT, my lord.
ಅಲ್ಲ 16 crores ನಲ್ಲಿ
I have paid.
how
about-
you are going to make repayment?
No, madam, sorry, my lord. My lord, in fact, I till date, I have paid about 15 crore rupees to the bank, my lord.
Question is not that. When they issued notice to you to demanding money, what
Please,
was the amount due? What was the amount you had borrowed?
Total amount borrowed was about 16 crores, my lord.
When it was?
It was in 2017 and 18, my lord.
What is the rate of interest?
It is about 11.5%, my lord.
11%.
Yes, ma'am. And page number 72, my lord. Just to bring it to the knowledge of the court.
How much you have paid in this?
I have paid 14 crores, 46 lakhs, 63,546 at page number 72, my lord.
No, 11% interest, how much it will work out?
It's about
ಹನ್ನೊಂದು
about 60%, my lord. 60% of the loan amount. Because it's a reducing balance. No,
annual rest ಅದು.
my lord, because it is a reducing balance, I was keeping regularly paying the money, my lord.
Where is your state, the
At
payment
page
schedule?
number, page number 63, my lord, 72, annexure G3, 14 crores, 46 lakhs, 63,546 I have paid, my lord. On the top of it, I have cumulatively computed, which is about 14 crores, 46 lakhs.
Page number?
Page number 72, my lord.
70?
72. Payment made till now, my lord, on the top of it.
How much is due
According
after making this repayment?
According to the bank, it is about 16 crores, my lord.
Still 16 crores.
16.
Therefore, we said it will be 100% of the
Yes, 16 crores, my lord.
16 crores.
Yes, my lord.
How are you going to
My
make
lord,
this payment?
My lord, in fact, my account is become a NPA because of the negligency of the bank, my lord. There was an amount which was available with the bank. Without adjusting that money, the bank has converted my account as an NPA. We are fighting since then, my lord. And my case is before the DRIT with the same conditions, with the same grounds that my account could not have been considered as an NPA because the money was there available in the account. And subsequent actions of the bank, my lord, my finance has become deteriorated, my lord. They issued a pamphlet to the neighboring areas not to take an admission in my school, my lord. These are all multiple actions have committed by the bank, which completely flantered my financial situation. In fact, for the last 2 years, we are working hard to get more admissions to see that it has been done, my lord. Now the issue, my lord, the DRIT has imposed a condition, pre-deposit condition of about 4 crores. I am ready with 1 crore rupees deposit, my lord, which is available at page number 80. I've got a DD, my lord.
That's DD, all right. What is the maximum relaxation that can be granted under section 17 or 18?
18, my lord.
18.
25%, 25%, my lord, which I am agreeable to pay deposit, my lord.
25% under the maximum, Madhu.
No, my lord.
Not as a matter of rule.
No, 50% is the maximum, my lord. 25% is the discretion of the learned chairperson, as proviso to section 18 of Surface Act, my lord. The third proviso to section 18.
Vijay Malya Kudi. May, for the regions to be recorded in writing, reduce the amount to not less than 25% of debt referred to in second proviso.
Please, my lord.
You have deposited 1 crore.
1 crore, I need a permission of this court, my lord, because my appeal has been dismissed by the DRIT because of non-payment of full amount, my lord.
Issue emergent notice. Interim order in Kelly.
Interim order is to stay the order of the land DRIT, my lord.
ಎಲ್ಲಿದೆ?
at page number 10, my lord,
10,
to set aside,
final order, the interim order.
my lord. At page number 83, my lord, praise that this honorable court may kindly be pleased to stay the order dated 19/3/2025, passed by the honorable DRAT, Chennai on.
ಅದು dismissal order. ಅದನ್ನ stay
Dismissal
ಮಾಡಿರಿ
order.
ಏನಾಗುತ್ತೆ?
Dismissal.
ಎಲ್ಲಿ ನೀವು ಬರ್ದಿಲ್ಲ interim order ಎಲ್ಲಿ?
At page 83, my lord.
83.
83, my lord.
Separate application.
I think, my lord,
application
it's a
ಹಾಕಿದ್ರಾ?
separate application.
ಅದರಲ್ಲೇ ಹಾಕಿ ನಡೀತಿತ್ತು. ಅಲ್ಲ ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ?
My lord, in fact, at least because the bank will not go, take the question.
ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಏನಾಗತ್ತೆ ರೀ? ಅದು ಬ್ಯಾಂಕ್ ಮೇಲೆ ಕೇಳ್ಬೇಕು. ಏನು ಅದ್ರ
Section 14 order, my lord, they are taking the position of the
issue emergent notice. The respondent bank is restrained from taking possession of the subject security property. The subject, the property, security property in question, subject to petitioner depositing rupees 1 crore with the respondent bank itself
much.
within 1 week.
No, today, I mean, in fact, tomorrow itself we can file it.
One week ಇಟ್ಕೊಳ್ಳಿ. ತುಂಬಿಟ್ರೆ ಆಯ್ತು.
Please, no.
Within 1 week, failing which the not only the interim order would stand rescinded, but the writ petition itself will be dismissed on that ground alone. First stop, next paragraph. In giving this interim protection, we have taken into account the vehement submission of learned counsel for the petitioner that in the subject property, the school is being run with the students,
1050 children's hostel.
with about 1,000 students of various standards, prosecuting their studies in various standards. Okay.
Not sure.
Office objection ಇದೆಯಲ್ಲ?
I'll complain.
Complain ಮಾಡಿ.
My lord, challenging the order of the KSAT, my lord, wherein the entrustment order has been annulled, my lord.
Entrustment order is annulled.
Yes.
You are Lokayukta.
I'm
Annulled on what ground?
My lord.
It
My
is
lord,
annulled on
stating that it's been 4 years. The respondent number 1 DGO has retired, my lord.
114.
214.
214.
2B clause 2.
2B clause
Clause
2.
two.
4-year
Right.
limitation.
4-year limit. But
2B. 2B.
2.
Correct.
Okay. That being the situation, my lord, if your lordships may kindly see the operative portion, which is at page number 19, my lord.
214 2B2 ಅಂತ ಹೇಳ್ಯಾರ ಇವರು. Civil service rules and supplement. The case accordingly the load and you have entrusted it on 6/11/2020. Government entrusted it to
Entrusted
you.
it on 6/11/2020.
In respect of what event?
My lord, it so happens, my lord, that a person was granted land under a scheme known as Hemavati Displaced Persons Project. This was, my lord.
But he retired on 30/4/2018.
Yes, my lord, may I just. This, my lord, what the KSAT, my lord, takes into consideration is the date on which land has been granted. Saguvalli Chit, my lord, was issued in the year 2004. Since he could not take possession, my lord, the complainant, my lord, he approaches the DC, my lord, the jurisdictional DC, my lord. The jurisdictional DC, my lord, he directs the respondent number 1 DGO, who was the Tahsildar, my lord, to afford him police protection to demarcate the land, my lord, of that 4 acres of land, my lord. And this order, my lord, was passed in 2012.
2012. That
The
order was passed.
38/2012.
Correct.
The order passed by the DC, my lord, of Hassan district.
Correct, but the
Subsequently,
incident happened when?
my lord, that's a continuous process because though there has been a direction issued by the DC to the Tahsildar to demarcate the land and then to put him in possession, and if required, to take police help, my lord. This has not been done right from the year 2012 till the date he retired. Subsequently, a complaint was given to the Lokayukta as on 2014, my lord, 16/12/2014. When an observation note is issued to the respondent number 1 DGO, my lord, he says that there are other persons also in the said survey.
That's all it.
That being the
Limitation, what you are going to say.
My lord,
ಅದು
as far
continuous
as the-
cause of action ಎಲ್ಲ ಅಂತದಕ್ಕೆಲ್ಲ apply
ಅಲ್ಲ ಅಲ್ಲ. So ಇದರಲ್ಲಿ he is again sent a letter to the DC stating that, my lord, that is not forthcoming.
You are to
Anywhere,
tell that.
anywhere in his application, nor in my pleadings, my lord. Now he retires, my lord, in the year 2018. And in 2015, when he gives a reply to the Lokayukta, my lord, he says that he has again given a letter to the DC stating that, so that, my lord, this is an aspect, my lord, whether it would fall within the 4-year limitations or not, my lord.
Limitation. ನಿಮ್ ಕನ್ಟೆನ್ಷನ್ ಒಪ್ಪಿರು ಮುಗಿದು ಹೋದ್ಕೊಂತ ಒಂದ್ ಲೆಟರ್ ಇಟ್ಕೊಂಡು 2001ನೇ ಇಶ್ವಿಗೆ ಕೊಟ್ಟಿವಿ ಅಂತ ಹೇಳ್ತೀರಿ ನಾಳೆ ಮುಂದೆ ಆಬ್ಜೆಕ್ಟ್ ಈಸ್ ಎ ಪರ್ಸನ್ ಹೂ ರಿಟೈರ್ಸ್ should be
Within-
peacefully living in the evening of his life.
Please,
That is the object.
Lord, I do understand that. My lord, I've just placed this on.
Dismissed agreeing with the reasoning of the tribunal. Registry to send a copy of this order to the private respondent by speed post.
Obliged. Obliged.
Okay. ಒಂದು ನಿಮಿಷ petition ಕೊಡಿ ಮೊತ್ತಲ್ಲಿ ಅಲ್ಲಿ ಹೋಗೋದೇ ಬೇಡ. The Lokayukta, Karnataka Lokayukta is invoking the jurisdiction of this court for assailing the State Administrative Tribunal's order dated 17 February 2021, whereby private respondents application number 396 of 2021 having been favored, the entrustment of disciplinary inquiry under Rule 14 capital A of KCS CCA Rules 1957, wide order dated 6/11/2020 has been voided. First, ಕೂತ್ಕೊಳ್ಳಿ. Learned DGA appears for the first respondent, correct?
Respondent number 2.
Second respondent. First, next paragraph. Having heard the learned counsel for the petitioner and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the tribunal, which has operated Rule 214 2B of KCSR, which prescribes a period of 4 years, a limitation period of 4 years. 4 years. First off, from the to be reckoned from the date of event, you are right. To be reckoned from the date of event, which happened long ago. First off, the object of prescribing limitation of the kind is to let the retiree to live in peace in the evening of his life, having put in long service, long public service. First off, Rule 214 2B is a rule of repose and peace, to borrow the words of Salmond in jurisprudence. First off, there is no provision for condonation of delay. First off. Next paragraph. The vehement submission of panel counsel appearing for the Lokayukta that the direction to hand over the possession of granted land to a particular person, if necessary by taking recourse to police help, was issued in 2012 itself, and that the direction has the effect of continuum CINTUNUUM. And therefore would give rise to recurring cause of action is bit difficult to countenance. First up, the reason for this is obvious. Colon, if such a contention is accepted, that would strike the death knell of prescription of limitation enacted in, promulgated in Rule 214 2B. First, admittedly, the private respondent demitted office on attaining the age of superannuation in on 30th of April 2018. First, next one, in the above circumstances, petition is liable to be and accordingly rejected in limine. Limine beda or notice agidella. Rejected. Costs having been made easy. First, registry to send a copy of this order to the private respondent by speed post immediately.
Obliged.
Petition by Lokayukta, my lord, the
What's the point?
lord, challenge before the KAT while my lord, the penalty order passed by the government. Penalty of my lord, withholding of 4 annual increment. My lord, the reasoning of the honorable KAT was that my lord, KAT has reappreciated the evidence and my lord, holds that my lord, there is a alternative remedy under section 8(1)(b) of the Lokayukta Act. It is hit by, because my lord, complainant father has filed a civil suit before the trial court, my lord. The allegation against the, my lord, allegation is that, my lord, in the complaint, the one private parties, they have, my lord, formed a road, my lord, in a, they have, my lord, erected a wall, my lord, across the roads.
Public road.
Public roads. My lord, we filed a complaint to, my lord, Lokayukta. In turn, Lokayukta, my lord, directed the PDO to conduct an inquiry. My lord, instead of, my lord, complaint, he did not take any action. He gave an endorsement stating that, my lord, the complainant father has filed a civil suit against the so-and-so, the encroached persons, and suit was pending. But however, it is only a suit for injunction, my lord. In court, my lord, it has to be, my lord,
Suit for injunction, not to demolish the wall.
not to demolish the wall. Suit for injunction, my lord.
Injunction what injunction?
Injunction and, my lord, declaratory injunction, and to declare that, my lord, this land belongs to me. That is the contention of the plaintiff's father. But suit was pending till 2019.
Correct.
But here, my lord, allegation against, my lord, DJ's misconduct. In spite of, my lord, complaint was filed.
What was the misconduct?
My lord, he did not take any action to survey the
Suit is pending.
Please, suit was pending, my lord. But however, my lord, there is no, my lord, order to restrain government officials.
Generally, when suits are pending,
Please,
especially title suit,
please.
that was pending.
Please.
Therefore, he said the suit is pending and I am helpless.
Because, my lord, the wall is built, my lord, across the road.
No, but suit is against wall only.
Please, that the subject matter suit was pending.
How you expect him to do something? When matter is pending here, if somebody does, though there is no interim order, how the court will look at him?
At least you could have conducted, my lord, the investigation or inquiry by calling upon, my lord, both the complainant and other side. But then to see whether it is a public road or a private property, he should have, my lord,
No, so that itself is the suit, subject matter.
please, but he should have forwarded them, my lord, report to the, my lord, Lokayukta on that aspect.
Correct.
That is the only allegation. That is the only finding of the trial. KAT.
A5, my lord.
Huh?
Client is produced in A5, my lord.
A5. Title suit adu.
Alla.
112 of
Injunction
2011.
Injunction dawa.
But then a suit on
Right, permanent injunction, restrain the defendant, their agents, workmen, supporters, henchmen, etc. from interfering with obstructing, blocking, using, otherwise restrain in the manner from using said road way. See.
Complainant defendant ಅಲ್ಲಿ.
Complainant father has filed a suit.
Father has filed.
How?
He claims under father.
And father has filed a suit. Only, my lord, observation with the KAT, my lord, complainant has not mentioned the pendency of the suit in the complaint. That is the, my lord.
Complaint has not mentioned pendency of suit.
Please, in the complaint. But however, our contention was that, my lord, suit is pending insofar as, my lord, injunction, prayer of injunction. But here, my lord, insofar as misconduct, we have filed a case against the DGO, my lord.
Yeah,
Being a
misconduct.
PDO.
ಅದರಲ್ಲಿ ಪಾರ್ಟಿ ಯಾರ್ಯಾರಿದ್ರು ಸೂಟ್ ನಲ್ಲಿ?
ಸೂಟ್ ನಲ್ಲಿ ಅವರು 3 ಜನ, ಕೃಷ್ಣಪ್ಪ, ಶಿವರಾಜು and my lord, one ಮಾರಪ್ಪ.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವ್ರು ಯಾರು?
Complaint, my lord, son of plaintiff, ಚಿಕ್ಕಸಣ್ಣಪ್ಪನ ಮಗ.
Son of plaintiff.
Please.
ಏನಂತ ಅಲ್ಲಿ
ಪಬ್ಲಿಕ್ ರೋಡ್ ಅಲ್ಲಿ ಅವ್ರು ಬ್ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ, ಪಬ್ಲಿಕ್ ಪ್ರೈವೇಟ್ ಅಂತ ಏನು ವೆರಿಫೈ ಮಾಡಿದೆ, 2 ರೋಡಿಗೆ ಅಕ್ರಾಸ್ ಆಗಿ ವಾಲ್ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ, ರೋಡ್ ಜಾಯಿನಿಂಗ್ ಅಲ್ಲಿ ಗೋಡೆ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ. One my lord, charge was framed on that aspect, my lord, and detailed inquiry was conducted. But in the inquiry, it is proved that, my lord, that there is a misconduct by the DGO.
ಎಂತ ಮಿಸ್ಕಂಡಕ್ಟ್ ಇಲ್ಲ ಏನಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Petitioner, additional registrar of Lokayukta is knocking at the doors. Please be seated, please. Doors of Reed Court for assailing the tribunal's order dated 10th February 2022, whereby private respondent's application number 2737 of 2021 having been favored, the subject inquiry proceedings have been quashed. Inter-alia on the ground that there is an availability of alternate remedy under section
81B.
81B
of
81B of Karnataka
Lokayukta Act.
Lokayukta Act 1984. First up. Learned AGA on request accepts notice for first respondent, correct? Second respondent.
Second.
Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter in as much as the tribunal has done the right thing on 2 counts, which the aggrieved party had an alternate remedy availing under section 8B, 81B na? 81B of 1984 Act. Semicolon. Secondly, in respect of the complaint itself, suit, an injunctive suit in OS number 112 of 2011 is pending. Allen injunction enra itta, temporary injunction order?
Temporary injunction was water.
Adu ittu. Ittu. And
Later it was vacated.
there was an order of temporary injunction at the hands of the civil court. Although the same is said to have been vacated at a later point of time. First up. When a suit is pending in respect of subject matter of the complaint, which involved allegedly a wall built on public property, comma, ordinarily, officials do not touch such matters, at times appreciably. First up, touching the matter when the suit is pending, comma, is not viewed by the courts graciously. First up, therefore, no fault can be attributed to the employee concerned. First up, this reasoning has animated the impugned order of the tribunal. First up, next part, the above circumstances, petition is dismissed. Courts having been made easy, registry to send a copy of this order to the private respondent by speed post immediately. Okay.
For the petition.
Yes.
Plus matter relates to Milord's withholding of penalty of retired employee.
Penalty,
Withholding of pension.
pension,
Milord's
just percent.
10% and also recovery of 4,55,000.
ಯಾಕೆ
Lords, the articles of our charges are that, my lords, one road which is already constructed in the year 2009-10 and again shown to be constructed in the year 2011, 10 and 11 in the Harapnalli Village Panchayat. Lords, petitioner was appointed as nodal officer of Harapnalli Village Panchayat on 16/8/2011 at annexure A3, my lords. And my lords, the allegation against the petitioner, my lords, will find at page 180.
Old
Signature,
matters ಯಾವಿದಾವ್?
my lords.
Old matters ಯಾವಿದಾವ್? ಕೊಡಿ. Wait, ಹೊಸ ವರ್ಷ ತಗೊಂಡ್ರೆ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಏನಾಗಬೇಕು?
Fresh
Old matter.
notice ಆಗಿ.
ನೋಡೋಣ, ನಾವು ಓದಿಲ್ಲ. ನೋಡೋಣ, ವಿಲ್ ಸಿ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ಬರೀ ನ್ಯೂ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡ್ರೆ ಅಥವಾ ಪೆಂಡಿಂಗ್ ಪಾಪ್ಸ್ ವೇಟ್ ಮಾಡ್ಕೋತಿರೋರು ಏನ್ ಮಾಡ್ಬೇಕು?
I'll wait.
That's ಇದೇ ಓಲ್ಡೆಸ್ಟ್?
That's this order, my lords. This writ petition is arising out of an order, my lords, whereby the commissioner suo moto has taken cognizance of an issue and, my lords, reversed a decision. The subject matter here is that, my lords, the petitioner is he's a hotelier, my lords, operating two set of hotels. Number one,
Yes.
Number one, my lords, he operates in the realm of serving food. These are few set of hotels. And there are another two hotels, my lords, two units of hotels where he's serving food with alcohol. Now, my lords, under the VAT regime, there's a concept called, my lords, composition scheme, which was called, my lords, as COT. There's some reason I'm looking behind us. Uday sir is coming. He's on his leg, so I didn't want to lose a chance. But that's 2016 matter and that started.
Yes.
That's the concept here is COT, which is a composition scheme as prescribed under section 15, my lords, of the VAT Act. Under that scheme, my lords, I am bestowed with a benefit so that I don't purchase any goods in stock from outside the state. And I purchase only in-house materials or in-state material and I continue my work. Now, my lords, when I had applied for the registration under the VAT Act, my lords, I had specifically told them that, look, I am operating two kinds of restaurants, one with serving only food and without alcohol. The other one is serving alcohol. So they gave me a registration certificate, my lords, wide annexure B of my writ petition, whereby, my lords, they had given me a VAT as well as COT registration.
Separate registration.
ಒಂದೇ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಎರಡೂ ಇದೆ. That is what my lords would get annexure B.
ಆ ರೀತಿ ಸರ್ಟಿಫಿಕೇಟ್ ಇದ್ರೆ ಮಾತ್ರ ಕಾಂಪೋಸಿಷನ್ ಟ್ಯಾಕ್ಸ್ ಬರ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
ಅಲ್ಲ, composition scheme separate ಆಗಿ they can mention. There are people, my lords, who only do composition scheme. Now, my lords, I disclosed my nature of business and that's why I'm before my lords. And, my lords, here what happened is that, my lords, once I started doing business, they gave me a certificate back in the year 2012. My lords, may look at the certificate for a moment, my lords. Annexure B, page number 74.
74. Under composition scheme.
Yes, my lords. My lords, may, under the tabular column, my lords, Swati restaurant ಕೆಳಗಡೆ, the aforesaid.
ಆಯ್ತಾಯ್ತು, ನೋಡಾಯ್ತಲ್ಲ.
Yes.
Tax under composition scheme under section 15.
Correct, my lords. Just above that, the dealer has also opted for payment.
Collect tax on his or her sales as specified in the said act from 1/3/2012.
Yes. My lords, what happens is that, my lords, 1/3/2012, I get this registration certificate and I start operating my business, my lords. My lords, in 2014 tanka, till 31st March 2014, they don't disturb me. I file my returns. Normally, the benefit I get is that, my lords, if I'm paying under VAT, I pay 14.5%.
Composition ಆದ್ರೆ
4%. So I get a substantial benefit. Now, because I'm getting a substantial benefit, my lords, till 2014, I continue paying under the scheme.
Are they not mutually exclusive actually? Are they not mutually exclusive? Such option is given.
Lords, what happens is that so far as composition is concerned, there are limited number of dealers or limited types of dealers who can opt for composition. And composition, my lords are aware, it is an amount in composition in lieu of tax. So
Correct.
it is in the nature of a voluntary payment.
Correct.
He has to, however, meet the conditions. One of the conditions is that he will not sell alcohol.
It's there in this.
It is there.
Yeah,
in
it
the
is there.
statute.
It is an
It's
act.
there in the statute.
It is there in the statute.
It's there in the statute.
Okay.
He will not sell alcohol. Now, he's saying that, look, I have various branches. One sells alcohol, no composition. One does not sell alcohol, composition. Very well. In order for him to do that, he needs to obtain a separate registration for each of the branches. Let him show where that is. There ends the story. There is an application under my lords, Rule 47 that is required. If that is done, there ends the story. Everything else is jargon.
Yes, Mr. Holla, where is your non-alcoholic unit?
Please, my lord.
He says, condition is, you shall not sell the alcohol.
Correct.
But you have sold the alcohol, not
But
sold the.
what happens is,
Ah.
we had, my lord, the principal bench, my lord, principal
Seat of the
seat for
business.
this thing, we took it.
Ah.
Thereafter, my lord, there were other branches we started.
Aveli down.
And that, my lord, I'll point out.
Yes.
Can I, my lord, just give you a lot, my lord, list of dates that are on
Got
Monday?
it, got it.
In the, if your lordship, my lord, take.
Ah.
the appeals.
As if senior can show the.
Bande, ಎಲ್ಲ ನಾನು ಇದು, let me argue in my own way. I can't, my lord, take instructions from them and argue. I think, you know. Not accustomed to. That also may not be proper ಅಂತ ಅಂದ್ಕೊಂಡಿದ್ದೀನಿ. ಗೊತ್ತಿಲ್ಲ, ಈಗೆಲ್ಲ change the scenario ಅಲ್ಲಿ ನಾವು we are all, my lord, old generation.
ಓಲ್ಡ್ ಮೊನ್ನೆ ನೀವು ಕ್ರಿಕೆಟ್ ಆಡಿದ್ ನೋಡಿ, ನಿಮ್ಗೆ ಓಲ್ಡ್ ಆಗಿದೆ ಅಂತ ಯಾರು ಒಪ್ಪಲ್ಲ.
My lord, please come to.
What happens is the more the fondness for a senior, the more the anxiety to impress him.
Good compliment.
So it just happens that whenever I oppose senior, I am a little more enthusiastic.
No problem. I'm always welcome, Lord. Youngsters, they ultimately they are the future. They are all the past. Please come to
Yes.
my Lord. Annexure, my Lord, B, page 74.
Yes, we saw that actually.
Then, please come to my Lord, the additional statement that we have filed, my Lord, the additional document, my Lord, that we had filed. Kottidvi. On, my Lord, 3/3/2025, we had filed, my Lord, a memo with 3 documents. I think, my Lord, we gave it across the bar, my Lord.
Is it 3/3?
How son?
31/125 is it?
Yeah.
3/3/25.
Please come to my Lord.
Why this matter is pending since last 9 years? We only should answer.
Illa.
Matter is covered. There was an SLP pending before the Supreme Court against the judgment by which it is covered.
Okay.
That SLP has been withdrawn.
Therefore, it was kept pending all these.
Idu cover agilla. Nan I'll show how it is not covered also.
Okay.
Please come to my Lord, the last page.
Last page of this document.
Yes. That colored.
Correct.
Please see, my Lord.
Welcome
MUL.
to dealer search system.
Correct.
Ah.
This is, my Lord, the website of the GST website itself.
Ah.
If my lords come to my Lord in the middle, registration type, multiple,
Registration.
MUL. Middle al baratte Swami.
Correct.
If your lordship sees.
MUL.
MUL. That's, my Lord.
Ah.
Multiple.
Correct.
Now, the all along from, my Lord, 2012 onwards, sorry, we have been filing returns in respect of, my Lord, the principal, my Lord,
Business.
business,
Seat of business.
seat of business.
Ah.
It is, my lord, vegetarian,
Ah.
no, my lord, liquor. Two other, my lord, we have, my lord, four other branches. But two other branches, my lord, there is liquor sold, in respect of which, my lord, regular tax is paid. There is, my lord, what is known as a composition of tax.
Correct.
So, my lord, in respect of these, composition of tax, my lord, in respect of, my lord, the principal seat and two others, and in respect of where liquor is served, my lord, we pay, my lord, regular tax of 14%, 14.5.
Otherwise, it is 4%. ಅದೆಲ್ಲಿದಾವ್ ನಿಮ್ಮ ಬ್ರಾಂಚಸ್ ಎಲ್ಲಿದಾವ್?
Please come to my lord. My lords may take, my lord, the page 74 ತಾವು ಬಂದ್ರೆ
74 is annexure B composition.
B, correct. ಅದರಲ್ಲಿ
ಎರಡೂ ಇದೆ.
Please come to 77.
77.
76 and 77. Additional place 76 ಅಲ್ಲಿ ತಾವು additional in the second line or third line. Holder of this certificate has additional places of work in the following addresses: Swati Restaurant number so and so Card Road, then Airport Road, then Ring Road, then Milord Vinayaka Layout, Nagarabavi. These
So these are 1, 2, 3, 4.
Yes. Then idu separate, idu bere alva, idu addition. 77 also.
This was in 2012 itself.
Correct. We kept on adding. Well, come to page 77 also. Same. Airport to same. 1, 2, 3, 4, 5. ಮುಂಚೆ 4 ಇತ್ತು, ಆಮೇಲೆ 5 ಆಯ್ತು, ಒಂದು ಎಡಿಷನ್ ಆಯ್ತು. ತಮಗೆ ನೋಡಿ, ವೆಸ್ಟ್ ಆಫ್ ಕಾರ್ಡ್ ರೋಡ್ ಇಸ್ ದ ಸೇಮ್ ಅರ್ಲಿಯರ್ ಆಲ್ 76 ಅಲ್ಲಿ ಇರೋದೇನೆ. ದೆನ್ ಮಲಾಡ್ ರಿಂಗ್ ರೋಡ್ ಅಲ್ಲಿ ಇರೋದೇನೆ. ದೆನ್
ಹಾಸ್ಪಿಟಲ್ ಸರ್ವಿಸ್ ಪ್ರೈವೇಟ್
ನಗರಭಾವಿ ಮಲಾಡ್ ಅಲ್ಲಿದೆ. ಇನ್ನೊಂದು ನಾವು ಎಡಿಷನ್ ಮಾಡಿದ್ದೇವೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾದಲ್ಲಿ.
ನಿಮ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೀಟ್ ಯಾವ್ದು?
Principal seat, my lord, my lords get that at page
74.
Correct. Number 5, west of Cord Road, Rajajinagar. That's the principal seat of business. And all along, my lord, we have been paying this and the authorities, my lord, have been accepting it. It's not as if, idyano iga first time now, itara heltivi antalla. All along, from 2012, whenever, my lord, we had, wherever liquor is sold, when we made, my lord, new.
Don't go for composition. Wherever liquor is not sold, you go for regular.
That's right. Therefore, my lord, my submission to your lordships is the section 38(5) of the Act, my lord, 38(6) of the Act, sorry.
38(6).
Is, my lord, assessment of tax. So 38(6) is bandre. Notwithstanding anything contained in this Act, where a dealer is a body corporate has more than one place of business, Commissioner may, subject to such conditions as may be prescribed, and with the consent of the dealer, treat each of such places of business as a separate unit for the purpose of levy, assessment, and collection of tax, and thereupon all the provisions of this Act regarding registration, filing of returns, assessment, collection of tax shall apply, as if such places of business is a separate unit. Then, my lord,
separate registration ಎಲ್ಲ ತಗೋಕಾಗ್ತದೆ.
My lord, separate registration ಅಂತ ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ. ನಮಗೇನಾಯ್ತು, ಇದನ್ನ ಕೊಟ್ಬಿಟ್ಟು ಇದನ್ನೆಲ್ಲ ನಾವು ಮಾಡ್ತಾ ಇದ್ದೆ ಮಲ್ಟಿಪಲ್ ಅಂತಾನೆ ಕೊಟ್ರು. As your lordship sees, my lord, if the authority, my lord, does not, my lord, give separate this thing, but treats it as, my lord, separate, my lord, that's, my lord, has been happening for the last, my lord, 12 years. 2012 in the, we have been, my lord, paying composition tax, my lord, in respect of where no liquor is served. In respect of two units, my lord, where liquor is served, my lord, we are paying 14.5, and they have been accepting it. Then, my lord, they issued us a notice. Please come to, my lord, running page 80. Show cause notice issue madadu.
You mean to say, annexure B74,
correct.
Alin ಎರಡು ಕಾಲಮ್ ಇಟ್ಟಾರಲ್ಲ.
Correct.
One column it applies where liquor is served.
Correct.
Other is where liquor is not
Not
served.
served. Not
ಆ
only that.
ಕಾರಣಕ್ಕನೇ ಈ ರೀತಿ ಕೊಟ್ಟಿದ್ದು ಅಂತ.
ಹೌದು, ಅದು ಮಾತ್ರ ಅಲ್ಲ. That's why, my lord, we produce that additional document. In their website itself, it says multiple. Therefore, my lord, it can't be something, my lord. And I'll point out, my learned friend said there's one judgment. I'll point out, my lord, that is clearly distinguishable. If, my lord, since my learned friend is saying that, let me point out that judgment first, and then, my lord, take your lords to the further fact.
38(6).
Thereupon, all the provisions of this act, sorry.
ನಿಮ್ ನೋಟ್ ನಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ 38(6) ಬಗ್ಗೆ ಹೇಳಿರಾ? 15(1) you have said 14.38(6). Anywhere have you mentioned that?
ತಾವು ಪೇಜ್ 6 ಬಂದರೆ
ಆ,
6 ಬಂದ್ರೆ
ಆ,
2 ಅಂತ ಬರುತ್ತೆ ನೋಡಿ ಅಲ್ಲಿ ಕೆಳಗಡೆ. ರೆಸ್ಪಾಂಡರ್ಸ್
ಆ, 38(6).
ಹೇಳಿದ್ದೀನಿ.
Correct. Multiple and
Multiple.
this is your ground.
Correct. That's the main ground. Then, my lord, they issued me a show cause notice.
ಏನಂತ ಶೋಕಾದ್ ನೋಟಿಸ್?
Saying that, my lord, ನಿಮ್ದು ಈ ತರ ಇದೆ, ನೀವು ಲಿಕ್ಕರ್ ಸರ್ವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಪೇಜ್ 80 ಬಂದ್ರೆ ತಾವು 80. Lord, that's all. ಅದರಲ್ಲಿ ಇನ್ನೇನಿಲ್ಲ, ಹೆಚ್ಚೇನಿಲ್ಲ ಅದರಲ್ಲಿ. 80 annexure F, that's a show cause notice. Saying that you are serving liquor, and so, my lord, we filed our returns, our objections.
ಅವ್ರು ಹೇಳೋದು ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಅವೈಲೇಬಲ್ ಇಲ್ಲ,
Correct.
ರೆಸ್ಟೋರೆಂಟ್ ಮಾತ್ರ ಇದೆ ಅಂತ ಅವ್ರ ಕಂಟೆಂಟ್.
Correct.
ನೀವು ಹೇಳೋದು ಬೇರೆ ಬೇರೆ ಯೂನಿಟ್ ಇದಾವು, ಕೆಲವು ಕಡೆ
ಎರಡು
ಬಾರ್
unit
ಅಂಡ್
ಗೆ-
ರೆಸ್ಟೋರೆಂಟ್ ಇದೆ, ಕೆಲವು ಬರೀ ರೆಸ್ಟೋರೆಂಟ್ ಇದೆ ಅನ್ನೋದು ನಿಮ್ಮ contention.
Correct. This is the short question for my lord's consideration. Then, my lord, they passed, my lord, based on this, my lord, we filed a detailed objections. Thereafter, my lord, an order came to be passed.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲಿದೆ?
My lord, please come to running page.
80.
Reply
Annexure F
80 ಎಂಬತ್ತಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ.
ಹ?
80 is our reply, sorry. Show cause notice is page 79, my lord. I stand corrected, my lord.
79.
My apologies.
80 ಇನ್ನು
ಹೌದು.
80 is your reply.
Correct.
ಅಲ್ಲಿ ಏನಂತ ತೊಂದ್ರೆ ಸ್ಟ್ಯಾಂಡ್?
But please come to my lord. We are into hotel business. This is classified by you generally. In hotel business, there are two types. One is a restaurant, another is a bar and restaurant. Both business are not one and the same. They are different because COT, that's composition tax, is available only for restaurant and it is not available for bar and restaurant. In case both are in case both are same business, there cannot be two different rules for the same type of business. Since they are different, there are two rules. In case both are one and the same, two laws for the same type of business will become discriminatory.
ಸೊ 74 ರೆಫರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು.
ಹೌದು.
74 ನಲ್ಲಿ ಮ್ಯೂಚುವಲಿ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಇದಾವು.
Correct.
ಎಲ್ಲಿ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಇರ್ತದೆ ಅಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಕೊಡೋದು 14%, 14.5%.
ಅಷ್ಟೇ.
ಇನ್ ಬೇರೆ ಕಡೆ ಇರುವಂತದ್ದು ಕಾಂಪೋಸಿಷನ್ ಟ್ಯಾಕ್ಸ್ ಅಂತ
Correct.
ನಿಮ್ ಕಂಟೆನ್ಷನ್.
Correct. Then, my lord, an order came to be passed at page 82. Please come to my lord. Page 82 ಅಲ್ಲಿ first paragraph ತಾವು ಬಂದ್ರೆ ಅಂದ್ರೆ after the tabular column, my lord, the dealer has filed ಅಂತ ಬರುತ್ತೆ ಸ್ವಾಮಿ. After the tabular column.
The dealer has filed returns from March
From March
2012.
2012 in both form VAT 100 and 120. 100, my lord, is VAT, that's regular tax. 120 is, my lord, composition tax.
That is
TOT.
100 is the restaurant.
Correct. Where there is no liquor.
Barcom restaurant.
ಇಲ್ಲ, Barcom restaurant is 100.
100.
ಹಾ.
ಅದೇ.
Regular restaurant, my lord, without bar and restaurant, I mean, without bar is VAT 120.
120.
Wherein tax at the regular rate of 14% has been discharged on the sale of goods and drinks sold at the business place where liquor is served, and under composition scheme at 4% on sale of food and drinks sold at a place where no liquor is served. This is, my lord, is undisputed because this is what, my lord, we have been paying and they have been accepting it.
ಆ ಟೇಬಲ್ ನಲ್ಲಿ ಯಾವುದು ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್, ಯಾವುದು ಓನ್ಲಿ ರೆಸ್ಟೋರೆಂಟ್ ಎಲ್ಲಿ ಹೇಳಿರಿ? ಆ ಟೇಬಲ್ ನಲ್ಲಿ ಪೇಜ್ 82 182 ದಲ್ಲಿ
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ ಅಂತ ಬೇಕು ಸಾಹೇಬ್.
Annexure G. Where have you stated?
1 minute, my lord, 1 minute. ಅಲ್ಲ, ನಿಮ್ಮ ರಿಟ್ ಪೇಜ್ 14 and 15 of the writ petition ನಾವು ಹೇಳಿದ್ದೀವಿ. ಅಲ್ಲಿ objection statement ಅಲ್ಲಿ ಅಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಹಾಕಿಲ್ಲ. But then, my lord, we have been placing it, they have been receiving it also. Please come to my lord, page 14 and 15. 14, 15. COT and VAT my lord are 6 and 7. Page 15 ಅಲ್ಲಿ 2.
Why, 1-5?
14, 15 Swami. 14 and 15. 1-5, 1-4 and 1-5. If your lordship sees principal.
Bar and restaurant and only restaurant.
Correct. 1, 2, 3, 4, 5. My lord, are all only restaurant, no bar and restaurant. 6 and 7 are with bar and with bar, where liquor is served. So regular tax of rate, my lord, VAT, my lord, we are paying. And can I persuade your lordship?
Regular rate of tax and composition scheme ಅಂತ specifically ಹೇಳಾಗಿದೆ.
ಹೌದು. Then, my lord, why, my lord, he cancels it is 2 grounds. One, my lord, saying that the liquor is served in 2 of them. Other is some capital goods, furniture ತಗೊಂಡ್ರಿ. Therefore, you have taken it from, my lord, intra-state. ಇದು interstate ಆಗಬೇಕು for composition tax. Intra-state ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಿ. Therefore, my lord, you are not entitled to it. My submission to your lordship is, this honorable court, my lord, has considered all that in another writ petition, where, my lord, their lordships have held, if it is capital goods, not used, my lord, in the stock, for, my lord, purpose of, my lord, consumption and all that, then, my lord, that, my lord, is not a, I'll just pass on, my lord, to judgment for my lord's consideration.
It can be interstate also.
Correct, correct. Please look at the first judgment, my lord. 2016 ಅಲ್ಲಿ ಅನಂತ ಪದ್ಮನಾಭ ಭಟ್ ಇದ್ದು, ಅದರಲ್ಲಿ paragraph 2, if my lords come to my lord, paragraph 2 at page 1.
1,
my lord. Petitioner runs restaurant serving, paragraph 2.
vegetarian food in Bangalore.
And opted to pay tax at the composition concessional rate of 4%. Under the composition scheme as enacted under section 15(1) of the Act with effect from so and so. Impugned reassessment notice under section 5, annexure A, dated so and so, and the consequent order passed wide annexure E, dated 17th of October 2015, and annexure F, dated 20th of October 2015, were based on the ground. During the course of inspection, investigation authorities observed petitioner SSC had effected a purchase of goods, that is vitrified tiles, worth 1,69,910 and 23,375 as per E. Sugan, number so and so. During the tax period in question, since they were goods in stock, there was violation of the condition restrictions imposed under section under rule 135 and 144 of the KB80 rules, and petitioner SSC was thus ineligible to continue under the composition scheme.
Kindly come to page para 7 and 8.
Correct, my lord. Absolutely. Admittedly, petitioners running restaurant only, engage in the business of serving vegetarian food, not engage in the business of selling vitrified tiles. In the restaurant, vitrified tiles in question were not sold by him in the regular course of business, but were used only for the purpose of flooring and the restaurant premises. When so fixed in the floor, vitrified tiles, of course, became a part of the immobile property, and it is beyond the common sense and basic commercial prudence to even comprehend that vitrified tiles fixed on the floor of the restaurant could be treated as an assessing authority as goods in stock, dealt with by the SSC or sold in the course of regular course of business. Assessing authority, trained and well acquainted with the commercial terms, cannot be allowed to take such a perverse view. It is this kind of impractical and hypertechnical approach of this, which seriously dents image of the revenue department, etc. This is, my lord, confirmed in the division bench, page 5, Baniswan. Paragraph 12, my lord, this honorable court allows it. Paragraph 5, para 4 of, my lord, page 5, my lord, I'm sorry, my apologies. Page 5, para 4. This is, my lord, against that Ananta Padmanabha, but same writ appeal, my lord, para 4, my lord. On hearing the counsel, learned counsel for the appellants, we do not find any merit in the appeal. Petitioner runs a vegetarian restaurant. He has purchased vitrified tiles worth so and so during the tax period, for his hotel during the tax period. Investigating authorities, having observed that the petitioner SSC has effected the said purchase, issued the impugned reassessment notice, demanding a sum of rupees so and so. Questioning the same, incident petitions were filed. Learned a single judge in so and so came to the view that in terms of 135.
But those goods were not consumables at all for the purpose of business.
Correct. That is one. Then, my lord, please look at, my lord, The other judgment is, what has happened is, ಇದು ಎರಡು ರೀಚ್ ಆಗಲಿಕ್ಕೆ ಕರೆಕ್ಟ್. ಬಟ್ ದೆನ್ ಪೇಜ್ 7 ತಾವು ಬಂದ್ರೆ
ಓರಿಯೆಂಟಲ್.
ಹೌದು, ಅದರಲ್ಲಿ ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಒಂದು ಇದ್ ಮಾಡಿದ್ದಾರೆ.
Huh. 17, 18. Ah. ನಿಮ್ಮ ಮೈಕ್ ಅನ್ನು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Sorry, my lord. My apologies.
No, nice.
In the light of these judgments, it is clear that unless certificate issued under Rule 137 has not been cancelled, dealer petitioner herein would be entitled to continue with the benefit of Section 15 of the KB80 Act on the composition scheme. Indisputably, as narrated above, order of cancellation composition scheme facility has been passed on 22nd of July 2015 with immediate effect. It's also made clear VAT option is enabled to file VAT 100 returns with effect from 1st of August 2015. Even in the notice for cancellation of the composition scheme, it was proposed to cancel the COT facility with immediate effect. Same coming into effect from July 22nd, 2015. Prescribed authority has no power to assess the petitioner dealer under VAT scheme for the period when the composition certificate issued under 137 of the rule was in existence, etc. The last sentence of para 17. Indisputably, certificate issued under Rule 137 was not cancelled during the tax period 2014-15. Hence, for the period in question, no reassessment can be made under 39(1) of the Act, subject to the petitioner.
ಅದು ಇಮಿಡಿಯೇಟ್ ಇಫೆಕ್ಟ್ ನಿಂದ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ನೋಟಿಸ್ ನಲ್ಲಿ, ವಿತ್ ರೆಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಇಫೆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ
ಬರೋದಿಲ್ಲ ಅಷ್ಟೇ, ಅದು ಒಂದೇ. Then
ಏನಂತ ಕೊಟ್ಟಾರೆ ನೋಟಿಸ್
ಇದರಲ್ಲಿ ಮಲಾಡ್, and this has been ಮಲಾಡ್ confirmed in ಮಲಾಡ್ page 17 ಅಲ್ಲಿ division bench ಇದು. It's all right. ಇದರಲ್ಲಿ ಮಲಾಡ್ what has happened is, please come to ಮಲಾಡ್ the order, impugned order. And ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮಲಾಡ್, since my lords are having ಮಲಾಡ್ this judgment compilation, can I also request you lot to look at one mallard judgment? I'll tell your lordships why. What has happened is, appellate authority mallard passed an order. Revisional authority reverses it, against which we have come before your lordships. Appellate authority mallard, if it takes a particular view, and if it is mallard a reasonable view, then mallard revisional authority cannot mallard reassess the thing. Please come to mallard page 31. 3.1. Bharat Petroleum Corporation Limited versus Additional Commissioner Commercial Tax. ಇದರಲ್ಲಿ paragraph 5 and 6 ಮಲಾಡ್ page 31 ಅಲ್ಲಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. 31 5 and 6 ತಮಗೆ 34. From the material and record, it is clear that while Deputy Commissioner issued notice proposing to apply Section 17 of the Act, SSC did not produce all the relevant documents before him. It is in the absence of the documents the said order came to be passed by the Deputy Commissioner. However, in an appeal, SSC has produced all the relevant documents. After going through the documents, this is what the appellate authority has held as follows. On a perusal, the copies of the purchase bill, stock transfer memos, hire purchase paid to the transporters, etc., produced by the appellant for having purchased LPG from Hindustan Petroleum Corporation Limited, and thereafter stock transferred outside the state. It's noticed that the appellant, after purchasing LPG from the Hindustan Petroleum Corporation, which is transported in a tanker, the same has been diverted, so and so, so and so, so and so. Then, my lord, paragraph 6. Sorry. Under the circumstances, I hold that respondent is not, this is the conclusion of the appellate authority. After going through the entire records, para 6, my lord. Therefore, it is clear that it is on perusal of the copies of the purchase bill, stock transfer issued, paid to the transporters, taking into consideration the tanker number mentioned in the stock transfer memos, tanker which transported the goods to the doors of the SSC, and without unloading, in the very same tanker, goods got transported by a stock transfer to his own depots located outside Karnataka. The appellate authority held that there is a one-to-one correlation between the purchase of LPG from HPCL to that of the stock transfer or the very same goods outside the state. Therefore, it held that the SSC is eligible for to claim benefit of input tax credit on the local registered dealer purchases of LPG corresponding to those stock transfers in accordance with the provisions of section 11A5, that be section 14. Therefore, finding recorded by the appellate authority is purely a question of fact, which he recorded after going through the records produced before him. Though the revenue authority has the jurisdiction to interfere with such orders, if they are to be prejudicial to the interests of the revenue, but before exercising that power, ingredients mentioned in the section are to be satisfied. In para 4, we get the reasons for interference, that he has verified the evidence of the local purchases or tax paid LPG and stock transfer of such LPG outside the state, and thereby section 11A5 read with 14 would apply. He has not recorded individual transactions linking with the stock transfer, inter-purchases, import outside the state. In appeal order, if there were no such evidence in appeal records also, if the revisional authority has looked into the very same records which are looked into by the appellate authority, and if he has recorded a finding that there is no one-to-one correlation between the purchase and stock transfer or the very same goods outside the state, then we would not have interfered with the said order passed by the revisional authority. Appellate authority categorically stated he has looked into the copies of purchase bills, etc.
Last paragraph.
Correct.
Therefore, at the threshold,
Correct.
the power exercised by the regional authority on such a ground is contrary to the statutory
That's-
provisions.
Then, my lord, to a similar effect is, my lord, another judgment at page 37, paragraph 8 ಅಲ್ಲಿ ಬರುತ್ತೆ. Page 37 ಅಲ್ಲಿ, ಇದರಲ್ಲಿ paragraph 8, my lord, at running page 39. This is again a division bench.
The order is a revisional order.
Yes.
The one which you are challenging.
Yes, yes.
After exhausting appeal.
No,
Appeal went in your favor.
in my favor.
And the revision
They
went
filed, my lord,
against you.
he so moto, my lord, take cognizance of it, my lord, and he exercised revisional power.
So your contention is the evidentiary material which the appellate authority has looked into and
Correct.
arrived at a conclusion.
Correct.
Cannot be reassessed because
Correct.
it's a question
Correct.
of fact.
Correct, correct. Can I, my lord, request your lordship, now in this, in the background of this, please come to page 93 of the writ petition. Sorry, 1 minute. Appellate authority. 93 ಅಲ್ಲ? Annexure J, page 93 ಬನ್ನಿ ಸ್ವಾಮಿ. Can I persuade your lordships to come to my lord?
Appellate order.
Howth, appellate order. Please come to, my lord, paragraph 11, 12 and 13 at page, my lord, 98 and 27 to 30 at page 101, 11 at page 98. On verification of the details, registration details of the appellant, assessing authority has noticed that the appellant from the month of March 2012, month
Has
of
filed
registration.
both monthly
Sorry,
returns of
sorry.
turnover rates and the quarterly return of so and so.
Correct.
100, VAT 100, VAT 120
On monthly basis.
on monthly basis.
Further, verify 100 ಬೇರೆ 120 ಬೇರೆ. My lord, liquor serve ಮಾಡಿದಲ್ಲಿ 100, liquor serve ಮಾಡದೇ ಇರೋದಲ್ಲಿ 120 caught. Then further verification by the assessing authority reveal the fact that the appellant from the month of March 2012 has filed monthly return of turnover in form VAT 100 in respect of units of branches wherein liquor was served along with the vegetarian, non-vegetarian foods and drinks, and has discharged tax at the regular rate of tax prevalent during that during that particular assessment period for the aforesaid units of branches mentioned at serial number 3B and 4B in table 1 supra. Also, the assessing authority has noticed that the appellant from the month of March 2012, month of registration, has filed quarterly return of turnover in form VAT 120 on monthly basis in respect of the units, branches where no liquor was served and only vegetarian, non-vegetarian food items and drinks were served. Further, appellant by virtue of opting composition scheme of the payment of tax as per the provisions of 15(1) of the Act for the aforesaid branches has discharged the composition tax at the rate prevalent during the particular assessment period with regard to these units of the branches mentioned at serial number 1, 2, 3A and 4A in table 1 cited supra. Then, my lord, please come to para 27. At 26, page 101, Bandra Swami. Para 26. Also in response, para 26, my lord, sorry.
Correct.
Page 20.
Also in
100.
response to the.
In
aforesaid
response to the
registration of-
aforesaid registration application, respondent has granted the appellant registration certificate in form VAT 07 on 3/4/2012 with effect from 31/3/2012. Verification of registration certificate in form VAT 07 issued by the respondent to the appellant clearly indicates VAT
Multiple type registration.
Correct. Multiple type of registration. In other words, specification mentioned with regard to the appellant in VAT registration certificate in form VAT 07 issued by the respondent clearly indicates that the respondent has issued multiple type of registration, both VAT and COT, to the appellant. This is evident from the specifications mentioned in VAT registration certificate in form VAT 07 issued by the respondent in the case of appellant with effect from so and so as under. Aforementioned dealer is authorized to collect tax on his or her sales as specified in the said act from 31/3/2012. Dealer has also opted for payment of tax under the composition scheme under section 15 under the category hotelier and restaurant.
This is page 74.
Correct. Then, my lord, para 27, where, my lord, again, my lord, the authority, appellate authority finds that, my lord, ours is a multiple registration, MUL. The further verification of the copy, para 27, or the dealer status available in VAT-E filing system of the department as on 6/9/2014, filed by the respondent, learned representative of the appellant depicts the fact that the registration type of the appellant is that of multiple registration, and the column of our registration type reflects the entry MUL, meaning that registration type is multiple one. On examination of the assessing authority, it was noticed that based on the stronghold of so and so, so and so. Ultimately, my lord, the appellate authority, my lord, comes 32 ಅಲ್ಲಿ ನಾವು. That's all right.
Yes, filed both ಅಂತ.
Correct.
VAT 100,
Correct.
VAT 120.
Correct. Both types ಅಂತ 32 ಅಲ್ಲಿ ಹೇಳಿದ್ರು. Then, my lord, he comes to the conclusion that, my lord, what we have been doing, my lord, is in order. He also, my lord, notices that, my lord, goods in stock, para 49, page 108 ಗೆ ತಾವು ಬಂದ್ರೆ, that, my lord, capital goods ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ please come to, my lord, para 40. Therefore, in the instant case, appellant is eligible to multiple registration for as per the provisions of 38(6). My lords may be pleased to see. This is what, my lord, the finding of the appellate authority. 48 ali. Para 48, page 108. Sorry.
Para 48.
Para 48, page 108. Therefore,
Therefore, in the instant case,
appellant is eligible for multiple type registration as per the provisions of section 38(6) of the Act, which is in accordance with the provisions with the specifications mentioned in the registration certificate in form VAT 07 issued on 31/3/2012 by a registering authority on 3/4/2012. Second issue pertaining to the main, this is, my lord, therefore, my lord, one, liquor, where liquor is served and where no liquor is served, my lord, is concluded at para 48. Second issue pertaining to the main content of the respondent revolves around the fact assessing authority has withdrawn, cancelled the benefit of composition scheme of the tax under section 15(1)(c) of the Act on the ground that appellant being hotelier and who has opted for composition tax has effected interstate purchase of goods for use in the business of hotel. With regard to the above issue, it is undisputed fact that as per the provision section 15(1)(c) of the Act read with rule 135 of the KB80 rules 2005, any dealer who is a hotelier, restaurant, caterer is bound by the conditions underlying with rule 135(2) of KB80 rules, that such dealer will not effect interstate purchase by virtue of being composition dealer and sub rule 1, 2, 3.
that is because to boost the domestic
Correct.
market ಅಂತ ಅನ್ಕೊಂಡು ಹೊರಗಿನಿಂದ
ಅದ್ರಲ್ಲಿ-
ಮಾಡದು ಇಲ್ಲಿದೆ ತಗೋಬೇಕು ಅಂತ.
Correct. ಅದಕ್ಕೆ ತಾವು ಲಾಸ್ಟ್ paragraph ಬನ್ನಿ ಸ್ವಾಮಿ, italics ಅಲ್ಲಿ ಇರೋದು. The dealer opting to pay tax by way of composition under section 15 shall satisfy the following conditions.
Correct.
He shall be a dealer registered under the Act or
A dealer who has made an application for registration.
Then second one,
shall
he
not
shall
have
not
any
have any
goods.
goods in stock. ಇದು goods in stock
ಅದು
ಅಲ್ಲ.
ಆಗಲ್ಲ
ಅಷ್ಟೇ ಅಷ್ಟೇ ಅದನ್ನು ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. He also comes.
ಬಿಸಿನೆಸ್ ನಲ್ಲಿ ಕನ್ಸ್ಯೂಮ್ ಆಗಂಗಿರ್ಬೇಕು.
Correct.
ಅವಾಗ ಬರ್ತದೆ, ಇಲ್ಲದು ಇಲ್ಲ ಅಂತ ಒಂದು ಕಂಟೆಂಟ್.
Correct. Then, my lord, the revisional authority, my lord, at page 113. Sorry.
ಈ ಟೈಲ್ಸ್ ಅನ್ನ ಏನ್ ಜನ ತಿನ್ನೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ ಅಂತ.
ನಮ್ಮಲ್ಲಿ ಫರ್ನಿಚರ್
ಇದು ನೀವು ಅಲ್ಲಿ 100 ರೂಲ್ 135 ಓದಿದ್ರಲ್ಲ.
ಕರೆಕ್ಟ್.
ಅದರಲ್ಲಿ ಡೀಲರ್ ಆಪ್ಟಿಂಗ್ ಟು ಪೇ ಟ್ಯಾಕ್ಸ್ ಬೈ ಕಂಪೋಸಿಷನ್ ಶಾಲ್ ಫಾಲೋ ದಿ satisfy the following conditions. He shall be dealer registered under the act. Page 74 is a registered dealer ಆಗ್ತಾನೆ.
Correct. Then, my lord, revisional authority, my lord, invokes section 64 and, my lord, passes the impugned order, which is, my lord, at annexure A, page 51 ಅಲ್ಲಿ ಸ್ವಾಮಿ. That's all right.
Now, where is the power to cancel the registration with retrospective effect ಅಂತ ಒಂದು argument ಮಾಡಿದ್ರಿ ನೀವು.
ಹಾ.
Registration.
Correct.
How they could have cancelled it with retrospective effect ಅಂತ.
ಅಂದ್ರೆ
2012 ನಿಂದಾನೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಬಿಟ್ರು. ಅದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಂಗಿರ್ಲಿಲ್ಲ.
Correct. ಅದು ಒಂದು. ಎರಡನೇದಾಗಿ ಇದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋ ಪ್ರಮೇಯ ಇಲ್ಲ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಎ ಮಲ್ಟಿಪಲ್ ಮಲಾಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ದೇರ್ ಫಾರ್ ಅಂತ ಹೇಳಿ. Then my lord, there is one judgment, my lord, which my learned friend, my lord, wanted your lordships to look at. I'll just pass on that judgment. Have a look at it. And my lord, it's clearly
Filed on
distinct.
record.
Huh?
It's filed on record by the state on.
My lord, state has already filed on. Alva.
You filed. 2112. Appellant has filed it in 2021. I can pass.
You have cancelled that registration with effect from which date?
From 2012 itself.
Your cancellation of registration. You not cancelled it.
He is not eligible for composition.
That's all. That's your case. Okay.
Page number 18, retrospective and 40.
Correct. Page 89 ಬನ್ನಿ ಸ್ವಾಮಿ.
89.
ಹೌದು. Last paragraph ಬನ್ನಿ.
With effect from 31/3/2012. With retrospective effect ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. Then my lord, the Swati hotels iddu. That is what my lord, my learned friend is trying. Ashwini hotel. Ide.
ತರ್ಸಿದ್ದೀನಿ. They've got the judgment. Because.
Proposition ಹೇಳಿ ನೋಡ್ತೇನೆ.
My lord, Ashwini hotels ಅಲ್ಲಿ,
ಹಾ.
what happened was, there was my lord, the principal place of business where liquor was being served. They rely upon idu STA, my lord, 28 of 2009. Can I persuade your lordships come to my lord paragraph 4? Idralli. Correct. Para 4, my lord, at page 5. We do not see any merit in the said contention. On an application filed by the appellant exercising power under 38(6) of the Act, permission was granted to treat each other place of business as a separate unit for the purpose of levy of assessment and collection of tax. Thereupon, all the provisions of the Act regarding registration, filing of returns, assessment, collection of tax was made applicable. However, aforesaid provisions made it very clear that where a dealer is a body corporate, has more than one place of business, and if he so desires, commissioner may on an application form from it, and on being satisfied the provisions are likely to cause hardship by a special order, grant such permission subject to the conditions as may be specified by him in terms of the Act and its rules. In the instant case, principal based place of business where the appellant is carrying on business and food items, he is also selling liquor. My lord, please mark this. I'll tell you lordships why. Now, my lord, please come to my lord. Rule 147, allene kelagade swami.
The appellant is entitled to the said benefit only when he satisfies the requirement of
Correct.
rule 47(1).
Now 47(1) ಬನ್ನಿ ಸ್ವಾಮಿ. Where a dealer, ಅಲ್ಲೇ ಕೆಳಗಡೆ ಹೋಗಿ ನೋಡಿ italics ಅಲ್ಲಿ.
Is a body
Last paragraph ಬನ್ನಿ ಸ್ವಾಮಿ.
The tax
Payable under any provisions of the Act by each of such branch together with the other places of business in the state shall not be less than the tax that would have been payable
by him. Under
ಇದರಲ್ಲಿ
any of
ಏನಾಯ್ತು?
such provisions of the Act.
Correct.
If such branch was not treated as a
Correct.
separate unit. In other words, collective collection from all the branches should not be less than what otherwise they would have paid individually under this or that
No, my lord.
scheme.
What I am submitting before your lordships is each branch ಅಲ್ಲಿ ನೀವು ಈಗ ಜಾಸ್ತಿ ಕೊಡಬೇಕೋ ಕಡಿಮೆ ಕೊಡಬೇಕು. That branch, please look at my lord 2(1) ಅಲ್ಲಿ 6 ಅಲ್ಲಿ last paragraph ಬನ್ನಿ ಸ್ವಾಮಿ. The tax payable under any other provisions of the Act by each of such branch together with the other places of business in the state shall not be less than the tax they would have been payable by him under any other provisions of the Act if such branch was not treated as a separate unit under section 6. So, ಇದರಲ್ಲಿ ಏನಾಯ್ತು? Principal place of business, my lord, is only, my lord, ಅದರಲ್ಲಿ principal place of business, my lord, had to pay, my lord, 14%.
Correct.
ಯಾವ್ದ್ರಲ್ಲಿ? ಅಶ್ವಥ್ ಇದರಲ್ಲಿ.
Correct.
Therefore, my lord, branches ಕಡಿಮೆ ಕೊಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಯಾಕಂದ್ರೆ rule 47(1) ನಲ್ಲಿ what they say is, let, my lord, the tax payable under any other provisions of the Act by each of such branch together with other places of business in the state shall not be less than the tax that would have been payable by him under any such provision of the Act if such branch was not treated as a separate unit under subsection 6 of section 38. If it is treated as a separate unit, otherly anaitu, they treated it as a separate unit. No liquor was served. Therefore, my lord, they said 4%. The rule says that branch, my lord, if that branch, my lord, were to, I mean, if the main principal business, my lord, 14% kotru. So that branch, my lord, cannot pay less than, my lord, what is given by the principal place. Please see, my lord, tax payable under any of the provisions of the Act by each of such branch, together with other place of business in the state, shall not be.
Mr. Hulla. Ali, by each of such branches ಆಗ್ಬೇಕಿತ್ತು.
My lord, this is made more clear. Can I persuade you? Let's look at, my lord, read further.
The aforesaid rule makes it very clear.
Separate registration filing returns by the branches of the corporate is permissible only when the tax payable by other separate units would be not less than the tax that would have been payable by them under any such provisions of the Act, if such branch was not treated as a separate unit under subsection 6 of section 38. It is not in dispute that the tax which is paid by separate unit is less than the tax that would have been payable if there was no separate registration. Therefore, they were not entitled to the said registration. Once the liquor is sold in the principal place of business, even if the SSC is not selling liquor for the purpose of benefit of composition tax, total tax payable should not be less than the tax payable by the principal unit. Overlooking this provision, the said benefit has been conferred. Even otherwise, the returns filed by the SSC in respect of the separate unit disclosed, tax payable was less than the tax payable by the principal unit. Therefore, they were not entitled to composition.
In other words, the exemption granted was contrary to statute.
Correct. When once the benefit is granted to an SSC, contrary to the statutory provisions, what I am submitting before your lordship is, in that case, principal place of business was selling liquor, and they were paying 14%. Principal place was paying 14%. Unit was paying less. In the light of section for regulation for
principal place of business nalli ಏನು ಮಾಡ್ತಾ ಇದ್ರಿ?
ನಮ್ದರಲ್ಲಿ vegetarian, nothing, no liquor.
Only restaurant.
Yes.
ಅದರಲ್ಲಿ ರೆಸ್ಟೋರೆಂಟ್ ಕಮ್ ಬಾರ್ ಅಂತಿತ್ತ?
ಹೌದು ತಾವು ಇದರಲ್ಲೇ ಬರುತ್ತೆ ನೋಡಿ, ಪೇಜ್
6 ತಿರುಮುರು ಹೇಳ್ತಾ ಇದ್ದೀರೋ ನೀವು?
ಇಲ್ಲ, ಪೇಜ್ 6 ಗೆ ಬನ್ನಿ. ಇದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪೇಜ್ 6 ಗೆ ಬನ್ನಿ, ಟಾಪ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ. ಇನ್ ದ ಇನ್ಸ್ಟೆಂಟ್ ಕೇಸ್, ಟಾಪ್ page 6.
In the instant case,
principal place of
business where the appellant is carrying business of food items
is also selling liquor. Once the liquor is sold, this is not entitled to benefit of tax under the scheme of composition. So therefore, my lord, rule
ಅಲ್ಲಿ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಇತ್ತು, ಇಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೀಟ್ ನಲ್ಲಿ ಇರುವಂತದ್ದು ಬೇರೆ ರೆಸ್ಟೋರೆಂಟ್.
Correct. Therefore, the branch cannot pay less than, my lord, what is being paid by the principal place of business. They have to pay more. In this incident case, my lord, they are paying more, 14%. Therefore, my lord,
because bar and restaurant.
Correct. Therefore, my lord, this judgment strictly, my lord, has no application. Ishte in idikinta illa now illa idan now
fact matrix se bere idu.
Correct. Therefore, my lord, and basically, my lord, two things as I submitted. One, it is a multiple registration. Two, admittedly, my lord, the assessing of my lord, the
they have accepted the whatever tax it has been paid up to 2016
and 14. And my lord, the appellate authority has, my lord, after going through the entire matter on factual matrix, has come to a definite conclusion. The representative authority could not have, my lord, overturned it unless, my lord, he comes to the conclusion that, my lord, it is totally perverse. Therefore, my lord, I submit. In idikinte helidre nanu repeat ಮಾಡ್ತಾನೆ ಇರ್ತೀನಿ ಸ್ವಾಮಿ.
ಏನಿದೆ?
ಇದು
ಟ್ಯಾಕ್ಸ್ ನಮಗೆ ನಾವು we are all
everybody is learning multi
stranger to the tax jurisprudence.
ಇಲ್ಲ ಈಗ ತಾವು ಈಗ ಟ್ಯಾಕ್ಸ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಿ. ನಿಮಗೆ ಯಾವ ಬ್ರಾಂಚ್ ಇದ್ರೂ ಏನು ಕಷ್ಟ ಇಲ್ಲ.
ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು ಪ್ಲೀಸ್ ಸೂತ್ರ ರೂಪದಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ, ಒಂದು ನಾವು 100 ಮತ್ತು 120 ಏನದು
120
ವ್ಯಾಟ್ 100 ವ್ಯಾಟ್ 120 ಎರಡನ್ನೂ ನಾವು ತಗೊಂಡಿದ್ದೀವಿ. ಒಂದೇ ಸರ್ಟಿಫಿಕೇಟ್ ನಲ್ಲಿ
ಕರೆಕ್ಟ್ ಮಲ್ಟಿಪಲ್
ಇದೆ. ಅದು ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೀಟ್ ಆಫ್ ಬಿಸ್ನೆಸ್ ನಲ್ಲಿ ಇಟ್ಸ್ ಓನ್ಲಿ ಎ ರೆಸ್ಟೋರೆಂಟ್. ಇನ್ ಬ್ರಾಂಚಸ್ ಇಟ್ ಇಸ್ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್
ಅಲ್ಲಿ ಎಕ್ಸೆಸ್ ಹೈಯರ್ ಟ್ಯಾಕ್ಸ್ ಕೊಡ್ತಾರೆ.
ಈ ಜಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗದಂಗೆ ಇರ್ಲಿಕ್ಕೆ ಕಾರಣ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ರೆಲೆವೆಂಟ್ ಫ್ಯಾಕ್ಟರ್ ವಾಸ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ಬ್ರಾಂಚ್ ಸೀಟ್ ಇಟ್ ಸೆಲ್ಫ್ ವಾಸ್ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್. Unlike this.
Yes.
And therefore, they could not have paid less than what principal seat will pay.
Correct.
That will not apply here.
47(1) ಅಷ್ಟೇ.
ಎರಡನೇದು ಆ goods ದ್ದೇನ್ ಪ್ರಶ್ನೆ
ಅದು ಬರೋದಿಲ್ಲ.
subject to what Aditya will say.
Yes, correct.
Third one is you have already received all these things. Fourth one is your revisional jurisdiction. You could not have
Correct.
gone that deeper
That's
ಅಂತ ಅನ್ಕೊಂಡು. Okay.
ನಾನು ಅದನ್ನು ಲಾಸ್ಟ್ ಅಲ್ಲಿ
ಹಾ.
of course I know it's not easy. Errors in the impugned judgment ಅಂತ page 6 of my ಇದರಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ನಾನು. ನನ್ನ ನೋಟ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ದಿ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಅಂಡ್ ಸಿನಾಪ್ಸಿಸ್.
Page 14. Paragraph 30.
Lord, ಒಂದು
Reason this becomes important is
Right.
revision of 30 holds the circle which is in cancel.
ಆಯ್ತು ಸಪೋಸ್ Then one more, my lord, they have given, my lord, they have produced a circular which, my lord, retrospective, my lord, cancels, my lord, this changes the regulation. Adik one judgment ತೋರಿಸ್ತೀನಿ ತಮಗೆ. Please come to, my lord, my compilation of judgments. Page 49 ಬನ್ನಿ ಸ್ವಾಮಿ.
That circular is internal guidance, my lord. Circular cannot override the law. It only explains what the.
All right, I'll not grateful to me. That's all.
So now your counsel, briefing counsel is satisfied with this answer.
ಅಂದ್ರೆ ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೇನೆ ಇದರಲ್ಲಿ.
Your lordships may be kind enough to take page 70 of his appeal notes. Some controversies can be set at naught immediately.
70.
69.
69.
68 agli. Para 15.
Para 15. In rule 135(2).
So now that he deals with the judgment in Anant Padmanabha Bhatt. 69 it is extracted. Kindly come to page 70.
This is a revisional order.
Revisional. I'll just close one controversy immediately.
Okay.
Your lordships may kindly take page 70.
70.
If the aforesaid observations made by learned single judge in the above case are carried to the logical end, a conclusion is obvious that a hotelier opting for payment of composition tax under 15 of the Act can purchase goods from outside of the state for the purpose of use in course of business activity. In the case of the assessee, good purchased from outside the state has not been traded. Instead, it has been used in the course of manufacturing food articles. In such circumstances, the conclusion is obvious that there is no violation of the conditions as specified in 135 so and so, as the High Court in the above case categorically ruled that the restriction against sale of goods which was purchased from the above state stands complied with. Even in the case on hand, assessee having purchased the goods from outside the state has not sold in case of business activity, but used the same for manufacturing goods. Therefore, stand
to that
taken by
extent,
LVO.
you go with the assessee.
There is no controversy.
Controversy.
There is no controversy.
That goes. So we need not go to Padmarabha judgment at all. Okay.
Now your lordships may see page 76. I just want to point out something. Your lordships have 76?
76.
Or number 4.
Yes.
This is a certificate of enrollment under the Profession Tax Act, which is completely a different statute. Now,
77 is bad.
I'm coming. So,
77.
It has just been,
Additional places of business as noted below.
there is nothing There is nothing exceptional about an additional place of business. Any business entity may have more than one branches. It could be a restaurant, it could be a cycle shop, it could be a bank. The question is, are you treating this separate place of business as a distinct entity for the purposes of the VAT Act? That your lordship may now your lordship may come to section 38(6).
Notwithstanding.
Yes. Notwithstanding anything contained in the act, where a dealer is a body corporate. So therefore, individuals, proprietorship firms do not have this benefit. A body corporate has this benefit. Where a dealer is a body corporate and has more than one place of business, that is granted. It can have more than one place of business. So therefore, to emphasize that it is multiple, any dealer can have multiple places of business. Commissioner may, subject to such conditions as may be prescribed, and with the consent of the dealer, treat each of such places of business as a separate unit for the purposes of levy, assessment and collection of tax, and thereupon all the provisions of this act regarding registration, filing of returns, assessment and collection of tax shall apply as if each of such places the business is a separate unit.
But whether that issue is adverted to by the appellate authority,
Yes.
that it's a corporate entity or not.
Yes, of course.
Advert-
Because there is no doubt that there is.
No, whether that order is made on the ground that he is not a corporate entity.
No. I'm just saying 38(6), any dealer may have any number of places.
branches.
A
Anyway.
corporate entity has the added option of treating each place of business as a separate unit. Here it says the commissioner may, with the consent. When this is operationalized, your lordship will kindly take rule 47.
Others need not wait. This will take time. Wherever there are interim orders, we'll continue the interim orders. Don't disturb us also. Rule
47.
separate registration and filing of returns by the branches of corporate bodies.
Yes.
This is a partnership firm.
It's a corporate body, private limited.
It's a corporate body only.
Yes, there is no controversy there. Only reason I said I drew a distinction was anybody can have any number of places of
But
business.
to be treated as such is the question.
Yes.
Who should do that?
Now, yes, that is what Rule 47 explains. So the first step is corporate body. So he's eligible. Now kindly see 47. Where a dealer is a body corporate and has more than one place of business, and if it so desires, the commissioner on an application from it and on being satisfied that the provisions of sub-rule 1 of Rule 38 are likely to cause hardship by a special order, permit each branch to file a separate return to the jurisdictional VAT officer, local VAT officer or VAT sub-officer in which the main place of business of such dealer is situated as a separate business, and to be assessed or reassessed separately but by the same officer as authorized by the commissioner, and such permission shall be subject to the provisions of the act and rules relating to registrations, filing of returns, so on so on. So my first submission, my lords, application under Rule 47 read with section 38 is nowhere to be found. It does not exist.
Please repeat. Please repeat.
My lords, in order to take the benefit of each unit or each branch or each place of business being treated as a separate unit, it requires an order of the commissioner. That order of the commissioner is made on an application by the assessee.
But is it the ground on which impugned order is structured?
Yes, yes. That There is no application under 47. There is no treatment under this act of each place of business as a separate unit.
Kindly come to 36, 39(6),
38(6).
38(6).
Yes.
Notwithstanding anything contained in this
Act.
where
the-
a dealer is a body corporate, has more than one place of business, commissioner may, subject to such as may be prescribed, that prescribed means a rule. And with consent of dealer, treat each of such places of business as a separate unit for the purposes of levy, assessment and collection. But from 2012, you have for several years, maybe about 3 years at least, you have accepted that they are the separate branches. They are, and you have treated them as separate. You have accepted the tax.
My lords, it's a self-assessment regime. I cannot, if I have to police each self-assessment.
No, you should have, that is no answer.
There is no, neither is there res judicata nor there is estoppel against the statute.
We agree.
Neither is there res judicata in tax,
Correct.
nor is there estoppel against the statute. There is no estoppel against the statute.
That's right.
If I have to, my lords, police each return in the manner in which it is filed, as it is in 2025, we are doing matters pertaining to 2015. If I have to apply my mind and police each return, my lords, I don't know where the wheels will get stuck. The argument that I have done something contrary to law, you have overlooked it for 2 years and therefore you are bound, my lords, that has no basis in law is my respectful submission. It's a self-assessment regime, my lords. The simple point, my lords, is that no such, your lordships may now kindly see the registration, the form. Sir, Cyber Act.
Act I have. Page number?
My lords, the form, your lordships may kindly see there is a form VAT 1, which in my copy is a 217. That for various kinds of entities, various details are picked up.
Rule 4.
Yes, ma'am. Registration.
Application for registration.
Madams. Your lordships may then come to page 226. Which is form VAT 3. Your lordships have it?
Yes. 226. Yes.
Madams.
VAT 3.
Form VAT 3.
Rule 5.
Rule 5. Address details of additional places of business.
Correct.
TIN, so and so. Name of proprietor, partner, member, authorized signatory, whatever. Next question. Are you a corporate body seeking separate registration for your units? Yes or no? If yes, furnish the TIN of each such unit while filling the address of unit or additional place. In other words, the moment you take a separate registration, you are required to have a separate identification number, a tax identification number for each such unit. That is because for Rule 47, your lordship saw that when you make an application and it is divided into separate units, it is treated as if it is to be assessed individually. Only condition it goes back to the assessing officer of the principal place, of the head office.
Same person will do that.
Same person, but separate TINs. I don't want to take the onus of showing the negative, but there is not one scrap of paper either produced along with the appeal memo or subsequently showing that there is one additional TIN.
Yes.
Now your lordships may see the impugned order. Your lordships may come directly to page 63.
Give some time. We'll read and come back again. Complexity ಇದೆ ಅದಕ್ಕೆ. No res judicata very well.
No estoppel against statute also.
That's true.
And if something has to be done in a manner prescribed by the act, it has to be done in that manner or not at all.
No res judicata, all right. But suppose for a quite number of years, you act upon a particular substratum. All of a sudden, can you have U-turn and say, no, no, we will not do that. But there are some judgments of the apex court, which Palkiwala has discussed in his income, Kanga in Palkiwala. No res judicata is true, but it is subject to so many qualifications. Suppose if you have operated with a particular substratum for quite long period.
Assuming I have operated, I have not. If there has been a reassessment order where this has been accepted, not appealed, not subjected to revision, your lordships, I may have no answer. But where it continues on the self-assessment and maybe after 2 years it comes to my notice, it hardly, my lords, that can be said that I have operated under some. He has acted contrary to statute, gotten away with it for 2 years, and now expects me to give him the benefit of that. Respectfully, my lords, not.
All right. All right, give us 1 week time.
My lords,
We'll also think and come back.
my lords.
Apart from Mr. La, I know in tax jurisprudence, there is no scope for invoking res judicata is one thing. But what is meant by that? Can a tax officer operate particular subject to, of course, you are not operated is your contention. That's
Madam.
another thing.
My lords.
Suppose for A, B, C, D, X, Y, Z, for all these branches, you treat them as branches for all practical purposes, collect the tax and send the man free. And all of a sudden, can the tax authority turn around and say, no res judicata, no estoppel. Therefore, I can turn around. Can that be to that extent? There is no limit for that.
Like I said, my lords, if I have passed a reassessment order, a reasoned order, I have accepted his assessment, or court has held to the contrary. Of course, my lord, I cannot do that. If it has gone unnoticed, my respectful submission is in a self-assessment regime. And it is not as
Now,
if
once you do not, once you accept self-assessment, you had an option to reopen. That you did not exercise. Therefore, self-assessment once accepted and regular assessment once done, they stand on same jurisprudential platform.
no, my lords.
No.
No, my lords. No, my lords. Because there may be any number of mistakes, positions contrary to law, which may go unnoticed because it is sampling, my lord. It is a dip check. Unless I receive an intelligence input or some trigger is ticked either by way of volume or some other trigger is, it is impossible for me to apply my mind to each such return.
Let us see.
My lords.
But my application for both MAT and COT, my application are dated 3/3 and first application on Hakim.
That results into page 74.
That multiple, that was.
Multiple, my lord, there is no controversy at all. He can have multiple as many as he likes. It's a free country.
Let us. res judicata and estoppel are treated in anti-equities. Just look into.
I'll look it. I'll look it. No, in the government advocate's office, we always say in this court, ಯಾವ ಕಡೆಯಿಂದ question ಬರುತ್ತೆ?
No, because many aspects, I was reading, which Mahatma Gandhi read, Snell's Equity,
Snell's equity.
very old book, more than 200 years old. One of the famous books, very, very illustrative, very illustrative.
In fact, before we had the privilege of our own libraries, all these books we had to go to senior's office.
Mr. Holla, you have done a great mistake. Why you, even I used to go to his office. His father was my guru. Very well. How res judicata is not applicable, very well. But still there should be some condition. Principles akin to res judicata.
Hello. I'll make myself.
Just look into that.
Please, definitely.
Principles akin to estoppel. Yeah, every time saying that no estoppel against statute, please. That sounds very beautiful for a law student. But when it comes to application, several shades it will have.
Precisely. Precisely.
I think there is one famous book, I forgot the name of the author. Equity and Estoppel. Estoppel, a lot of decisions, right from which Palkiwala quoted in his affidavit filed before the New York court in Bhopal gas tragedy case. He quoted Motilal Padampat versus Union, state of Madhya Pradesh, where, of course, that was a promissory estoppel. When the American company said, Indian courts are not that capable, all substandard judges, therefore, you should, American court should decide the matter. Then Union government got two affidavits filed, one of Palkiwala, another by J.B. Darjanji. They filed why Indian high courts are very great institutions. And New York court accepted it. He quoted that Motilal Padampat, sugar mills, where estoppel, promissory estoppel, all these things. Very well, a very illuminating argument from both the sides. As you
Even before we joined the profession, the Airbus case that senior had appeared in.
Shankar Bhatt commission.
On which court to exercise jurisdiction. Leading case, in fact, after Bhopal, the senior's case in Bangalore.
Okay, true. Yeah, on this aspect, there is a Dr. Upendra Bakshi's book, Mass Disaster and Law by Indian Law Institute. He has produced those affidavits of Palkiwala and Darjanji. Next week, after some, third in part, please. Okay. Date. Let us see. Don't disturb. Nobody is supposed to disturb us. We have work.
Next week, Sir. Sir, dismiss ಆಗ್ಬೇಕು.
Memo ಮಾಡೋದಾ? ಯಾಕಂದ್ರೆ next week ಮೂರೇ ದಿನ ರಜಾ. ಆಯ್ತು.
Serial number serial number
I'll come back.
ರಾಘವೇಂದ್ರ ಸರ್ ಸಾಹೇಬ್ ಗೊತ್ತಾಗಿಲ್ವಾ ಅಂತ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ ಗೊತ್ತಾ? ಇದಕ್ಕೆ ಹೆಂಗಿದೆ ಗೊತ್ತಾ? ಸರಿ ಇಲ್ಲ ಆಗುತ್ತೆ.
What do you want?
ಸರ್ ಅದು ನಾಳೆನೇ ನಾಡಿದ್ದು.
ನಾಳೆ